Close, but not perfect. Oh, similar.
Yeah, 13.
Hmm?
We have 13 now. They said the one that just got here said the last one had to get on the show.
Okay, great. Thank you for sharing that. We are waiting on Mr. King and one more juror then.
Oh, I see.
You're good with that too, right? You're good.
I think we're waiting for one more juror. And we can get going.
Right here, the part where it's out of bounds, and then,
Sarge, when you're ready, staffing wise, if we could bring the defendants out, we'll see if we need to get anything on the record so that we're ready to go when our last juror gets here. Thanks. All right, Ms. Clay, are you ready?
Ready.
Great. Ladies and gentlemen, we're going to get on the record in State versus Blige and Head. It is Monday, November 1. Happy November. We have our prosecutors here. We have Mr. King and his client, Ms. Fagan and her client. And we have today Ms. Clay as our court reporter. Ms. Rivers is out today. So Ms. Clay is gamely filling in towards the end of the trial. When we ended on Friday, the state had rested. We had our charge conference, discussed motions for directed verdict, which were denied. And I'm going to ask Ms. Fagan now if she, well, first, Mr. Abate, anything from the state before I engage with the defense counsel? Okay. Ms. Fagan, do you intend to present any evidence today?
Yes, Your Honor.
All right. Mr. King, I received your potential witness and the business records. I don't know if you've spoken with the state. Was that the only evidence you were planning on presenting, or you're going to wait to see what happens with Ms. Fagan's presentation?
I expect that to be done.
Okay. And do we know if it simply will be the records being admitted, or are you going to need to call Mr. MAGID?
Judge, I would just only want to admit the records unless it's ruled upon that we need the live witness. He is under subpoena. I can get in here within 45 minutes if I need.
Okay. Mr. Abate, I don't know if you had time over the weekend to look at Mr. King's motion to, or notice to introduce what he said are business records that might not require the presence of a witness, but we certainly, it sounds like we can get Mr. Did you pronounce it McGid?
Correct.
Mr. McGid here. Did you have a position on that?
Yes.
Mr. Rao?
Yes, Judge, we object. This is untimely discovery served upon the state under 1716 6.4 subsections. B2 through B3 clearly indicates discovery obligations for the defense. They've opted in. They opted in previously when I had the case. And at this point in time, they waited until the end of the state case in chief to present us with documents and evidence that the state has not had enough time to vet. At this point, we object. We don't believe the probative value is substantially, or that probative value is substantially outweighed by any unfair prejudice given the nature and timing of the disclosure of this discovery. We respectfully object on those grounds.
So I hear you. If I allow Mr. King to move forward with this, and he's going to need to address the late disclosure, we'll discuss that, but assume for a moment that I get past that. Are you arguing that the certification is not sufficient, the business records affidavit and Mr. McGid should come on in, or the affidavit is sufficient and the records are admissible?
I mean, from my understanding and reviewing the document, the certification itself would be proper, given that Mr. Majid was, would have been a custodian. But from the state's perspective, that point is moot. This is someone that the defense likely probably had access to well in advance prior to trial. It didn't seem like it took them that long to provide us with that information after close of business on Friday. So at this point, if that were to be allowed to come in, it essentially would be a trial by ambush at this point. We've served discovery, we've met our requirements, and we served discovery, I understand, continuously throughout the pendency of this case, but the last piece of discovery that was ever served on the defense was on Friday. With respect to the GBI ballistics, I understand the actual report was served on the Tuesday before trial, but the actual results that were indicated in that report were served in a timely manner. So to allow the defense now to violate the obligations that they're under 1710.6.4 subsection B, having already opted in, would essentially be a trial by ambush and unfairly prejudice the state in its presentation of its case.
Tell me what you think the harm is to the state's case for Mr. Head to effectively say, yeah, I had a 380. He's not charged with felon in possession or unlawful possession of a firearm. It's possession during commission of a felony. So it doesn't matter if he owned the gun or not. But I'm going to ask a similar question of Mr. King in a minute. I'm trying to figure out how this necessarily advances things a whole lot for the defense. He's got a great theory, I'm sure. How is this prejudicial to the state?
Well, based on how the evidence has come out in the state's case in chief, the defendant's girlfriend has testified the defendant was in possession of a 380 firearm. The GBI ballistics indicate that 5 380 shell casings were fired from the same firearm, and I believe it, while not necessarily excluding the possibility of other makes 380, other manufacturers of 380 firearms, it did specify a specific one that is not the one that's listed.
Oh, okay. So the firearms expert said, I'm making it up, said, hey, it's consistent with a Lawson.
Correct, Judge. I don't remember the exact make and model off the top of my head. Davis Industries and Cobra is what was indicated in that report, and I believe in the actual certification on the pawn shop, it's a make and model that's different from those. Okay,
but if you had had this in time, you could have asked your expert, hey, is a High Point? Oh yeah, High Point, same thing. I could have listed that. I don't list High Point. I always list Davis Industries. You didn't get a chance to ask that of.
And not only that, Judge, but if that was the case, we could have served the defendants with a discovery request as to that specific firearm, so that we could then analyze that firearm for ballistics analysis on this. The fact that he purchased this firearm is not something I'm sure the defendant himself was not aware of until Friday afternoon. So the fact that now we're being served with discovery that the defendant has had in possession this whole time is now put the state in a position where it's going to be substantially prejudiced by the fact that this is evidence that could be introduced. And furthermore, Judge, in your point to whether or not this advances the defendant's case, it's not necessarily probative of anything. It's not that Mr. Drain testified that he was only ever in possession of a make and model that was similar to the one listed in the GBI report. She just said that he had a 380 firearm in his possession. So to now introduce this for the jury without having the state, giving the state the opportunity to effectively vet this information and proceed accordingly, puts us at a severe disadvantage.
Okay, got it. Mr. King, tell me why it wasn't until October 30th, which would have been Friday, Saturday, that you got this business records affidavit from Mr. McGid and these records.
Judge, it wasn't until Friday that I realized that the state was attempting tied a specific 380 to my client. I knew that their argument was that he was on scene and he was shooting a firearm. But I didn't know until then that that they were gonna try to make the argument my client was shooting the 380. And that came in the afternoon of Friday. Secondly, Judge, although I'm not trying to complain a lot about how this whole thing has developed, but I kind of am when it comes to discovery. And the ballistics report, and I understand that they served an unapproved copy upon me, but the approved copy is what we have to go by, and that was not served until a few days before trial. And it's not like I brought this up before.
You brought what up before?
Ballistics report.
Your concern about the timeliness of the serving of the official version of the GBI report.
Right, and I'm only saying it because they're bringing up timeliness, because things happen at the last minute all the time. And what I'm saying is they brought stuff up at the last minute, and this is directly related to that. So, okay, so we got hundreds of videos in this case, and multiple other types of discovery that we're constantly going and preparing, and then the ballistics comes at the last minute, and I don't have the time to do my due diligence with an expert with it. So I'm doing my best. And when I look at the ballistics report, I'm thinking, okay, I don't necessarily know what they're going to try to do with this, except for just kind of do their best in proving their case. But then on Friday, at the end of the week, then they start making the case, try to make the case that my client has a 380. Okay, and at that point, that's when I discovered that I may be able to find the purchase record of the 380 that the state's witness testified to. And that's why I asked for your assistant to give me a copy of the subpoena that I sent her. Of course, I would have liked to have this earlier. I would like to have this 6 months ago. But this is how it's played out. There's absolutely no, I beg to differ about ambush, but because that's obviously what's not going on. I would have rather have given this a long time ago, have known about it, but didn't know about it until Friday afternoon. And as soon as I knew about it, I sent them the information.
When you say know about it, though, I want to make sure I'm hearing you say it was news to you that the state was going to present evidence that your client owned a specific caliber of gun. Ms. Drain says 380, and that's what you're saying is the first time you heard any evidence that there was a specific caliber of gun associated with your client. Is that what you mean knew about? Because presumably, and you're not don't need to divulge client confidences, but Mr. Head has known since March 25th, 2017. So now 4.5 years that he bought a gun from Mr. McGid at the Arrowhead Pawn Shop. I mean, he's the one who bought it. He signed it. So that's been knowable to you for years. Since your involvement in this case, Mr. Head could have said, hey, I had a 380. Know where it went. He can tell you where it may have gone, but there's a connection between him and a gun that, frankly, the state may have been able to find too by doing a query in federal databases. I don't know how that works. I'm not suggesting that they should have found this, but certainly eminently knowable for you if Mr. Head had decided to share with you, I was a legit gun owner, I bought a gun, and somehow you were able to figure out where he bought it because with pretty short notice, you got everything you needed in connection with it.
That's right. Because, and I agree with what you're saying, but to me, it only becomes relevant as a rebuttal when the witness testifies that my client actually owns a 380. And then the other thing is about the whole evidence regarding the calls. They're using that to compound the whole, okay, he had a 380, because Ms. Drain said so. And then the calls are now admitted, saying that he got rid of the 380. And
Although
that
I don't think-
was Friday.
Okay, I'm sorry to step on your words. I don't recall anything in the calls about a 380. It's just okay. It's a gun, but it's not your 380 you got from Arrowhead Pawn Shop or anything like that. It's just gun.
Agreed.
Okay.
Agreed. I'm just saying that me knowing how both sides are supposed to operate when it comes to the flow of evidence, that's what's going on here. And so at the end of the day, this is the truth. And this is how the truth has come out. And there's, in my opinion, well, not my opinion, but in my research, when it comes to rebuttal evidence, it has to do with, yes, did you know about it? But is it something that we are directly, is it something you anticipated? And I did not. And that's why it wasn't until now. And then also, I mean, just being candid, Judge, this whole thing with the ballistics didn't come out until a few days before trial. And this is and obviously you know this is a murder trial. We are diving deep into the stuff we already have. And it's hard to do everything that, I guess, anticipate every possible thing when trial is only a few days from now, and we're preparing. So I just want to make sure that everybody knows that there's no ill will to this. And it is truly rebuttal evidence. And I mean, they already knew kind of what I was doing on Friday because I mentioned it. But I didn't get it completely until Saturday. I got some of the records Friday, then I had to go back on Saturday and get the affidavit, and that's what I sent.
Okay. Mr. Rao, I don't remember. Was there anything in the state's opening about Mr. Head having a 380 as opposed to, you'll hear jail calls about Mr. Head trying to dispose of the gun or colleagues of Mr. Head's trying to dispose of the gun? Put differently, was the first time I would have, jurors would have, maybe Mr. King, have heard anything about Mr. Head's gun that he had on or about the time of the shooting being a 380?
Not that I'm aware of in the opening, but Ms. Drain has been on the witness list, and of course, Mr. Head himself would know his relationship with Ms. Drain and would be aware of the things that she may or may not be.
Sure.
But he certainly was aware that he was in possession of a 380 firearm. And more to the point, Judge, the ballistics report by the GBI, all that does to confirm is that those 5 380 shell casings were fired from the same firearm. I'm not to say that that's not an important fact. The fact that there were 380 shell casings found at the scene is something that's been known since the inception of this case, because the crime scene report indicated as such.
Okay.
And shell casings indicate what kind of caliber it is. The fact that there's a 380 firearm that was used in this scene is not something that was unaware to any party by any means.
Got it. Mr. King, I remember Ms. Drain's testimony and some of the things she said about your client. Did you try to talk to her, or and if so, how did, in preparation for trial? And if so, how did that go?
Didn't go well, Judge. Well, not me, but I do have an investigator.
Sure, your team.
Yes.
And was she cordial and happy to talk to you and answered all your questions?
Oh, no, we weren't able to.
Okay. All right.
And lastly, there is a recorded interview of her, and she doesn't mention the cop.
All right. Thank you.
Sorry, you said she does not.
Does not mention the cop.
That was an important question for Ms. Clay to ask. Does not. Right. Okay. I'm going to take that under advisement because Mr. Head's presentation will be a little ways down the road. I would need to have a conversation with Mr. Blige on the record. Normally, Mr. Blige, you don't have to answer any questions anyone other than your lawyer may ask you unless you testify, in which case you have to answer questions other people ask you. But I need to ask you a few questions about whether you want to testify or not, because Ms. Fagan is going to present something on your behalf, and it may be you, it may be something else. So we're going to cover a few things, okay? And you're going to need to, you take your mask off so the court reporter can hear your answers, all right? Mr. Blige, do you understand that you have a right to testify and that if you wish to testify, no one can prevent you from doing so? Do you understand that in that same way, no one can force or compel you to testify? In other words, if you want to say nothing at all, that is your absolute right. Do you understand that in the end, it is you and not Ms. Fagan or anyone in your circle of friends or in your family who decides whether you, Tyree Blige, will testify? Do you understand that if you do not testify, I will tell the jury that that decision not to testify cannot be used against you in any way? Do you understand that if you choose to testify, you will answer the questions from your lawyer, but you will also have to answer all proper questions posed by either of these prosecutors? You don't get to just stop once Ms. Fagan is done and run back to your seat and sit down. Understand? All right. Understanding those things, Mr. Blige, do you wish to testify in your case? All right. I find that Mr. Blige has made the decision to testify with a full understanding of his constitutional rights and that he has knowingly and voluntarily elected to testify. We'll bring the jurors in just a minute. And at some point during Ms. Fagan's presentation, she's going to call you to the stand. So,
And before the jury comes in, because of the lag thing, have you already been on the stand?
that was what I was going to ask Sarge. Is that the only witness you plan to call?
First, yes.
Or at least that's who you're calling first.
Yes.
All right. Then my suggestion is that we do just that. We get Mr. Blige situated. He's not going to need to stand to get sworn in. He can raise his right hand from a seated position. He will stay at the witness stand. You guys will set up however you want with the defendant at the witness stand. You know what to do with that. I'll ask you if you're going to present any evidence. You'll say yes. I'll say, call your first witness. You'll say, my client, however you want to say it, and he'll be right there and we'll get going. Does that work for you, Ms. Fagan? All right. Mr. King, any questions about that process for Mr. Blige? Mr. Abate, Mr. Rao, you good to go?
Yes, Judge.
All right. Do we have all 14 now? Great. Let's bring the jurors in. Well, let's not bring them in. Let's get Mr. Blige situated. Then we'll bring them in. Sure. Yes, please. Yes, sir. It works. We'll manage it. Thank you, Sergeant. Good Monday morning, ladies and gentlemen. Hope you all had a good Halloween weekend. I'm sorry, you all can be seated. Sorry, our Atlanta Braves couldn't finish things off for us as a little Halloween treat. Falcons neither, but my son's a Green Bay Packers fan, so there was joy in our house from Thursday night onward, beating the Cardinals. We left off on Friday, got to leave a little early. The state had rested. Lawyers and I worked through a whole bunch of things that we needed to. And it is now time to see if either defendant's going to present any evidence. I'll remind you of the burden of proof, which is 100% on the state. So neither defendant needs to present any evidence in this phase of the proceedings. But of course, they have the right to do so. And you may have figured out, because Mr. Blige is seated to my left, that Ms. Fagan is going to present some evidence. Ms. Fagan, do you intend to present any evidence in your case in chief?
Yes, Your Honor, we call Tyree Blige.
All right, Mr. Blige, if you'd stand to get sworn in.
That's one, it's not a true, all of it, so, yeah. Have a seat. State your name and spell for the record.
Mr. Blige, yep, you've been listening. Thank you for taking your mask off, and make sure you use that microphone.
Yes, sir. You say something about unmuting.
Yeah, so if you would hit stay muted. And got it. There we go. If you'd state your name, spelling it for the record, please.
My name is Tyree Blige, Tyreeblige.
All right, Mr. Blige, do you understand that you have the right not to testify
Yes, ma'am.
and that you do not have to testify today?
Yes, ma'am.
Are you waiving that right?
Yes, ma'am.
Let's get straight into it. Let's talk about that now. What time did you arrive?
I want to say between 1:40, 1:45.
Okay.
Mr. Blige, I'm gonna have you bend the microphone up a little bit. If you talk right into the end of it, it works best of all.
Can you hear me? Hello?
We're here, but just sort of have it going like straight in your mouth like it's a straw. There you go.
Okay.
Perfect.
All right.
Thank you.
Are you nervous?
Yes, ma'am.
So we've seen the video, and why did you arrive so late?
Because earlier in the day, yesterday I was working. I just got back in town from work, so I was at home most of the night. I was planning on staying home actually, but they kept asking me to come. It was a birthday celebration, so I just decided to go, even though it was late.
And what kind of work do you do?
I'm a professional commercial driver.
A professional commercial
Drive.
like truck driver?
Yes, sir.
And roughly how many hours a week were you working?
How many hours a week? I'm usually gone months at a time.
And that night, on the video, why did you leave around 2:08?
To go back and get my wallet.
Okay, so tell the jury what happened when you first arrived.
When I first arrived, I come in the club, see everyone, I see one person because I'm trying to get a direction of where to go, where the section is or where everyone is exactly. I go inside, I see somebody that was with the group, they direct me to go where everyone is, greet everyone, I'm in there. William asked me to buy a bottle for him. So I said, it's his birthday. So I said, okay. I asked the waitress, what's the price of the bottle, whatever. She tell me $300. Look in my pocket. I ain't got $300. So I asked her, did she take debit or credit? She tell me, yeah. So I said, okay, I got to go back out, get my wallet, go back out, get my wallet, come back in. By that time, it was kind of dying down, even though I was just in there I wasn't even in there that long. People were starting to walk out, starting to leave, and then everybody was acting like they was getting ready to go. So I already seen the bottle over there. So my assumption was somebody already paid for it because she was already serving the drinks for the bottle.
When you leave, did you leave with William Lewis and them?
No, ma'am.
What made you leave?
Like I said, it was already late. They were out. It was already late. I was getting ready to leave anyway. Looked like it was time to go.
Were they leaving?
They looked like they was preparing to leave, but they were still in there. When I walked in there, they were still sitting down.
Then let's go to when you finally get outside.
Right.
Okay. So when you get outside, you don't initially just get in your car and leave. Why?
No, ma'am. Because I'm waiting on to see what everybody is going to do. If they're leaving, make sure everybody's okay. If anybody need anything, just leave.
Did you drink any alcohol that night?
No, ma'am.
When you get outside, you went and grabbed a gun.
Right.
Why?
Because I seen someone else grab a gun.
Okay. So tell us about what you were actually seeing, not just what the video shows, what you saw.
Okay. First, I seen a female grab a gun. She grabs a gun from, I want to say did she grab a gun from a truck or a car or from a female? She grabbed a gun and she starts pointing at people. At the time, I'm still observing, just watching. She has a gun. She's pointed at William's head. The guy with the white shirt, the black shirt, the Nike. She points at the back of his head. I'm still observing because it's nothing happening. And she only thing she was saying, just chill. She's like she was trying to calm everything down. As far as I know, she had a gun to the back of his head, so I'm still observing. After she leaves, it's a scuffle. I see her go back with the gun, so I'm still right there, just observing by my car with my gun as well. By my car, no one can see me. So she goes by get the gun. Then Mr. Rivers, he goes back and gets the gun again. I'm still observing by my car door. He goes back and as he gets the gun, he's telling people like, I'm finna start shooting. I'm about to start shooting. He's putting the gun in people's face. Puts the gun in two of my friends' face. One of them backs away. He's running. One of them is actually froze. He is stuck because he's really in shock. He's by a car door. Put the guns in his face and he's backing up and say, I'm about to start, excuse my language, but I'm about to start shooting niggas. So he walks
Okay,
to.
let's stop. So we got when Helen had grabbed the gun and then Javante grabbed the gun.
Right.
After Javante grabbed the gun, you said you see him pointing it into someone's face. Who was the first friend?
Quentin Williams.
Okay, and so the jury remembers who Quentin Williams was. What did he look like that night?
That night he had I want to say he had the laces on his pants. He had the black pants and it had laces on it.
Okay, and is Quentin Williams the one that's running?
Yes, ma'am.
Okay, then you said there was another friend. Was that friend? So there's an empty parking spot where the commotion's going on.
Correct.
Was that friend in there?
Yes, ma'am.
And who was that friend?
We call him WAP.
WAP?
Yes, ma'am.
And so when the jury sees that video, what's WAP look like?
He has black on, and he's right next to the orange SUV.
Is he big, short?
Yes, he's big. He's big.
Okay, like 6 foot? Or
He's probably taller than 6 foot, probably like 6'3",
Okay.
6'4".
Did you see him with a gun?
No, ma'am.
Did you see Quentin Williams with a
No,
gun?
ma'am.
Did you see William Lewis with a gun?
No, ma'am.
Now, eventually you start shooting.
Correct.
What makes you start shooting?
Due to the fact Rivers is telling his people to get out the way. I'm finna shoot him.
Now, after the shots, you go behind your car.
Yes, ma'am.
Now, tell the jury what was going through your head then.
When I'm behind my car, I'm just thinking, is anyone shot? Is anyone killed? I'm back there scared. I'm trying to make sure I'm really worried to make sure he's not even shooting anybody anymore unless he make sure he stops shooting.
Now, when you say he, Who is it that you were watching that whole time?
Mr. Rivers.
Okay. And then you lay off 2 more shots.
Correct.
What was your line of vision? What made you lay off those last 2 shots?
My last 2 shots, I heard somebody shoot again. So that told me that he was still actively shooting his gun.
And now, 10 minutes later, we see someone with a jacket over their head and a
Correct.
white t-shirt on.
Correct.
Is that you?
Yes, ma'am.
Okay. And what were you doing?
Picking up shell cases in my ring.
And why?
I can't, there's no good reason to say that I did it. I was just nervous. I was just scared.
Have you ever been in trouble before?
No, ma'am.
Have you ever been in an active shooting before?
No, ma'am.
Were you licensed to carry?
Yes, ma'am.
And Tyree, what type of gun did you have that night?
A Glock 9mm.
Nothing further.
Mr. King, do you have any questions for Mr. Blige? Mr. Abate or Mr. Rao? And if you could, you had used the microphone. Wait, there we go. Thank you.
Good morning, Mr. Blige.
Good morning.
Now, you said you were going to the club for William's birthday,
Yes, sir.
and where were you coming from?
Home.
Where's home?
Rex, Georgia.
And when you drove to the club, were you in your black or dark colored 2003 Mercedes?
Yes, sir.
Okay. And the same Mercedes that you sold 2 months after this incident occurred?
Yes, sir.
You'd agree that inside the club, there was no conflict with anyone, correct?
Yes, sir.
And you'd agree you were only in the club for 10 to 15, maximum 20 minutes.
Yes, sir.
And you said you walked out of the club alone,
Yes, sir.
but you waited around.
Yes, sir.
And you said you waited around because you were seeing if your friends were okay or everything was good.
You just making sure that, everyone leaving, see if anybody need anything, because I was getting ready to leave.
So when you talking about everybody, you talking about Will, Preston, Xavier Head,
The whole group.
Asia Ashley.
The whole group. Yes, sir.
You got eyes on the whole group?
Not at the moment he's sitting in the car, just for me being inside phone, as far as a phone call wise.
Explain that to me. Phone call wise with who?
The people call William, somebody called me from William phone, asked me was I good. Couple more people called me just saying what they was going to do after. I was like letting everyone know I was going home.
Okay. So they called you to check on you, correct?
Yes, it was a back and forth thing.
And they asked you what your next move was, correct?
Right.
And you told them your next move was you going home.
Yeah, I'm finna leave, go home.
So explain this to me. If you told your friends who were checking on you, you were going home, what are you waiting around for?
Waiting around to see what they're going to get ready to do.
But you going home.
Correct.
So what are you waiting for?
Objection, Your Honor, ask and answer.
Overruled.
Just waiting on them to see what they're going to get ready to do. They're leaving.
While you're waiting to see what they're gonna do you watch them walk out of the bucket lot?
No, I couldn't see them walking out from my view.
Can you hear them?
No, sir. Not really. Because I'm just sitting in the car at the time.
Okay. What makes you get out?
I hear loud banging.
You hear a loud what?
Banging.
Did you see your friend, William Lewis, punch his girlfriend into a vehicle?
Not at the time. I seen it on the video that we've been showing.
You hear a loud bang, what do?
I get out the car and observe.
You observe Miss Asia Ashley on the ground?
No, the loud banging that I heard was from Miss Helen, I think, hitting the car window.
You don't hear anything. But what you're telling the jury is you hear nothing until you hear Miss Helen banging on a car window?
Hear the car window getting banged. It's loud commotion. It's screaming and yelling.
You called her Miss Helen. Did you know Helen?
No, sir. I know her from this case from when we've been the evidence.
So you're in your car, correct?
Yes, sir. What time are you referring to?
You just said you were in your car, right?
Correct.
And you didn't get out until somebody was knocking on a window?
Knocking on the window, yelling, it's commotion.
How did you know that she was knocking on a window?
When I got out, that's what I observed. I seen it. It was more than one banging on the window, punching.
So you're out of your car now?
Yes, sir.
Okay. Do you see your friend, William Lewis, come over and assault 3 females?
Yes, I seen it.
At that point, you didn't feel you should intervene?
It was a lot going on. I wasn't down there. Me rushing down there, seeing what's going on. I didn't know. It was male and female down there. I didn't want to be involved in any brawl.
But you're observing, correct?
Correct.
And you're making sure your friends, your people are good, correct?
Yes, sir.
Well, in that moment, you'd agree your friends aren't good.
No, they're not good.
And you did nothing, correct?
No, it wasn't I wasn't getting into that brawl.
But you did get in the brawl, correct?
No, I never got into the fist fight.
Right, you brought a gun, correct?
Not into the fist fight.
But you brought a gun down to where everybody was fighting, correct?
No, sir.
So is it your testimony that at the time you brought the gun down there, nobody was fighting, correct?
There was no fight when I brought my gun out.
No fight.
No fight. It was guns. When I brought my gun out, it was guns.
Brought your gun out,
Yes,
there was no threat to anyone, correct?
it was threats to everyone.
Because you had a gun, right?
No, because someone else had a gun.
You'd agree that before you fired your gun, nobody else did, correct?
Right.
But you didn't come down there alone, correct?
I came to the club alone. Yes, sir.
I'll be more specific, I apologize. You didn't come down with your gun alone, correct?
I came with my gun. I'm sorry. I'm not. I had my gun by myself. I came by my gun by myself and I shot my gun by myself. I'm not understanding. I guess if that's what you asked me. Yes, sir.
Okay. Ask a more specific question. As you walk down holding your gun, you walk down next to someone, correct?
Not next to someone's by me. Yes, sir.
Okay, so you just mentioned you've seen the video multiple times, like we all have during the last.
Yes, sir.
week and a half, correct?
Correct.
And you watched the video, right?
Correct.
And when you watch the video, you see your friend Xavier Head get out of his car,
Right.
okay, and then his car rolls back, correct?
Correct.
He gets back in the car, correct?
Correct.
And moves the car right aligned with the end of your vehicle, correct?
Yes, sir.
Right where you're standing with a gun, correct?
Yes, sir.
And then he gets out of his car, correct?
Yes, sir.
What kind of car was it?
I believe it was silver or gray from the video. I seen the video. It was from silver gray.
So when we see someone get out of that silver and gray car,
Correct.
that's Xavier Head sitting over there, correct?
Correct. Far as we seen on the video. Yes, sir.
Okay. And when he gets out of his car, he leaves that door open, correct?
Yes, sir.
And he's got gun in hand, correct?
Yes, sir. What we seen on the video. Yes, sir.
And before you guys go down there, the two of you stop, look at each other, and then begin to casually walk down to the area, correct?
Yeah, I wouldn't say look at each other, but it's on. Yes, sir. It's on video. Yes, sir. That's what we do about now.
But you'd agree you didn't run,
No, sir. No, sir. We never ran.
but there was a imminent threat, right?
Yes, sir. I'm just not. I'm confused on the word imminent. Sorry. I was confused on the word imminent.
I'm sorry. So at that, I'll rephrase the question. At that point, what you're telling this jury is that the threat was real, right?
Yes, sir. Yes, sir.
The threat was so real that the two of you just walked down like this, like any other day, correct?
Yes, sir.
Didn't run down there.
Yes, sir.
You didn't fire from there, correct?
From on the hill. Yes, sir.
You agree you walked at least 5 or 6 feet before you got to a point where you fired your gun, correct?
Yes, sir. Not far, probably a little further than 5 or 6 feet, but
Probably a little further.
like, yes, sir, far as backwards from where they were, from Mr. Riverson.
And you walked up even to where Tressen's white car with the black roof was, correct?
I wouldn't say I walked to his car. On the video, it's just his headlights is right there, just flash. They're on, so not necessarily walk right up to his car.
So it's your testimony. You heard the girls knocking on Asia Ashton's car, correct?
Right. I seen it. I heard a lot of commotion, a lot of banging going on. So that's why I got it.
Waited and observed, correct?
Correct.
And you observed a physical fight between William Lewis, Quentin Williams, and Solomon Smith, correct?
Yes, sir. Yes, sir.
You still waiting to see if your people need any help, correct?
Right. 'Cause I wasn't getting into it. So it's a fight. It's a fight. You know, two people fight, so they fight.
Well, at that point, didn't you just tell the jury that you had seen Helen with a gun?
Yes.
Was it still just a fight?
She had the gun, but like as I was saying, she was telling him to calm down. She didn't look like she was getting ready to do anything with the gun, but she still had the gun, which allowed me to get my gun just in case.
So, but it's your testimony that Helen pointed the gun at your boy Will. No big deal. You don't need to get involved at this point.
That is a deal. That is a deal. Not at the moment, no, sir.
And at that point, Will, Solomon, your friend starts with a W, and Quentin Williams, they're all like really punching each other at this point, correct?
Yes, sir.
But you still don't go and help, correct?
It's more than one person down there fighting at the time, but no, I do not go down there.
You never go down to break it up.
No, sir.
You don't do anything to cause the fight to stop, correct?
No, sir, because it eventually stopped by itself.
The fight stops, right?
Yes, sir.
And you say you see at this point Helen with a gun again?
Yes, sir.
He gets a gun for the second time?
She only gets gun one time.
All right, you have to explain it to me because now I'm confused. I'm direct. You said Helen gets the gun, she walks back over to the trees, or she gets the gun by the trees,
Correct.
walks back over, points the gun at Will's head.
Correct.
She walks back over to the black truck, is what you said, right?
Yeah.
And then where does she go with the gun this time?
She's right there. Mr. Rivers grabs the gun as seen on video.
So Helen only has the gun one time.
Yes,
correct?
sir.
You said Mr. Rivers gets the gun?
Yes, sir.
You do remember saying on direct that Helen had the gun 2 times and she took it from the trees where the truck was to the group, back and back to the group. You remember saying that on direct?
I said she grabbed the gun. She came over there, pointing at his head, telling him to calm down. After she tells him to calm down, it's a fight break out. She goes back over there where she got the gun from. Mr. Rivers comes over there and grab the gun, which I stated.
Okay. Now, you'd agree you pulled your gun and you shot, correct?
Yes, sir.
How many times you shoot, Mr. Blige?
Around 4 times.
4 times?
Yes, sir.
Now, you'd agree before you shot, you had to reach over your body and grab your gun, correct?
Before I shot, I'm not. What do you mean that I reached over my body and
Where was your gun?
in the car?
Okay, so before you shot, you had to physically go in your car and get your gun, correct?
Correct.
And then, according to your testimony, you wait around and continue to observe people fighting and guns out, correct?
Correct. I observed the fight. Yes, sir.
And there were guns involved, correct?
Yes, sir. Yes, sir.
And at that point, you do nothing, correct?
Right. I'm still watching.
And where's your gun at this point when you get it out of the car?
When I get out of the car, it's by my side.
Can you demonstrate for this jury how you had your gun?
Just by my side.
Stand up a little bit. Side, okay, is it in your pocket or do you just hold it by your side?
By my side.
Left or right hand?
Right hand.
Okay. Now, you're holding the gun. Is your finger on the trigger?
Oh, no, sir.
Okay. What? How you holding it?
I hold the gun and along the top part, just have my hands along the top part until I get ready to fire. That's when I use the trigger. But my hand is never on the trigger unless I'm getting ready to fight.
And you'd agree, where you were kind of hiding in the dark, correct?
Yes, sir.
No one knew you were over there, right?
I don't know, but I was out in the open with the firearm, so people seen me, I suppose.
Well, people seen you when you got out in the open and started open firing on a crowd of people, correct?
No, sir. I believe people seen me before that.
Where did they see you before that?
I was in the open. I was in the middle of the street, middle of the top of the hill.
When you say you were at the middle of the top of the hill, are you saying you were in the middle of the top of the hill when you were walking down with Mr. Head?
Correct. Very visible. I'm sorry, I was very visible. Yeah, exactly what you were saying, walking down, very visible.
So you'd agree, you just told the jury that you got your gun out of the car, correct?
Correct.
And as you waited and observed, you waited behind your car in the dark with your hand on your gun, correct? Holding it.
Correct.
Okay. And no one could see you at that point, right?
As far as I know, no.
You were the only one that knew you were armed who wasn't in your crew, correct?
I don't think no one knew I was armed.
Do you carry a gun everywhere you go?
No, sir.
Where do you keep it when you don't have it?
It's at home.
But you just chose to bring it that night?
If I'm going out, most of the time I bring it out. But again, like I said, when I'm working, I don't carry a gun while I'm working.
So when Mr. Head got out of the car, you'd agree that at that point you put your finger on the trigger, correct?
I would say yes to that question, I guess.
And then you and Mr. Head had to walk down almost in sync down to where you began to fire your gun, correct?
According to the video, yes.
And had, isn't it true you and Mr. Head were communicating, right?
Not. I guess you could say yes, but not really directly. Like I said, only time I really seen him was leaving from the club because he actually passed me by once he walked out the club.
I'm talking about during all the commotion,
Correct.
you and Mr. Head were communicating on your cell phones, correct?
No, sir, not during the commotion.
Tell this jury how Mr. Head knew to stop right in front of where you were, where nobody else could see you.
That I don't know.
Just a coincidence?
When he did, actually, I'm in the middle of the street once he stopped, according to the video.
And is it,
So I'm not in the dark when he stopped the car.
and is it just a coincidence that Mr. Head tries to get out not once, but twice to join you?
No, he has, according to the video, he was right there by the commotion before Miss Ashley backs up her car. He tries to put his car in drive, get where I don't know if it's in neutral or drive, whatever. He gets out, starts rolling back. He's still down the hill. Then as the fight breaks out, he drives up the hill, then stop.
Next to you.
Yeah, behind me some more. Oh, he's more further up the hill than I am, but up the when it kind of by me, yes, sir.
And then he gets out.
Yeah, yes, sir. Yes, sir. According to the video.
Well, I'm asking you what you saw. I'm not asking about the video. I'm asking what you saw.
At the time, I didn't see anything. I'm worried about Mr. Rivers with this gun towards everyone.
It's your testimony when Xavier Head got out of his car, you had no idea he was holding his gun.
No, I didn't know he had no gun.
When did you realize he had a gun?
When he started shooting.
It's your testimony. You're telling the ladies and gentlemen of the jury that
Yes,
you
sir.
didn't know Xavier Head was armed until he started shooting.
Exactly.
So the walk down from Xavier's car and where you're at, where you guys walked down almost side by side, you had absolutely no idea that Xavier Head had a gun.
Again, no, sir, due to the fact that I didn't even see him until we was leaving. So I didn't even know he had a gun. I was only there for approximately, as you said, 20 minutes, the max. So there was no way he could just tell me that I have a gun in the car or I'm supposed to know. Because again, like I told you, I just coming back from on the road for months at a time. So I wouldn't have known if he had a gun or not.
I must have asked a confusing question, so I apologize. What I'm asking you is when Xavier Head gets out of the car, okay?
Correct.
And you two walk down towards the bottom of the hill or the incline.
Correct.
You had no idea that Xavier Head had a gun until he fired it?
Yes, sir.
And before you pull the trigger, you got to lift your arm, correct?
Correct.
And you lift it up, right?
Correct.
And you aim that gun at the crowd of people, correct?
No, I aim it at Mr. Rivers.
And you would agree, Quentin Williams was at the very back of the parking lot away from Mr. Rivers before you shot your firearm.
Yes, sir. He backed up. He backed up from the firearm.
And at the time you shot your firearm, nobody was fighting, correct?
No, sir.
At the time you shot your firearm, Mr. Rivers is behind the orange SUV that your friend Nick had, correct?
No, he's not behind it. He's actually on the left side, on the left back side of it.
Of the SUV.
Correct. But not directly behind it.
And you agree Mr. Rivers never shot it at that point?
No, not at that point. No, sir.
And you'd agree at the time that you shot your gun, Mr. Rivers wasn't threatening anyone.
Yes, he was threatening him.
You've seen the video, right?
Correct.
No one's around him but his own friend. You tell the jury he's threatened his friend?
He's threatening my friends.
Which friend?
It's two friends, again, in that vicinity that you're talking about. When Williams backs up, it's still one friend right there by the truck that you saying that he was behind.
Which friend is that?
His name is Walt.
What's he look like again?
He's big. He's about 6'3", 6'4". He's right there by the driver's side door, by the SUV. I could show you if you was to play the video again. which I don't know.
I can pull it up for you in a second.
Thank
And when you decide to pull the trigger, you hear the gun fires, correct?
Yes, sir.
And you can feel it fire, right?
Yes, sir.
And you fire again.
What incident? What part are you talking about?
Well, how many times do you fire a gun?
Just about 4 times.
So after the first one, you fire again, correct?
Yes, sir.
And in order to do that, you have to keep squeezing the trigger, correct?
Yes, twice.
And you'd agree after you pull the trigger the first time, everybody scatters, correct?
Correct.
No one's threatening you, correct?
Correct.
No one's threatening your friends, correct?
They are.
As you're firing your gun?
As I'm firing my gun,
Mhm.
no. He's shooting as well.
Well, you've seen the video, right?
Correct.
You'd agree that Javonta Rivers didn't fire his gun until you and Xavier Head fire into a crowd of people multiple times, correct?
We didn't fire into a crowd of people.
Okay. Explain that to me because you saw the video, right?
Correct.
And when you fired your gun, there were people all around, correct?
When I fire my gun, Rivers is behind. He's away from his people, and he's actually telling them to get out of the way.
He's behind what?
He is behind the vehicle. The people that he came with, they're not over there by him because he is still a further distance from where they are. But he's by the sure.
You go ahead, I'm sorry.
No, I'm listening to what you're saying.
I think you were about to answer what I was about to ask. What vehicle is he behind?
He's by the SUVs on the left side, further back from the SUV.
Orange.
Correct.
Your friend's SUV.
Correct.
And you'd agree that there were no bullet holes inside of Nick's orange SUV, correct?
No, sir. Far as I know, I'm not sure, but far as I know,
But you were firing at Javonta Rivers, correct?
correct.
Now, your position to this jury is that you were acting in defense of others, correct?
Yes, sir.
But you'd agree before you had to pull the trigger the first time, you had to make a lot of decisions, correct?
Correct.
And you ultimately made the decision to fire into a crowd of people, correct?
No, sir. I didn't fire into a crowd of people.
Okay. Well, how many people were in the area that you recall when you shot your gun, what you say 4 times?
The first couple times, it was a group of people near, and then after the times, it was only him. The second couple times that I shot.
So let's count together, okay? Your friend, I want to mispronounce it. Wap?
Yes, sir.
So your friend Wap,
Yes, sir.
you got Tresson, correct?
I don't think he's there at the time. From far as I can remember. No, I don't think he's there at the time.
You don't remember on the video seeing Tresson's car right parallel to where you and Xavier Head are shooting?
Sorry, say that one more time.
You don't recall seeing it being right next Treston's car when you and Xavier Head are shooting?
Again, no, I was not right next to his car.
And Kayla Rivers was out there, correct?
Yes, sir.
Devonta Rivers, correct?
Yes, sir. Correct.
Solomon Smith, correct?
Yes, sir.
And then you got Deanna Clark,
Yes, sir.
Helen Abraham,
Yes, sir.
Rhea Thompson.
Yes, sir.
We up to almost 10 people. So what's a crowd to you?
Crowd is more than four.
More than what?
More than four to me.
More than 4?
Yeah.
So you fired your gun, at least the first time, based on your testimony, into a crowd of people, correct?
Not into a crowd of people, no, sir.
You would agree when you fired that gun, you endangered every single person's life in that parking lot, correct?
No, sir. I don't agree to that.
Why not?
Because when I fired my gun, he was away again from the crowd of people.
Well, you'd agree you didn't hit Devonta Rivers, correct?
Correct.
You'd agree as a result of all this gunfire, Solomon Smith is dead, correct?
Correct.
Now, after you fired your gun, Xavier Head drove away, correct?
Yes, sir. According to video, yes, sir.
You didn't though, correct?
No, sir.
You stayed by your car, crouching behind it, correct?
Correct.
And
I got in the car, then I got back out.
when you got back out, you crouched behind the back of it, correct?
Yes, sir. I was peeking over the side. Yes, sir.
And then you fired 2 more shots in the direction of multiple people, correct?
In direction of Mr. Rivers, yes, sir.
You'd agree when you fired those additional shots at Devonta Rivers, he didn't have a gun, correct?
Not from what I can see.
But you shot at him anyway, correct?
Yes, sir.
Not once, but twice.
Yeah, I shot twice.
And after you finished shooting, did you call 911?
No, sir.
So you didn't report to 911 that your life was in danger, correct?
No, sir. Not at the time. Not in the midst of everything. No, sir.
And that your friends' lives were in danger, correct?
No. Yes, sir.
And in fact, you never reported to 911 that anyone was in danger, correct?
No, sir.
And that's because you took care of it, right?
Yeah. Yes, sir. It was over with, the situation.
And you'd agree the reason you got your gun, went in your car, was because you heard your boy Will say, "Get the strap," correct?
No, sir.
So is it your testimony? You heard everything but Will say, "Get the strap."
I didn't hear him say nothing, get no strap. I heard a female's voice say, "Get the strap," but I didn't necessarily hear him say, "Get no strap."
And you were present during Mr. Lewis's testimony, correct?
Yes, sir.
And you heard me ask him, you said, "Get the strap," right?
Yes, sir.
And do you recall him saying, "I don't remember saying it, but that sounds like something I'd say," correct?
You have to refresh my memory on that. So I don't remember that last part. I remember him saying he didn't say it, but I don't remember him saying that's something he would say.
You don't remember him saying that in the courtroom just a couple days ago, correct?
Yes, sir. Like I said, I remember him saying that he didn't say that.
And you remember Will saying during his interview, or was questioned here about his interview, that when he comes to Atlanta, he travels with people with guns, correct?
I heard him say, and which he stated on in his interview, is that he has to be around or protection. It was something like that, but it's in his interview. But I didn't say that every time he comes to Atlanta, as you're saying, like Fulton County, that he has to have guns.
Okay. You and Mr. Head were his protection that night, correct?
No, sir.
No, sir.
No, sir. Not as far as like a body, like a bodyguard, a security guard, something like that.
Not an official, right?
Not, no. I'm everyone's protection to anything. It can be a stranger. There, anything. If it's gun violence, somebody's getting harmed, is getting ready to die. That's when I feel like I had to intervene. That's when I feel like I'm protection in.
But you don't intervene when women are being assaulted, correct?
No, I would have intervened, but again, it was a crowd, it was a group fight. It was a whole brawl. Me getting into that brawl with male, female. I don't know what's going on. So it's no threat to anyone is going to die.
You know that doesn't make sense, right?
It makes sense. You have to sit there and think about it, Mr. Abate.
Okay. So I'm gonna sit here and think about it. So you don't get involved when Will's pretty big, right?
Not that big according to me. It is not big.
Well, he's bigger than me, right?
Y'all about the same size.
We're about the same size?
Yes, sir.
Okay. That make me feel real good. Now, you would agree that Will is way bigger than Helen, correct?
I don't know how necessarily big is Helen.
So you didn't see that.
See what?
How big Miss Helen was. She's a short female. You didn't see that?
Miss Helen was pretty short. She was about my height when she came in here.
Okay. And Will knew you had guns that night, correct?
No, sir. No one knew I had a gun.
You're just the secret protection.
If that's what you want to call me, Mr. Abate.
Well, you tell me what I'd call it.
You said I'm the secret protection.
What would you call it?
No one knew I had a gun.
Okay. You've known Will for how long?
Probably about four or 5 years, including to today.
And you've known Tresson for how long?
About the same amount of time.
And it's your testimony that in those years, no one knew you carried a firearm.
No, sir. I didn't get a firearm till 2019.
Okay. When in 2019?
It had to be around my birthday. No, it wasn't probably like around my birthday. It had to be probably like earlier that year, 2019. Could be like February or something like that.
Because you know that doesn't make sense, right?
Ooh.
To be your birthday. Because when is your birthday? It's August, right?
No, my birthday's not in August.
When is it?
My birthday's in June.
Okay. So your testimony, you got it in February 2019?
Yeah, it had to be like February.
Okay.
Around early, it was early that year though, 2019 for a fact.
Now, you wait in your car, correct?
Yes, sir.
And then you make the decision to move your car to the back of the parking lot, correct?
Yes, sir. Yes, sir.
And when you move your car to the back of the parking lot, Quentin William walks back there with you, correct?
I believe he was already back there.
So you guys, when you get back, they're able to meet, talk, correct?
Yeah, I moved my car to the back to make sure everyone was okay and just to check on everyone and see if anyone was hurt or not.
And while you're checking to see if anybody's hurt, y'all have a discussion about picking up shell cases, correct?
No, sir. The conversation I had was is anybody hurt? Everybody was okay. Mr. Williams stated to me that he lost his phone and his wallet, so he began looking for his phone and his wallet.
Okay, and you see Mr. Williams, you walk up with Mr. Williams, correct?
Walk up with him?
Yes.
No, sir, no, sir.
Okay.
He walked up to the same areas, but not necessarily with him though.
Okay, so y'all don't go up there together, but you walk up there at the same time, correct?
Up where are you referring to down the hill or are you referring to up the hill where my car was parked at previously, where I parked it back again?
Let me be more specific. Remember where the orange SUV is in the parking lot?
Correct.
You and Mr. Williams walk into that area together, correct?
We walked into the area.
And you'd agree, because you've seen the video, Mr. Williams bends down multiple times, correct?
Correct.
And then goes around in a circle up to where the red car is, and even up to where you're shooting, correct?
All I can remember from what I seen was the video, him looking around, going in a circle by the orange in the red vehicle.
And you'd agree he bends down over 10 times, correct?
Correct. He's looking for his phone and his wallet, according to what he told me.
How many phones and wallets he got?
He got 155. I don't know how many he has, but like I said, he said he looking for his phone and his wallet.
But you know he dropped them all, correct?
Did he drop who?
He dropped them all, correct?
He dropped all of them.
Mhm.
Oh, yes, sir. He dropped his phone and his wallet.
Okay. And that's why he bends down and picks something off the ground many, many times.
Like I said, he said he looked for his phone and his wallet. And he said that's what he lost. So he was looking for it.
What are you looking for
I pick up the shell case.
in that area by the red
Yes, sir.
car?
I pick up shell cases by where I previously parked it.
So after you walk up there with Mr. Williams, you go back to your car, correct?
Yes, sir.
Mr. Williams goes back for a second round in that area to look around, correct?
Yes, sir. Yes, sir.
And then Mr. Williams runs back to your car, correct?
Yes, sir.
Is he bringing you his phone?
No, I think he asked me for a ride.
Did you give him one?
He's no, because somebody said he's going to give him one.
Somebody said he's gonna give him one, but he ran to ask you for a ride first?
Yeah, because he was actually going the same area, but I guess he changed his mind because somebody told me he's going to give him a ride.
So he ran to your car after walking in a circle, picking things up, asked for a ride.
We was getting ready to leave.
But were you getting ready to leave?
Yes, sir. I was getting ready to leave.
So if the video shows Mr. Williams run to Nick's car, and then you pull out of your parking spot back, round the corner, and then you park back into where you were parked earlier.
Correct.
That be incorrect?
No, that's correct.
You weren't leaving, correct?
Correct.
You parked the car.
Right.
And when you park your car, you put your zip up jacket that you had on earlier on your head
Right.
to conceal your identity, correct?
No, sir. I was panicking and it's the middle of July night. So I was hot as well.
So you put it on your head?
It wasn't on my body. So, and again, like I said, I was panicking, very nervous, actually scared at the time as well.
But you're so scared that you don't leave, correct?
Correct.
That you wait in the back area of the parking lot with Mr. Williams, correct?
Are you talking about, you just said that I came out the car when I parked the second time. Now you went back to when I went back down the hill again the first time?
Correct, because you said you were panicked and scared.
Yes, I was. Yes, I was scared. I was scared. I was even more scared after the fact. Once I met up with everyone from the situation you talking about the first time.
Were you even more scared where you went back to the spot where you acted kind of like a sniper and shot at Mr. Rivers, Miss Jakayla, and Miss Kiana?
Just repeat that question one more time.
You were so scared that you went back to the spot where you acted like kind of like a sniper and shot at Mr. Rivers, Mr. Kayla Rivers, and Kiana Clark.
Yes, sir. I was still scared at the same time.
So you went back.
Yes, sir.
And it's your testimony that you put your jacket on your head because it's a July night and you're hot.
I was having a panic. I was really panicking, nervous.
When you're panicky and nervous, do you calmly walk around and just pick up shell casing?
To you, it may look calmly, but I'm not calm. I'm not calm right now.
You're nervous right now, right?
Yes, nervous then, nervous now. Been nervous for the last 2 years of my life, every day.
And you'd agree that you were so scared and you were so nervous, you didn't call 911, correct?
No, sir.
You didn't walk to the club where you knew there was security and get help, correct?
There was no one there.
There was no one there.
No one outside over there.
How do you know? You didn't go check.
Now you can see the entrance of the club from where.
From when you're sitting in your vehicle, you can see.
No, you can see the entrance from down the hill where the whole incident occurred.
But you couldn't see Ms. Asia get pushed into the car.
Again, I was in the car up the hill. I couldn't see that with multiple cars on the right side of me parked.
You'd agree you couldn't see the security because the door into the club was closed, correct?
Correct. No one was outside in the front.
And you never went to check to get security, correct?
No, sir, not at the time. No, sir.
Instead, you just watched and observed, correct?
Yes, watch, observe the brawl. Yes, sir.
So you continue to watch and observe, and you said watch men fight, correct?
Yes, it was men fighting. Men and women fighting. Yes, sir.
You're worried about your friends, correct?
Yes, sir. Once the gun was involved. Yes, sir.
Glad you brought that up. Once the gun got involved, you didn't go get security, correct?
Once the gun got involved, no, sir.
That's because you were going to take care of it, correct?
Yes, I was going to try to intervene and stop the violence.
Because that's what you're there for, correct?
That's not why I was there.
Well, you were the one with the gun, right?
I had a gun in the car. Yes, sir.
And you're the one who protects everybody, correct?
No, I'm just not a person somebody calls to protect.
Didn't you just testify to this jury that you were there to protect your friends?
No, I did not tell the jury that I'm just there to protect my friends. I came to have a good time.
And he killed someone, correct?
No, sir.
Someone died as a result of your shooting, correct?
No, sir. They did not die because of me shooting them. No, sir.
Well, who shot him?
I don't know. Evidence concludes to someone who was closer by him shot him.
Well, you've seen the video, correct?
Yes, sir.
And you see Mr. Rivers' first shot into the air, correct?
I see him shoot.
You didn't see where he was shooting, though.
It didn't, to me personally, that what you asking me, Mr. Abate?
Yes.
To me personally, it didn't look like he was in the air just because you see a muzzle flash.
Well, you're focused on him when you're out there on July 12th, correct?
Correct.
And you're focused on him because he's got a gun, right?
Correct.
But you're not focused on where he's shooting.
I see him shooting, but at the time, once I show, as you see me run back to my car.
After you shot Solomon Smith, correct?
No, sir, I did not shoot Solomon Smith.
Well, you've seen the video, correct?
Correct.
And you'd agree that Solomon Smith goes down before Javonte Rivers fires one shot, correct?
No, are you stating that I shot Solomon Smith?
I'm asking you. You watched the video, correct?
Correct.
And Solomon Smith goes down after you and Xavier Head are shooting in that direction.
He goes down once everyone shoots.
You watched the whole video with your attorney mistake,
I
correct?
watched the whole video with everyone present in this courtroom.
Right. And so you were watching. Did you see Solomon Smith fall before Javonte Rivers fired a single shot?
No, he fell once everyone shot.
So you weren't watching that, correct?
Yes, we was watching.
So if Solomon Smith fell before Javonte Rivers fired a single shot, who shot him?
That is the question you should ask the detective.
And you heard the evidence that there's two types of projectiles inside of Solomon Smith,
Yes, sir.
a 380 and a 45, correct?
Yes, sir.
And Mr. Smith fell before Javonte Rivers fired a single shot.
If that's what you stating, Mr. Abate, again, once everybody shot, that's when I seen Mr. Smith fall.
And in the direction of Solomon Smith, you and Xavier Head are shooting, correct?
I'm not shooting in the direction of Mr. Smith. I'm shooting in the direction of Mr. Rivers.
Okay. Now, you don't shoot after you see people holding guns, correct?
I shoot not while the female is, I don't shoot while the female's holding a gun. I shoot when the male is holding a gun, telling everyone he's going to kill them.
Is that because you wanted to get in the best position to kill people?
No, sir. It's never my intention to kill anyone. That's why I was waiting so long.
And you can see on that video, you had many clean shots to hit Javonte Rivers, correct?
Yes, sir. That's why I waited till the crowd removed itself, which was first why I shot into the crowd, which I didn't. I waited till him remove itself from the crowd to get a clean shot. Yes, sir.
But when you had the clean shot, you didn't take it, correct?
I did. That's the only time I did shoot, when he was away from everyone.
Well, before you shot, you had many, many clean shots of Javonte Rivers and you didn't take it, correct?
No, it was not a clean shot if he was by the crowd.
But instead, you and Mr. Head casually walked down the hill and then began shooting, correct?
Yes, sir. You say we walked down and sing. I said I walked down on one side, he walked down on the other side.
And that's because Javonte Rivers wasn't the target, was he?
Javonte Rivers was always the target.
No. Because Solomon Smith was the one who was fighting your friend Will Lewis, correct?
Everywhere. It was a brawl. Everyone was fighting everyone.
And he was disrespecting your crew, correct?
No, I don't know. Again, I was up the hill. Only time I responded was when I seen a gun come out, sir.
And you wave Xavier Head to move up the hill, correct?
No, sir.
Okay. Now, you keep saying according to the video,
Yes, sir.
Mr. Blige, but you were there live, right?
Yes, sir.
And you say you've never been in a shootout, correct?
Yes, sir. I've never been in a shootout.
Then this is a pretty memorable experience, correct?
Yes, sir.
But it's all of your answers today have been according to the video, correct?
Yes, sir.
Not according to what you remember that night.
Yes, sir. Because what I remember and what's on the video are facts. Anybody can try to remember something, but that's not how it happened. That video is going to show you the truth, though.
And you'd agree, you waited to tell everybody your story until you looked, examined all of the evidence, correct?
Yes, sir. Well, I already knew what happened, but that just The video is going to show you the facts, exactly what happened.
You knew what happened, but you didn't tell anyone, correct?
No, sir, I was scared.
In fact, your story of self-defense has never been told until today, correct?
No, my story of self-defense always been told especially since the beginning of time.
But that story was never communicated to 911,
No, sir, I did not call the police. No, sir.
was never communicated to the security guards, correct?
Again, no, sir, there was no security guard out there.
And this incident happened on July 12th of 2019, wasn't communicated in August of 2019, correct?
No, sir. Well, no, it happened on July 12th.
Your story about self-defense of others wasn't communicated in September of 2019.
What do you mean? It was communicated to who? I'm sorry, I can't ask you a question. Can you ask me a different question? Because I'm not understanding what you're saying.
Your story of self-defense wasn't communicated to anyone until 2.5 years later today.
No, sir. Again, it was always been self-defense.
Well, the detective called you, correct?
No, sir. She didn't call me. We got in contact with her.
You don't remember talking to the detective over the phone?
I did not talk to the detective on the phone. My attorney talked to the detective on the phone.
Okay, so it's your testimony that you never spoke to Detective Barry over the phone.
My attorney spoke to the detective.
Not what I asked. Is it your testimony that you never spoke to Detective Barry over the phone?
Again, my attorney spoke to the detective.
So the question, Mr. Blige, is not, did your attorney? The question is, did you?
Correct. I didn't talk to the detective.
So if you heard your own voice, would you be able to recognize it?
Yes, sir.
Your Honor, I object to this discovery that was not provided until after the 10 days. My client has not seen this discovery before.
My response would be this is impeachment evidence of Mr. Blige, since he physically was the one on the
Well,
phone.
before we get into what it is, are you saying, Ms. Fagan, you didn't receive what Mr. Abate has right now until, we'll just say, a few days ago? Okay. How would that be? Should we take our morning break?
Mhm.
We're going to take our morning break, ladies and gentlemen. If you would please return to the jury room. Don't talk about the case while you're back there. No outside research. And we'll get you back in here before 11. Ms. Blige, you stay right there. At the latest. Unless Ms. Clay needs more time, then we'll do more. We'll see.
Thank you.
All right. You all can be seated. So I'm just confused if this is a recording of Mr. Blige even saying, my name is Mr. Blige, and he's talking to law enforcement, why Ms. Fagan doesn't have that. That's what she told me. So
She hasn't, and I reserved the discovery once I got on the case and the abundance of caution, because I
can't assume.
Right, can't assume, and you can't rely on anyone from the past. So I basically reserved the supplemental report, because my supplemental report was missing 2 pages after speaking with Detective Barry, and I reserved recordings that when I clicked on them in my drive actually weren't working. So I went ahead and reserved them. So
And when would this reservice have occurred?
probably probably week and a half, maybe two weeks ago today, probably.
Okay.
And a little bit of background into the phone call. It's a phone call that my client has not had an opportunity to hear. And it only says, I thought my lawyer was gonna call you and she's gonna call me. That, and there's we're really touching on his Fifth Amendment right here.
We are getting, it's another reason why the jury's taking a break. You've been kind of careful, but did you talk to anyone? Mr. Blige doesn't have an obligation to talk to anyone. The fact that he didn't tell some people, you might be able to explore, but I know you're aware of what you're doing, but you are in a space that gets real complicated for the state real quickly. But you may have known, which I didn't, that in fact, Mr. Blige did speak, even if only fleetingly, to Detective Barry. He seems not to remember that. And maybe he could listen to the call during the break, since it sounds like it's 15 seconds worth. And then you could ask him again about that. But I caution you, I know you're aware of what the law is, but you need to be very careful around asking Mr. Blige why he didn't say something to law enforcement. But I wasn't aware that he actually exchanged words, however briefly, with Detective Barry. I thought it had always been counsel having that interaction.
And according to the recording, my recollection, he hadn't retained Miss Fagan at that point. They were thinking about it. She had not been retained. He said when he retains his counsel, that's when his counsel will, make a call to Detective Barry.
And there were no warrants for Mr. Blige at this time either.
Correct.
Okay.
He was under arrest, he was in custody, and he didn't have counsel at the time.
Okay.
Except that the next recording is of me, maybe less than 30 minutes later, saying I've advised him not to.
Okay. But if in fact, when Mr. Blige was talking with Detective Barry, the final arrangements hadn't been made, then it's less problematic. But more importantly, why don't you and Mr. Blige listen to it during the break? And
he does, though, provide my full name in the recording. So under his impression, he thought there was an attorney-client relationship at that point. Even though he had not retained me, we knew we were moving forward further together from day one.
I don't want to be argumentative, but that's kind of incorrect, because the detective asked after he says her name,
how about this? Can you just play it right now?
Yes.
Yeah.
Is this more audible than the jail calls?
Yes.
Hope so. Yeah. I'm sorry. And the sharing of the screen don't do that.
Remember to click the little audio box.
How you doing today, man?
I'm good. How about yourself, sir?
I'm okay.
Good, good. One second, because I'm trying to figure out something that I'm doing right now. 1 second.
Okay.
I'll make the block.
Oh, that'd be.
Yeah.
Okay. All right. Can you hear me?
Yes, man.
Okay, cool. Now, so you know, I was calling. I'm trying to get in touch with you about that incident that happened a couple weeks ago at the.
Okay, yes, ma'am.
Are you willing to talk with me? Or there was a rumor. I feel like I heard that possibly you were getting a lawyer.
Yes, ma'am. Yes, ma'am. Actually, she told me that she was going to get ready to contact you all.
Okay.
Because she told me I didn't have to, had to come down or whatnot. Which is why, because I just seen a phone call, and then my father had just called me just recently and told me that she was calling. That's why I didn't know.
Okay.
That's why I didn't attempt to call yet.
That's okay. That's okay. I support your decision with it, but if she already, I'm talking about your lawyer, already retained, if so, I can go ahead and take her information.
Because we was working on it, as far as everything. Because I was actually supposed to be meeting her today.
No problem.
But she told me she was going to be giving you guys a phone call. That's why I was saying anyway.
Okay, she hasn't called yet, which is the only reason I was just still trying to reach out, because I didn't know. Like, again, it's a rumor about it, but I do want to respect it if it's already so. But
yes,
so I can wait for her to give me a call, but I just want to ask, do you want to speak with me before me speaking with her?
Well, I'll just rather let her talk. Just talk to everything. Yes, ma'am.
That's fine. Do you have her name or the law firm that she works for?
Yes, ma'am. It's Nicole Fegan.
1 second. One second. Fegan?
Yes, ma'am.
F-E, I guess, G-A-N, Nicole. Do you know what law firm she works for?
I believe that just a law firm with LLC.
No,
Yes, ma'am.
I should be able to Google that for her number then, yeah?
Yeah. Yes, ma'am.
I appreciate you giving me a call back. I look forward to hearing from her soon.
Okay.
All right.
Thanks, man.
Bye-bye.
All right. I don't think you should ask.
Blige.
Yeah, how you doing today, man?
Cool. I don't think you should ask Mr. Blige anymore about his communication with Detective Barry, having heard that recording. Do you have more you want to ask him about after the break?
Yes, Judge.
Okay.
Just briefly before the break, the objection was not really an objection to the question. It was an objection to not being served and things of that nature, and it was served. So
I find that Ms. Fagan has sufficient notice of the content of this call. I also find that having heard the call, it's such that it wouldn't be appropriate to explore anymore why Mr. Blige didn't share anything with Detective Barry. That you might want to argue he had an opportunity because he had contact with Detective Barry to say, hey, this was all self-defense. I find from that call that Mr. Blige believed that he was represented and that his lawyer had said, let me do the talking. And so this wouldn't be the interaction that would be appropriate for you to use for that point. And I think it is safer for these proceedings to move away from your last question and go to a different topic about something else other than did Mr. Blige tell people? I think you've made the point that he didn't reach out to security. He didn't call 911. If you want to ask him, did he tell other people who've testified here who are non-law enforcement? I guess you can do that. point's been made, but I'm directing you to move away from anything about Mr. Blige telling the great unknown or in particular law enforcement.
No, I don't disagree with Your Honor.
Okay.
My remarks were based on her objection. It appears to the jury that she wasn't served with this.
Got it. I will make clear, we listened to it. It's something that we all have. That's not the issue. We're moving on. If you want me to do that. Well, you tell me what's fine. I'm happy to, so they're not left with the impression that Ms. Fagan didn't have it. I don't think that's the issue. That doesn't influence my ruling at all. It's a 2-minute and 36-second phone call. So she's had it for more than enough time to figure out what to do with it. I just don't think, I think it's contents drive my decision.
And I agree with your decision.
Okay.
I'm not disagreeing with your decision by any means. I guess when the jury left, the impression was the reason Ms. Fagan was objecting was because she didn't have it or wasn't served, or her client wasn't on notice of the call.
Right. She said, my client's never heard this. And that may be, it's not entirely true. Of course, he was party to the conversation. So he heard the conversation. He didn't hear the recording of it. I'm happy to say something to address that. We didn't have a discovery issue, but for another reason, we're moving on to your next topic.
That sounds good. Thank you.
Ms. Fagan, you all right with that? Okay. Mr. King, anything else? All right. So I misinformed the jury. I need to make sure Ms. Clay gets a little bit of a break as well. So we will come back at 11:10, please. And our lunch break's got to start at 12:15 today. So we've got about an hour before we hit the lunch break. Thanks. Sure.
So you good? Well, it's gonna have to, you can't breathe, you can't breathe, you be dead. Couldn't breathe.
I'm having trouble.
Oh, okay, you have trouble breathing?
Yeah.
Okay, well, you gotta keep a mask on while you just sit. You good, sir? That's good? Okay. Can you move? Okay. Okay. Report come to order.
Did you get the break you needed?
Yes.
Great. All right, Sarge, when you're ready, if we could bring the defendants out, get Mr. Blige back to the stand. All right, Mr. Abate, are you ready for the jurors to come back?
Yeah, yes, just for clarification, are we gonna at least answer the last question?
Tell me what you recall the last question being.
It's your testimony that you didn't speak to Detective Barry, and I wasn't gonna go into the context, that was never my point. It was just, he's the one who said he never spoke to Detective Barry, he's the one who brought, I asked about 911, and he said something about the police, so at that point, he opened the door.
So he did speak with Detective Barry. We've heard that, but what are you going to do with that fact? And the jurors may say, what did he say to Detective Barry? And the kinds of things he said, normally a jury wouldn't hear. He basically said, I've got a lawyer and that's who you should talk to. And so my preference would be we just move on. Ms. Fagan, is that all right with you? All right. Anything else, Mr. Abate?
No, you're on.
Mr. King, ready for the jury?
Yes, sir.
Ms. Fagan?
Yes, Your Honor.
Great. Thanks.
all jurors are present, Your Honor.
Thank you, Sergeant. Everyone can be seated, please. Ladies and gentlemen, when we took the break, there was some concern about whether certain things had been provided in discovery or not. That's been cleared up. Everyone has everything that was being discussed, but we're going to move to a different topic. So, Mr. Abate, if you would ask, your next question of Mr. Blige.
Thank you, Judge. Now, Mr. Blige, in your mind, you didn't do anything wrong that night, correct?
Yes, sir, I did.
Yes, sir, you did something wrong?
Yes, sir.
Okay. I guess, what do you think you did wrong?
Pick up those shell case.
Okay. And in your mind, when you shot, you were justified, correct?
Yes, sir.
But you picked up the shell casings.
Yes, sir.
And yet, when you did it, you hid evidence, correct?
Yes, sir.
And you didn't want anyone from 911 there, correct?
Yeah, I did, but I didn't make the effort to call.
Because when you were in the back of in the parking lot, you knew Solomon Smith had been shot, correct?
No, sir, I didn't know no one was shot.
But you were observing everything, right?
Yes, sir.
Nothing further, Judge.
Ms. Fagan, do you have any redirect?
Yes, Your Honor, just 3 questions. Were you scared of being in trouble that night?
Yes, ma'am.
Is there a difference between your memory and the actual video?
Yes, ma'am. A big difference.
Which is better, your memory or that video?
The video.
Mr. King, do you have any follow-up with Mr. Blige?
Yes. Good morning, sir.
Good morning.
You made some reference to seeing my client during this incident, right?
Yes, sir.
Okay, I just wanted to ask you a few questions about that regarding my client, Xavier. When you were observing the brawl / melee, were you having any conversations with Xavier Head?
No, sir. He was
Okay.
nowhere by me.
All right, what was the last thing you
He
said?
was nowhere by me.
Okay. When you felt as if it was right for you to put your gun in your hand, did you have any discussions with Xavier Head at that point?
No, sir.
Okay. And when obviously we saw it on the video, so you see you walking down and you're next to what you testified was my client. Well, they're kind of on the opposite
Yes,
sides
sir.
of a vehicle. Is
Yes,
that
sir.
right?
Yes, sir.
Okay. And at that point, did you all have any verbal or nonverbal communication with each other regarding what was going on?
No, sir. It was just he's seen. I guess he's seen exactly what I seen, but we never talked to just saying what was finna happen, what was about to happen.
I understand. Nothing further, Judge. Thanks.
Mr. Abate, anything else?
No, Judge.
Any questions from the jurors? Okay. Sarge, there'll be a few cards. Thank you. Mr. Blige, you testified this morning about two shots you fired later in the process when you were over by your car rather than in front with the person who you said is Mr. Head. Did those two bring the total number of shots you fired to 6, or were those two part of the total 4 that you fired? Does that make sense?
Yes, sir. It's just 4 in all. Those are the last 2 shots equal 4.
So your testimony is that when you were down the hill a little ways, initially shooting 2 shots.
2 shots, yes, sir.
Okay. And then later up by your car, 2 more.
Yes, sir. 2.
How many shell casings did you pick up?
It had to be 4
Why do you say it had to be?
because that's how many. I only got the ones that I shot.
What did you do with the shell casings?
We took everything home.
Say that again.
Took everything home.
And what did you do with the shell casings when you got home with the shell casings?
I put everything in the bag at home.
And then what did you do with the bag?
It's just from the last time I remember, it was at home.
Ms. Fagan, any follow-up on that?
Yes, Your Honor, just on the last couple of questions you asked. Mr. Blige, when you were told about the warrant, did you turn yourself in?
Yes, ma'am.
Did you bring anything to the jail when you turned yourself in?
No, ma'am, just my clothes.
And what kind of gun did you have that night?
Glock 9mm.
Okay, and so what kind of caliber was that?
9mm.
Mr. King?
No more questions, Chair.
Mr. Abate?
Mr. Blige, before you turned yourself in, you told Mr. Lewis that you weren't the only shooter, correct?
From what he said, yes, sir.
I'm asking you, do you?
Yeah, I object.
I don't-
This was
Stop.
not- This was not part of within the subject matter of the cross.
Well, not that, generally the follow-up is based on the exchange that I have with the witness. So I guess the objection is sort of outside the scope of this area.
I don't disagree, but my question is in response to the question that Ms. Fagan asked about, did you turn yourself in, which didn't involve any of the questions.
Okay. I think it is connected to a question Ms. Fagan asked, so you can ask it.
Thank you, Judge. Did you tell Will that you weren't the only shooter that night?
I don't recall telling him that. What I recall telling him was he asked me about what I was going to do because the detective been calling him or whatever, and I told him I was going to obtain an attorney.
The bag you talked about with the judge, still at your house?
Yes, sir. Far as I know, as you know, I've been in jail for 7 months. So last place I put it was at home.
Your mom's house, your dad's house?
My mom's house.
And since you've been in jail, have you spoken to your mom?
Numerous of times.
Did you ask her if it's still there?
No, when I talked to my mom about a gun over no jail phone, no, sir.
That's because it was used to kill Solomon Smith, correct?
No, sir, it was not used to kill Solomon Smith.
No further questions, Judge.
All right. Ms. Fagan, do you have other evidence you're going to present in your case in chief?
This time, we rest retired.
Okay, ladies and gentlemen, much like we did when the state rested, we need to take this will be a quicker break than on Friday when you got to go home. But I'm gonna ask you all to go back into the jury room while we cover some things because now another party has rested and then we'll get you back out here. My guess is by 11:30 to see if Mr. King, on behalf of his client, is going to present any evidence. So please go with Sarge. Don't talk about the case yet. No outside research.
Thank you.
All right, Mr. Blige, if you'd work your way back to council table, please. Mr. Head, everyone else can take a seat. Mr. Head, if you don't mind staying standing, only because I can't see you behind the monitor if you're seated. I got to ask you a few questions, if that's all right. And then I'm going to ask Mr. King a few questions. Mr. Head, do you understand that you have the right to testify and that if you wish to testify in this case, no one can prevent you from doing so? Do you understand that in the same way, if you don't want to testify, no one can compel you or force you to testify? Do you understand that if you choose not to testify, I will tell the jury that they should draw no adverse inference about that? They should not hold against you the fact that you did not testify. Do you understand that? Do you understand that in the end, it's going to be your decision whether you testify or not? I'm not going to ask Mr. King, and you're welcome to ask him again. I trust you guys have been talking about it, but it's your decision in the end whether you testify or not. You understand that? Do you understand that if you choose to testify, not only will you get to answer all the questions Mr. King has for you, but you will be subject to cross-examination by one of the prosecutors and in theory, Ms. Fagan as well. And you need to answer all those questions, much like you saw with Mr. Blige. You understand that? Do you have any questions about this issue of testifying? Do you wish to testify in your case, Mr. Head? All right. Well, I find that Mr. Head has made a knowing, informed, and voluntary decision not to testify. I will include in my charge to the jury that they are to draw no adverse conclusions or anything like that from your decision to exercise your right not to testify. Okay. Mr. King, do you have any witnesses you're going to call, or it's limited to the business records?
Just a business record.
Okay. Mr. Rao, anything you want to add in connection with your objection to the admission of the business records from Arrowhead Pond?
Judge, and I apologize if I already said this, but I don't believe that it's probative of anything other than the fact that Mr. Head purchased a .380 firearm manufactured, I believe, by High Point. That's not necessarily probative of anything other than he had that weapon. It doesn't tend to prove or disprove whether or not he was in possession of a make and model similar to what is on the GBI report. And I think that this would be substantially outweighed by the unfair prejudice that would serve if it's admitted into evidence and unfairly confuse the jury as to the issues in this case. The question is not whether or not he owned a .380 caliber firearm that was manufactured by High Point. The question in this particular case is whether or not Mr. Blige or Mr. Head is guilty of the charges. And at no point is there any indication that he's been charged with possession of a firearm, of a .380 firearm manufactured by High Point.
Mr. Rao, I'm not remembering all the specifics of the firearm examiner testimony, but was she able to connect the .380 projectile, which I think was removed from Mr. Smith's leg, with a particular type of firearm, or simply that it was a .380 projectile?
I believe it was initially in the top subset, Judge, and I apologize for not having that information
Memorized?
memorized. But it is my understanding that it was manufactured by Davis Industries or Cobra. So initially what I said earlier, that the projectile was manufactured by one of those two.
Not what, because the projectile could have been manufactured by Ralston Purina. That doesn't, that's not
I
a,
apologize. No, it did not say where the projectile itself.
You guys can jointly answer this question if we get an answer sooner.
The answer, Judge, is that the expert saying that the bullet, the 380 bullet came from a Davis Industries and Cobra firearm.
Not the shell casings, but the bullet. She was able to say because of the markings on the projectile,
Correct.
that it came from a certain family of firearms.
That's correct. And Davis Industries went out of business. Cobra took over Davis Industries, and that's why you have those
The two.
two together. Because oftentimes, like, they still use same magazine and all that kind of stuff.
So it's not just the shell casings, which she testified were all fired. They all came out of the same gun. She didn't say that the bullet, the projectile came from the shell casings, but she did say that the projectile appears to have been fired from Davis/Cobra.
The second thing is correct, and I think the first thing is also correct. Well, not obviously, I'll stick to the second part, which is the answer to your question regarding the firearm and the bullet.
Okay. Tell me, Mr. Rao, what you think you would have been able to do with more time with this information.
I'm going to leave that with Mr. Abadi.
Okay. State, tell me what you would have done if you had received this. Let's say as you handed Mr. King the draft version of the firearms report, he handed you this. He said, interesting, Davis Industries, here's High Point.
Your Honor, I would have been able to do an E-trace with ATF as it pertains to the serial number on the firearm that was provided on Saturday. I've attempted to do that, but it's not a quick process. It takes a couple of days, a week is what I've been advised. I also would have requested the firearm from Mr. King, where I would have done a notice to inspect the firearm if the firearm is still available, as this defense can do with the state to determine if that firearm was actually fired that night, if he still has the gun.
Okay. I didn't get the sense that this business record suggested Mr. Head still had the gun or that mom did or anything like that.
But I think that's the argument. If you put this in, Mr. King is very smart. I think he's going to make the argument he still has this gun. And because this gun is a High Point and there is no evidence a High Point was fired on July 12th of 2019, my client wasn't fired. I think that's what potentially could be his argument. And had I been on notice, I would have been able to determine if he still had the firearm, if it had been sold or to another pawn shop or a business like the one he purchased it from. I would have been able to look through databases with APD and other counties throughout the metro area to determine if it was recovered by any of those agencies. But I got it at 5 o'clock on Saturday and nobody was available Sunday. And we've been attempting to speak with the GBI, Ms. Catherine Jordan, to determine what she could say, but I haven't had an opportunity to actually speak with her.
All right. Mr. King, anything more you want to add?
Judge, I think that, not really, Judge, I just want to stand on what I said before. I do believe this is, proper rebuttal evidence that the relevance of it did not come to light until Friday. And I've been working on it immediately and to provide to the court and the state. And it's just like Mr. Abate said that, he doesn't, he knows what my argument would be. I know what their argument would be. And their argument is that he had a 380. And because all this is circumstantial, but it's circumstantial on both sides. Because their argument is he had a 380 and his family got rid of a 380, and 380 was used to shoot the alleged, the victim in his case in the leg. Therefore, that's a connection of the dots. And so it's the same argument on the other side. He had a 380, but it wasn't. And it's all argument, and it's all based on circumstances because, of course, we don't have a gun. But at the same time, regarding that point, the state has an opportunity to do what it was doing that type of search prior to this. Just like the court asked me whether or not I had the opportunity to research his gun ownership, the state had the opportunity to research the gun ownership. It doesn't bother me that he's saying that time-wise, but it's the same argument on my side that this stuff comes sometimes at the last minute. And there is always an element of prejudice, whether it's 5 days before, 1 day before, on a 2.5-year-old case. But the same thing that they're arguing is the same issues that I've been having, that I brought attention to the court. And even in July, when we had a conversation about discovery, I said to the court, there seems to be things missing here. And Mr. Rao, he gave me everything he had at the time. But then 5 days before trial, we get certain things, including the supplement that spoke about a little while ago. That supplement, we didn't get that. And it's kind of filled in some dots on why we're even here. So the point being is that all of this has happened like this. And I wish I'd had it earlier. I wish I would have known to get it earlier, but I didn't. And that's why I let everybody know what I was trying to do on Friday, just to put folks on notice. But I didn't, and that's where we are.
Okay. So my understanding of the discovery is that from the initial production of the detective's full report, everyone involved would have known that there were at least 2 firearms, because independent of the GBI, don't need them. There's the crime scene diagram prepared by Detective Bacon that refers to 380 shell casings and 45 caliber shell casings. So for years, everyone involved has known there were at least 2 guns fired. The GBI report confirmed that from an expert perspective, but the expert work that was done that really required someone with a GBI expert's training was to identify that the 45s were all fired by just one gun, and that the 380s were all fired by just one gun, so that universe of shell casings is limited to only 2 guns and not maybe 8 guns, because everyone fired their gun one time. There are all these shell casings around. It provided a possible make or model of a firearm for the 380 projectile, maybe for the 45, I don't remember, but that's not what's at issue here. Really, the only thing that was last second is Ms. Drain testifying that Mr. Head had a 380. Her testimony that he had a gun and that she was going to get rid of it, or Mr. Holly was going to get rid of it, or Mr. Head's mom was going to get rid of it, or maybe Mr. Head's father through Mr. Holly. That was all stuff that was known or knowable to all the parties because of the jail calls, which had been provided further in advance than the GBI results. So I'm not going to allow this to come in. I find that number one, Mr. Head in particular has known since March of 2017 that he had a 380, and he shares what he chooses to share with his lawyer, but the lawyer with the best ability to learn about what kind of gun or guns Mr. Head had would be Mr. King. And I appreciate that in his mind, it really didn't crystallize until Ms. Drain testified. But I think that she was putting more of a punctuation mark on the end of a sentence that says there's evidence to suggest that one of the two alleged shooters had a 380, and that could well be Mr. Head. But I find that the prejudice to the state in being unable either to have a firearms expert come in here to say, you know what, High Point Davis Industries, that's like two different models of an Oldsmobile. It's the same engine, everything. We didn't list High Point, or possibly to Mr. King's perspective, a High Point. I would never in 1,000 years confuse a High Point with a Davis Industries. They are so different. We're left in the dark on that. So for that reason, I'm going to exclude it. If you want a stipulation, Mr. King, that your client lawfully purchased a 380 in March of 2017, would hope the state would go along with that. I know that's not the biggest point you were trying to make from this, but if that was part of it, I think that that doesn't get into the same area of undercutting some of the impact of the GBI testimony in a way that the state couldn't meaningfully rebut it. Because you keep referring to this as rebuttal. It serves to contradict something the state has said, but this isn't your rebuttal case. This is your case in chief. And for your case in chief, the things you're going to use ought to have been provided in a timely way. Rebuttal evidence, the standards are a little looser, and the calculus that the court engages in assessing prejudice and whatnot is a little different. So while literally this may rebut something in the state's case, it is not, in fact, rebuttal evidence. It would be evidence in your case in chief. I've made the ruling. You've made a very good record as to why it ought to come in, and you had timely objected to the lateness of the state's production of the GBI information. So I think you have made the record you ought to. Should this be an issue, should there be an appeal? But I want to make sure if there's anything else you want to add for the record, you do that now, Mr. King.
Judge, yes. The fact that the report was created late and served late puts us in the situation because it's not crucial until the report comes. And I respect everything that you, always respect what you say, but respect everything you say specifically about the fact that there was 380, known 380, or known 45. But the thing is, it's their burden to create this picture so we can defend. And so basically you're just saying that, and maybe you're right about, as a defense lawyer, I should think of every hypothetical and every possibility. Because that's what it sounds like.
Now you're not respecting me.
Well, no, but isn't that what you said?
No, I don't think you should think of every hypothetical. But I've heard you say something different, because if the triggering event for you in thinking, hey, I need to get these business records was getting the GBI report, either draft or final, you've demonstrated that you were able to get from Mr. Majid within 24 to 36 hours what you needed. You didn't try to get that when you got the draft report. You didn't try to get it when you got the final report. But what you were just saying now is, well, wait a minute, the thing that crystallized all this was the GBI report. And had you told me, you know what, it could have been ex parte. I'm trying to track down this evidence, but I only got the GBI report now, and it's going to take 3 days. We would have had a different conversation. But that's not what I heard you say. No,
well, I agree. It's not crystallization. That's what started the whole thing in motion. So if I misspoke with, if that was the only thing, it was the series of waves from that point. Okay, so I apologize for saying it only crystallized, because that's not what I meant. But that is when this thing started, ending with the testimony of Ms. Dre. And I understand you made your ruling, but I just wanted to
Okay.
make sure you understood.
No, I do, and I respect it. Thank you.
Thank you, Judge.
All right. Given my ruling, when the jurors come back out, is your announcement going to be that Mr. Head rests?
Yes, sir.
Do you have any rebuttal evidence, Mr. Abate?
No, Judge.
Okay, then we will have rested all the way around. I think what we'll do is give the jurors an early lunch. They'll come out here and we'll have you rest. We will tighten up the final charge because a few things have happened, like Mr. Blige testified. And so there'll be some things that I thought maybe didn't need to go in that should stay in. And there may still be a few things we pull out we remove from the final charge. And then we will take our lunch break. But when the jurors come back, we'll start with closing arguments. Does that work? Excuse me, for you, Mr. Abate?
Yes, sir.
Mr. King?
Yes, sir.
And Ms. Fagan?
Yes, Your Honor. My one request is that if we do expect that we're going past 5, to allow the jury enough time to make arrangements for childcare if we are going, or.
So I'm hoping that not all 3 parties think they need 2 hours for closing in this case. You get the time you need to think about whether the jury wants 6 hours of closing in the case, but you guys will do what you need to do. Maybe you can give me an estimate, ballparkish, as to how long you think your closings will be when we come back from the lunch break before we bring the jury in. It would be best if we could do all the closings today. And if the math is such that we have to go past 5, I'll let the jurors know that. If that's not the math, meaning we don't have to push more than 5:15, then we can finish closings today and they can come back tomorrow, although we may be down to 13 jurors for tomorrow. We have to discuss that with them as well. And they can start their deliberations tomorrow morning. So I hear you on that. I just need to know better how long you think your closings will be. Mr. Abate, will the state be opening and closing or just closing?
Opening and closing, Judge.
Okay. Then let's bring the jury back in. We'll have Mr. King get on the record that Mr. Head rests. I'll tell them it's lunchtime. We'll take a little time to finish the charge. And then you guys can have a lunch break / prep session and be thinking about whether you want that monitor, if you're going to be using PowerPoints, moved out into the middle so that the jurors are looking straight at it rather than some of these jurors across everyone else. And we can try to do that, find a space where it could be. And it may be that for that some of you will be able to see it on a screen, but it may be that a lawyer or 2 want to be over to the side. But I think that will be more helpful for the jury if we move that screen. But we can talk about that. All right, Mr. Abate, does that plan work for you?
Yes, sir.
Mr. King and Ms. Fagan?
Yes, sir.
All right, let's bring the jury in, please.
prosecutor is present, Your Honor.
Thank you, Sergeant. Welcome back, ladies and gentlemen. You all can be seated. Mr. King, are you going to be presenting any evidence on behalf of Mr. Head?
No, Your Honor, the defense rests.
Mr. Abate, any rebuttal from the state?
No, Your Honor.
All right, ladies and gentlemen, the evidence in the case of State versus Blige and Head is now closed. You've heard the testimony and received the exhibits that will make up the universe of evidence that you'll be considering when you begin your deliberations. There are only 2 steps left before you start your deliberations. One is to hear the closing arguments of the lawyers. And then 2 is to receive from me the law that you must apply to the facts as you find them to be. What I'm going to do to allow the lawyers a chance to just get situated and ready for their summations, their closing arguments, is have you go to your lunch break now. And then when you get back, we'll be ready to start with closing arguments. Because the state has the burden of proof, the state has the ability to open and close within closing. So one of the prosecutors will get up first and share with you some things, then sit down. And then if Ms. Fagan and Mr. King want to give closings, and again, no burden on the defendants, they don't have to say anything, but I bet you'll hear from them. They will share with you their thoughts about what the state has shown or failed to show, what the evidence shows or it doesn't. And then finally, the state will get that last word, sort of the rebuttal, if you will, to the defense closings. Then I'll give you the law. We'll see what time it is, and we will go from there. But I'm going to ask you all to take your lunch break now. You think you could be back by 12:45, or is that going to leave people with heartburn and indigestion? I'm happy to say 12:50, but anyone not be able to make it back by 12:45? Let's do that. Please, even though the evidence is closed, it is not yet time to begin your discussions or deliberations. You haven't heard the closing arguments. You don't have the law yet to know on what framework you try to hang the facts to see what is the state proven or not proven beyond a reasonable doubt. So enjoy your lunch break. Nice day out there. We'll see you at 12:45. Thank you so much.
All right, so you're. Sir.
Thank you.
Thank you, Sarge. All right, you all can be seated. If you would get your charge out. I'm going to jump straight to it so we can get you to your lunch break / closing preparation. One thing we had left on hold was whether to include the charge on accomplice corroboration. I think, Mr. King, having heard Mr. Blige's testimony, that is an appropriate charge to give. Do you still want it in?
Yes, Judge.
Ms. Fagan, any concern about having accomplice corroboration in?
I didn't ask for it, Your Honor,
I know,
but.
but okay.
No.
Mr. Abate? All right, let me unhighlight it. It will be in. I will include defendant's choice not to testify. We've got a split decision in this trial. So the next one, statement by one defendant at joint trial. It refers to out-of-court statement made by a defendant. And I don't think we had out-of-court statement because it's about freely and voluntarily made. That typically applies to defendant A sits for a custodial interrogation and says some things, and it's used maybe just against defendant A, maybe against more than that. That's not this case. We don't have an out-of-court statement made where the jury needs to think about whether it was freely and voluntarily made, in particular because the only statement I'm aware of we actually didn't get into because of the concerns that Ms. Fagan had and then ultimately I had. So I think that's confusing / not applicable. I don't know who asked for it.
I did, Your Honor, and my purpose of asking for was in preparation for those jail calls from Mr. Head, and his statements regarding the gun and his actions. I wanted the jury to have an instruction that wasn't involving Mr. Blige.
Okay, so. All right, did you also ask for the limiting instruction?
Yes, Your Honor.
And tell me why what evidence you think has been admitted for a limited purpose?
Well, it never came out. I thought there was gonna be 404B issues.
Okay, all right. I don't think I'm gonna give either of those, the statement by one defendant, or the limiting instruction. Mr. King, any objection to that?
No, Judge.
Mr. Abate?
No, Your Honor.
All right, but you are asking that I give the statement by one defendant, not the limiting instruction.
Correct.
Okay.
And I prepared my closing, not including these things.
Okay. Good choice. That's it. I fleshed out the justifications to put aggravated assault as the forcible felony. And it no longer says, where did it go? On justification, it is justified if he believes that the use of force is necessary to prevent, now it simply says death or serious bodily injury to himself or a third person. It used to say herself as well, but we are dealing only with male defendants here. So that's it. Oh, wait, we have more. Yes, ma'am. I was gonna get to no duty to retreat. That's the next one I had flagged.
But real quick, though, you're still saying 2A and 2B?
Yes, ma'am.
Okay.
Yep. Death or serious bodily injury to himself or a third person, or the commission of a forcible felony. And then I go on to say aggravated assault is a forcible felony. So yes, they're both in there. All right. No duty to retreat. I don't remember, was that one you had requested, Ms. Fagan?
Yes, Your Honor.
Tell me how it applies here.
Well, I think that the theory of the state's case, I feel that the theory of our case is that the actual aggressor in this situation was first Helen, who then transferred to Javante.
Mhm.
And that ultimately, Mr. Blige was not an aggressor, and that his justification argument of defense of third parties covers the no duty to retreat.
So that's usually given when the evidence shows, like the classic one is you're on your front porch and someone's walking up. You don't have to back off. You can just say, I'm going to shoot you if you come any closer. This fact pattern doesn't seem to fit in the retreat situation. I didn't hear Mr. Blige say anything about, he was particularly worried about himself. He's defending others, and he also is trying to prevent the commission of a forcible felony. And so the whole concept of retreating doesn't seem to fit in your theory of the case, but tell me what I'm missing.
Well, I prepared my closing to not have either of these after our discussion on Friday.
Okay.
So I'm okay to withdraw the no duty to retreat.
Okay.
That's where we left it.
Got it. Mr. King, you all right with removing no duty to retreat?
Yes.
Mr. Abate?
Yes, Your Honor.
All right. Then the last one is threats justifying a homicide. And as I was listening to Mr. Blige's testimony, I looked at this and I think that it is an appropriate charge and it should stay in there because Mr. Blige was referring to the menacing action of, it's the alleged victim, but that was in a sense, the alleged victim of what Mr. Blige was trying to do. He made real clear he was trying to neutralize the threats posed by Mr. Rivers. Mr. Rivers didn't get hit, but I think that it is an appropriate charge.
And Your Honor, as far as the parentheticals, is there a specific parenthetical that you're using so that I can include that?
Yeah, I'm addressing that now. I think it would be all three.
I agree.
So they will all three be in there. No parentheticals, just that text. Mr. King, any objection to keeping that in?
No, Judge.
Mr. Abate? All right, it's in. I'll prepare a verdict form, 2 verdict forms, one for each defendant for you all to review. It's gonna be pretty plain, but I'll get that out for when we reconvene. All right, so I think that's the charge. I will bring you a hard copy of the final charge for each attorney when we regroup. Mr. Abate, anything else before we break for lunch?
Just briefly, Judge, this statement at this point after Mr. Blige's testimony, it wasn't relevant to ask for transferred intent. I think based on what Mr. Blige testified to, I think the transferred intent pattern charge would be appropriate, as well as a charge on transfer justification as well, based on Mr. Blige's testimony. So I will submit that for the record, but in file, I just wanted to switch you now.
Okay. I think that's correct. I had to look up early on in the trial transfer justification after I heard Ms. Fagan's opening, and I think that that's an appropriate charge to give. And I think transferred intent sort of goes hand in hand with that. Ms. Fagan, I need to get the language in front of all of you, but do you agree that both those charges ought to be added?
Yes, Your
Mr. King?
Judge, I had to read the language, but sounds like that's probably appropriate, but I haven't read it.
So, and I've never read transferred justification. I'll need to see what the language is, but the gist of it is if you are justified in using deadly force on person X, and as a result, you inadvertently, that deadly force is applied to person Y, who was not the threat, that justification protects you, if you will. It's still justified. It's not suddenly murder because you had bad aim or someone jumped in front of the person who you reasonably perceive to be the threat. So it's just like transferred intent can work to a defendant's disadvantage. Transferred justification carries that principle, and it would say you were justified in using the force, and as long as it wasn't reckless, the fact that someone else ended up receiving that force, you were still justified in doing it.
Yes.
It'll sound better than that, but that's what it says.
No, I totally understand. It sounds like that's probably appropriate.
Okay.
Judge, would it be okay for me to email you, Fagan, Mr. King, proposed language? I had to deal with this issue.
It'd be very helpful. There's not a pattern for transfer justification. We just found the cases that talk about it. So that would be great. And I will work on those two, weaving those in while you guys are getting ready for your closings. And again, I leave it up to you all, but if you want to agree on a place to put the big screen for your closings, go for it. It is movable. All right, I will come back out a little before, maybe like 12:40, make sure everyone's doing okay. Thank you.
And where did we? He said, I got
Honor. Tell me, because either he gets, because you can put it in front of them, and you're like, it's not gonna happen, you know?
Right.
There may be a way, I don't know. Well, I'll let you guys navigate that. Step back. Don't worry about me. I got it right here.
Okay, and then.
Well, if you have the big screen over here and you share it, you should, then everyone should get it.
Why not? I never.
Oh, really?
Right, all right. You went on the window.
Yeah.
But he's not like this.
Let me just add 2 nuggets to your discussion. One, I don't care if you block me. They don't need to see me. And I don't mind if Mr. Blige sits in a slightly different place during closings so that he can see the jurors and they can see him. No defendants should be blocked by the big screen. The lawyers, they can look at it on another screen, but the defendants should have clear line of sight to the jury. Don't worry about me.
Do you want us to move it?
If you know it's going to be moved, I'll send IT down here to assist. Is it going to be moved?
Yeah, I think. maybe it's-
Okay, let me send someone down.
Crazy. Oh, you're crazy. No way. I don't
Hey,
know.
come here for a second. I gotta ask you a quick question.
How long are you doing?
Sure.
Hmm?
As long as you hit the points, I'll just follow it. No, I mean, 20 minutes.
Yeah, we could have. We. Get some of the. Yeah, no. Okay, so-
I was that dinner.
I know, I the bottle pages, I love bottle pages.
What'd you do?
What?
Also, the jury.
Oh, I didn't want to-
Okay.
Yeah, that
Are
hurt.
you good with
Yeah.
that?
What's that?
The big question.
Strength?
That was my soul. Yeah, that was my soul. That really did hurt me. I didn't want to ask him anything. But I had to ask him something.
No, I know. Here's. Ask.
It's not fair. It's not.
So if I use an hour and say an hour, I mean, you're kind of longer than you others, just saying. I'm
Well,
just saying your guesstimates are not very good.
No.
How long are you?
5 minutes, right? I said I would.
I'm good with my guesstimates. I'm thinking I'm 45, maybe an hour tops. I got 64 slots.
I'm an hour 25.
Are you?
Well, I mean, unfortunately, I have the burden.
So two
Yeah,
and
he
a
has
half-
the burden.
so that puts us-
He gotta talk about stuff that we don't have to talk.
I don't think that's the issue.
Well.
I think he's long-winded.
No one's ever said that to me, actually.
Really?
You can't be long-winded when you're in Ellerby and Adams.
Yeah.
She like gets to the point.
I'm gonna go back over that. 12:45.
Yeah.
So whoever stole the candies out from my house yesterday stole my bucket too.
You're gonna get up there.
We can leave some of our stuff.
Dude, you
Okay.
leave stuff on you.
Appreciate it. Thank you.
Courtroom floor. I don't know.
Okay.
I'm gonna stay up there.
Sounds good. Appreciate it.
No, You staying around?
Yeah, I stay around,
'Cause I was thinking about just going to get some crackers and then coming back.
because most of the time, I don't take them back down. 'Cause,
Okay,
you know,
well, I'm just gonna come and I'll be back up in 5 minutes. I'm not.
yeah, when they say an hour, they only talking about an hour. Then
Right. I'll be back in a few.
that's all. I'll let you-
Yeah. I wouldn't be too, from the deputy that has to come in here and, constantly have to just the lunch. So why should I oblige you with in rotation? I'm saying, that's how I fix that. Because my thing is, you got somebody sign. You check it out first. They got me in here, they like 30 minutes in there. But he said this stuff for me. Yeah, then you gonna do it wrong. I mean, I guess that's just power, so they can do. But I don't see the power strip out here that will accommodate both of those bugs. So, and if we ain't taking them down, we gotta say, well, you know what I'm saying, not both. What you gonna do for us?
I'm gonna sit in there.
You brought something? No, bro. I ain't bringing nothing. So I'm gonna go grab something.
I ain't burning much, but I promise.
Yeah, it's a Chick-fil-A over there. I think I got, I should be able to pull what they got. I just want it to be able to go and, you know what I'm saying, eat. Yeah. Judging by how roll call look. You know, telling how. Uh, 12:45.
Okay. Hey. If the king said he wanna come back. Yeah. Okay.
Hey, can you, put that, I forgot where it is.
Huh?
Yes.
Huh? No. No, I don't.
Yes, to.
Okay, we'll give him a call. I'll be out in a sec. Thanks.
Yes, sir. Williamson and Palmer's gonna come up. 3-2-13. So far,
Like, no, IT people. With the monitor. Okay. You're welcome.
Seems that they have power.
Oh, is the problem power?
Yeah, because this is our feed here.
Oh, that's not, I thought this was a power cable. This is the signal? Okay.
So it shouldn't be an issue.
Well, but we've got, if they're moving over here, which I think is the plan. Assuming that plug works. Okay.
Gotcha. Jonathan wanted to plastic too.
Usually a charter. Check.
All right now.
Oh, no, I've been using it, I'm saying.
So Sarge, if we could bring the defendants out, we got a couple things we can get on the record, and I'm told IT people are working their way down here to move that. Thanks.
No, appreciate it. I think I'm good. Appreciate you.
Oh, hey, how are you?
I'm doing well.
I'm gonna let the lawyers tell you. I think it's coming towards me. So we may need to plug it in. I think data we're good. Power wise, it may need to plug into the jury box. There's that plug right there. I don't know, Mr. Abate, Ms. Fagan, Mr. King, who's in a good position to let us know where the screen's supposed to go.
I think we were in a chatty corner, right in front of the judge in this little corner, right? Like right here, what we had discussed.
Yeah, it's fine if you need to shut it down to move it, whatever you need to do.
Remove this device.
Yeah. That's gallery. Oh, one of your colleagues set up a special connection to the podium. So to make a better feed for a bunch of video that was being played. So I just removed gallery, but I don't know what effect that'll have on that machine. You want me to remove podium too? Okay. All right. Well, let's get on the record, if we could, please, to close out the jury charge. If you all the lawyers who are here in court, their clients are here in court, you have in front of you the final version of the jury charge. And if you will turn to page 8, you will see a charge on transferred intent. That's more or less pattern language. I massage it so it is a little less stilted, but if you all would read that, please. Mr. Abate, any objection to the transferred intent language?
There you are.
Mr. King?
Okay.
Ms. Fagan? Corresponding on page 15 in the middle is transferred justification. Please read that. Mr. Abate, any objection to transferred justification?
There you are.
Mr. King?
No, Your Honor.
Ms. Fagan?
Yeah.
All right, you've got the final charge. Just a note, when it is time to charge the jury, I will read to them what you've got in front of you. It will also be displayed on this big screen and your screens as well in a PowerPoint where it's sort of it's broken up into more bite-sized chunks, but some jurors follow better if they can read it while it's being read to them. And then they will get the actual charge I'm reading. That hard copy will go back with them for their deliberations. Mr. Abate, how long do you envision your closing running, roughly?
No longer. I was in more than an hour, 20 minutes.
Okay, and that's both pieces combined?
Yes, Judge, and I know my time estimation is always not great, but that's
You're not aiming to use the full 2 hours? Okay. Mr. King?
Probably about 20 minutes.
All right, Ms. Fagan?
Probably an hour.
All right. I think we can fit it all in before we end for the day. That'll be our goal, but we will take stock of things. As we get partway through. If you need to move that air purifier thing, which looks sort of like a garbage can by your leg, you're welcome to move that. I don't know if that's obstructing anything. Did any of you get in the jury box to see if that helps or? If you're at the very end, so Mr. Wynn and one other guy tend to sit there. Can they see it?
They can see it, but it's difficult.
So why don't we rotate it a little bit towards them, because we're not using the witness stand. Just don't break anything. Both the IT guys are watching. Yep, good. Let's try that. That's better. Now, more importantly, is it on?
Yes.
And does it show? What's it showing? I removed gallery because you guys were going to move it, and then I had forgotten gallery was pushing through podium. Do I need to reconnect gallery, or it's just basically a puppet to whatever's on podium?
Well, this is on the second input, based on them showing evidence.
Yeah.
So you want back into the regular Zoom room?
No, I think they may be playing things in their closings. So if what they're doing, if they're sharing their screen through some device that's on here, it'll come across that. Okay, I think we're good. Thanks for coming down, guys. All right, Mr. Abate, you ready for the jurors? Mr. King?
Yes, sir.
And Ms. Fagan. All right, let's bring them in, please.
Sure.
Thank you. Ladies and gentlemen, you can be seated. Jurors, you can't see me so much, but I'm not real important at this point. We've moved the monitor so that you can see it better during the attorney's closing arguments. In a moment, Mr. Abate is going to give you the first part of the state's closing. I will remind you something that I told you in my opening remarks and that I'll repeat when I give you the final charge. Nothing that you're about to hear from any of the lawyers is evidence. It is their view of what the evidence has shown or failed to show. You decide what the facts are. These lawyers are free to try to persuade you, but it's what witnesses said and the exhibits that are admitted that make up the universe of evidence, and not what the lawyers tell you the witnesses said or things like that. So feel free to be persuaded, but know that you are the fact finders, not the lawyers. And with that, Mr. Abate.
Thank you, Judge. Members of the jury, those two defendants on July 12th, 2019, put Solomon Smith down. That's what the facts and the evidence have shown over the last week. With one victim, two gunmen, and a barrage of shots. Now, before we get into the facts and the evidence, I'm going to tell you a little bit about the not so exciting part, a little bit about the law and the framework that the judge is going to instruct you at the end of this trial, and the principles you're to use as you are sifting through all the facts and the evidence that you've heard over the course of this trial. And one of the things the judge is going to tell you is that the state has the burden of proof, and our burden is beyond a reasonable doubt. And that's important. It's not proof beyond all doubt. It's not proof to a mathematical certainty. It's not a vague or arbitrary doubt. It's exactly what it sounds like. It's a reasonable doubt. The doubt of a fair-minded, impartial juror, honestly seeking the truth. Your duty is to seek the truth. It's not to seek doubt. Your duty is to weigh the evidence, weigh all the facts, apply the law, and determine if the state has met its burden. If we have proven every count in the indictment beyond a reasonable doubt. And ladies and gentlemen, in the last week, the state has done that. Now, you may have noticed the state took some detours, things out of order, like members of the jury that witnesses have realized as well. And because of that, things have to be adjusted. Because what's important, what matters is that you hear all the evidence so you can make an informed decision at the end of the case. Technology has not been my friend over the last week. Let's see if we can get it working. But here you look at a picture, and in your head, I know all of you guys are saying, I know what that is. And it looks silly, it looks ridiculous, but the point is there any reasonable doubt in any of your minds that that's the Statue of Liberty, even though your hand's covered? That, ladies and gentlemen, is what reasonable doubt is. The judge is going to instruct you that you have a duty to follow the law that he's going to read to you. And you apply that law to the facts and the evidence. And he's going to tell you that there's two types of evidence: direct and circumstantial evidence. Now, direct evidence is evidence that points immediately to the question at issue. Here we have direct evidence. You've seen a video, any video, ad nauseam. I know that. And the reason we all showed it to you so many times is because it's so important. It captures what happens on that day. It's not like memories. It's not like people when they testify. It's frozen in time. It can't be changed. So as we waited through the COVID emergency, as we're coming out of it, people's memories are always going to fade. I can't remember what I did yesterday. But we were able to preserve the video for you to see, and that's direct evidence. You're also going to hear about circumstantial evidence. And circumstantial evidence is proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. Ladies and gentlemen, think about why Tyree Blige and members of his friend group were picking up shell casing. He told you, didn't it? Think about why. Why do you pick up shell casings if you're acting in self-defense or defense of others? Why do you do it? The reason you do it is because you are trying to conceal evidence that proves you're guilty, that you didn't act in self-defense. In fact, you did the exact opposite. Now, an easy way to kind of illustrate circumstantial evidence is something we do, once a week. Some people may be lucky enough to do it twice a month. Go into the gas station. Now, I'm superstitious. I always go to pump number 5. I'll wait until I can get to it, and I'll park. I'll open the door to my gas tank, unscrew the nozzle, slide my credit card in, begrudgingly. It just keeps going up and up. It'll accept it, thank God. And then I'll be able to pick the gas. I'll take the hose, put it in the nozzle, and I'm not someone who holds it. I'll let it automatically do it for me, and I'll sit in my car, and I hear a click. But before I hear the click, I can hear the gas coming through the tube. I can smell it. But ladies and gentlemen, I can't see it. I don't know that it's actually gas going into my car, but my experiences, my common sense tell me that what's being pumped in my car is gas. I hear the click, I pull out the knob, the hose, hang it up, start my car, and I go from E to full. Now, there's circumstantial evidence, smelling the gas, hearing it pump, hearing the click when it's full, and then starting my car. All circumstantial evidence that gas went into my vehicle. Now, is it possible that while I wasn't looking, someone from the sky, an alien came down and filled it up with whatever they fill it up with and started? I guess it's possible, but it's not reasonable. Our common sense and our experiences tell us from the circumstantial evidence that we're going to be able to drive away. Now, what is the evidence? In this case, it's witnesses, the testimony. You, ladies and gentlemen, of the jury are going to be able to weigh their credibility. You decide their credibility, not me, not defense counsel, not your own, you guys. And you're going to weigh their credibility with the other parts of the evidence, the exhibits, the videos, the photos, any documents, expert reports, things of that nature. And when you're weighing the credibility of a witness, you'll look at the manner in which they testify, their interest or lack of interest, their means and opportunity of knowing the facts that they were able to tell you about. The probability or improbability of what they told you is possible. It is for you to determine the credibility of each and every witness that sat at that stand. And I know it's a difficult job and it's a difficult thing to do. There are many people who got there and didn't tell you the truth. Many people, they had to be impeached with prior statements. They flat out dug their heels in. That's all stuff for you to weigh. That's all stuff for you to look at. That's all stuff for you to weigh and measure when looking at the video. Now, the judge is going to tell you that the testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. And I want to bring your attention to one witness. It's Helen Abraham. I remember, and I hope you guys do. Throughout this trial, she is the one witness who got up there and was authentic. She was true to herself and she was true to you. And I say that because when I asked her the question, when you're knocking on that window, what are you saying? And she said a nice thing, something like that. And I said, well, what did you say? And she turns to the judge and she says, can I say it? It's, you know, full of, you know, cuss words and expletives. But she wanted you to know everything that she experienced that night. She wanted you to know everything that she remembered from that night. And there's a reason why she remembered it all, because it was a traumatic event. But she didn't hide from her actions that night. She told you why she did what she did. She told you she was scared. She was scared because a man much larger than her punched her in the face and attacked her friend. And that's all on video. And that's why she got that firearm. She was acting in self-defense. But she showed common sense. She showed reason as to what she did with that firearm. She showed control, ladies and gentlemen. She used force necessary to make sure that she stayed alive and that she stayed safe. That's what she did. That's not what these defendants did. There's a big difference between what Helen did and what those two people sitting at those two tables did. Why continuing with technical difficulty, why the computer was shut down. There are many legal principles you're going to hear from the judge as we move forward. And one of those legal principles is going to be about intent. And the judge is going to tell us, or to tell you guys, that the state has to prove intent when proving every element of every part of each charge in the indictment. And what the judge is going to tell you, it's not the intent to violate the law. It's the intent to do the action that led to the crime. It's the intent to hold a firearm and shoot it over and over and over again into a crowd of people in a public parking lot, just as a club was closing. The judge is also going to instruct you as to each one of the charges that the state has to prove. And before instructing you about the charges, the college,
You guys are equally matched.
lucky us.
Oh.
The judge is going to instruct you about a principle called parties to a crime. And what the judge is going to tell you is that you're to consider the actions of all before, during, and after the crimes that were charged. Yeah. And that's important. Because what you're to consider before is that you see Xavier had remained in his vehicle. You see Tyree Blige hide or hanging out in front of his vehicle where he gets a gun. He gets a gun prior to everything unfolding. And he waits. And he waits. And you're gonna see, you saw it on the video, Xavier Head move his car and get out. And when he does, you will see Tyree Blige kind of leaning forward. And he moves forward. And then they get out of the vehicle, he gets out of the vehicle, and they walk in concert. They walk side by side, both with firearms in their hand. And continue to wait and wait and wait until they both begin firing at the exact same time. And the video is clear. Javonte Rivers is nowhere near where they're at. Javonte Rivers is behind the orange vehicle. And you see Solomon Smith run, and you see Solomon Smith go down. And after Solomon Smith goes down, you see Javonte Rivers fire 3 shots into the air. Now the judge is going to tell you that to be a party to a crime, you can directly commit it. You can intentionally help, advise, encourage, hire counsel, or procure another, or cause someone else to commit a crime. And a good example that everybody uses, or we use to talk about party to a crime, is with a bank robbery. So you've got a driver, you've got someone who's holding up the cashier, and you've got someone who's waiting at the door being looked at. And while getting the money or holding the cashier up, the security guard comes in and busts it up. And the guy that's lookout, he shoots the security guard. So the guy getting the money, grabs the bag, and they all take off. And the getaway driver is waiting, get into the car, and they're caught, down the road. They are all guilty of pulling the trigger because they were all party to the crime, the bank robbery, that led to the murder of the security guard. So the first count that you're going to hear about is murder. And murder is the unlawful killing with malice aforethought. The malice can either be expressed or implied. Here, Solomon Smith's death was caused because those 2 defendants opened fire on him and his group of friends. Now, malice is not ill will or hatred. It's the unlawful intention to kill without justification, excuse, or mitigation. And premeditation under the laws of Georgia is not required. There's no particular length of time required for malice to be generated. It can happen in an instant. Proof of motive is not required. Evidence of motive may be admitted to establish the defendant's state of mind, but the state is under no obligation to prove motive. But we have motive here. The motive is William Lewis. Mr. Lewis told Detective Berry that when he comes into Atlanta, he's got to be with people who are strapped, which corroborates why everybody said he's the one who said, get the strap. He told you the truth. He didn't want to. He said, sounds like something I said. Makes sense. Felony murder. No proof of malice is required. No express malice, no implied malice. No intent to cause the death is required. Here, all that's required is that you intended to do the act that led to the death of here Solomon Smith. They intended to open fire on a crowd of people that they knew Solomon Smith was in. He was the one who was fighting William Lewis for all the things he had done that evening. For punching all 3 of his friends. They intended to shoot Solomon Smith. There's 2 ballistics that were pulled, or 2 caliber ballistics pulled out of Solomon Smith, a 380 and a 45. You saw 2 people shooting at and in the direction of Solomon Smith. You see those 2 people shooting, and then you see Solomon Smith go down. The state has proven beyond a reasonable doubt that those are the 2 people, 2 shooters who caused the death of Solomon Smith, not Javonte Rivers. Aggravated assault, the assault of the deadly weapon. Here, the judge is going to tell you that as a matter of law, a firearm is a deadly weapon. And to constitute an assault, injury need not be shown, but obviously we have actual injury here. We get 2 gunshot wounds, one to the back flank or lower back, and one to the left shin. And last is possession of a firearm or weapon or commission of felony. It's exactly as it sounds. You have a firearm that's within arm's reach of the person, actually in the person's hand when they're committing a felony. Here, murder, felony murder, and aggravated assault. Now, the judge is also going to talk about the law on self-defense. And this is going to be an important piece, an important part of the law that the judge is going to charge you on. And he's going to charge you that deadly force is justified only if a person reasonably believes that the force is necessary to prevent death or great bodily injury to himself or a third person. The force is justified only if a person reasonably believes that the force is necessary to defend from the imminent use of unlawful force. And that's key here. Because the argument from defense counsel and defendants is the reason they opened fire was because there was an imminent use of unlawful force to their friends. But ladies and gentlemen, that would require for Solomon Smith and Helen Abraham and the rest, Javonta Rivers, to be the aggressors. And the evidence has been clear that they weren't the aggressors. The aggressors were William Lewis. That's the person who started it all. That's the whole reason the events occurred and continued to unravel. Now, the standard for self-defense is a reasonable person. So what you're gonna ask yourself is, would a reasonable person open fire into that parking lot that night? Are those the actions of a reasonable person? That's what you're to determine. We're looking at the standard of self-defense. Now, the judge is also going to talk to you a little bit about excessive force. And the use of excessive or unlawful force while acting in self-defense is not justified. It's not justified if the force used exceeds what is necessary. A defendant can only do what is reasonable and necessary to defend against the victim's use of unlawful force, if any. But I submit to you, ladies and gentlemen of the jury, that there was no unlawful force of the victims in this case. They were reacting, they were defending themselves against William Lewis after he had punched several people that night, after they heard him say, "Get the strap." They reacted. They reacted reasonably. They reacted with reasonable and necessary force, unlike the defendants that night. When force exceeds that needed for self-defense, the law considers the defender the aggressor. So what that means is that the defendants were to say that the victims were the aggressor. The defendants then become the aggressor after the force becomes excessive. Now, I submit that the victims were never the aggressor, that the aggressors were always William Lewis and the rest of his friends. But the force in this case was excessive. Firing as many times as they did into a public parking lot was not reasonable, and it was excessive, and it was unnecessary and it led to the senseless death of Solomon Smith. I'll transfer to intent, the judges want to instruct you in intentionally committing an unlawful act upon another, yet the act harmed an unintended victim. And you heard the testimony of Tyree Blige today, where he indicated that he was intending to shoot Javonte Rivers, and Solomon Smith, as a result of all the gunfire, died. It's not a defense that the defendant did not intend to harm the actual person, here Solomon Smith. But ladies and gentlemen, the person that Xavier Head and Tyree Blige were aiming for was Solomon Smith. You heard Mr. Blige say they had several clear shots to Javonte Rivers, but they weren't taken. And when they decided to take their shots, they did it when Mr. Smith was right in front of them, was running across right in front of them to dive for cover between the vehicles. And they shot him. But Javonte nowhere around them. Now, I'm going to ask you to, while you're listening to arguments of defense counsel, to ask yourself 3 things. Why not report crime on the night that the incident occurred? Why conceal evidence if their actions were justified? And lastly, why have we not heard about this justification, this self-defense of others?
Stop.
No, this was the issue when we took the break. I have the same objection as to the content.
Okay, overruled as it's been presented so far.
The last question I want you to consider is, why have we not heard one word about justification until this trial? We didn't hear anything about self-defense on the jail phone calls with Xavier's head. All we heard about was hiding the gun, concealing more evidence. And we learned today, additional evidence was being concealed, apparently, at Mr. Blige's mom's house. Ask yourself why. Think about that as you're listening to the arguments. And I'll get another opportunity to stand before you and ask you to return the verdict that only speaks the truth. And that's if these defendants are deemed to be unreasonable doubt.
Ms. Fagan?
Good afternoon, everyone. All right. Good afternoon. So first and foremost, I do want to thank everyone for paying such close attention. We have noticed that you guys have been taking notes, and we asked that you guys to take notes in the beginning, because in my opening statement, I said that this was going to be a chain of events. I said that the video you can't hear, and determining what was actually said depends on who testified. Ladies and gentlemen, this case, when we began, I said it was serious. We owned up to the tampering from the beginning. But this case is also a civil case because of those chain of events. Ladies and gentlemen, this isn't a case of poor police work. What the issue is, and what the state just said, is that you should hear all the evidence. But ladies and gentlemen, you know you haven't heard all the evidence, because Detective Berry took that stand and she said she recorded every interview. And instead of just refreshing Will Lewis's recollection, because he wasn't saying what they wanted to hear, they just said, oh, so you don't remember. But when Javonte Rivers didn't remember his interviews, we ended the day short, and I spent time with Javonte Rivers so he could remember everything that was said. And ladies and gentlemen, we don't have the burden as the defense, but the state chose not to show you any of that evidence. That was a choice by them, because they've had you guys sit here for 6 days and you still didn't hear everything. You only heard what they wanted you to see. The burden is not on the defense. Ladies and gentlemen, you know, a lie, when you tell a lie, there's a snowball effect. And you gotta keep telling a lie to keep up with your lie. And that's what happened with Javante Rivers. And that's why we have 6 separate statements. But whether you like Will Lewis or not, he got to understand that he told his truth. Whether you like Tyree or not, good, bad, or ugly, he got to understand that he told his truth. But Jacayla Rivers, Javante Rivers, they took this stand and they told whatever they needed to say. Ladies and gentlemen, the story of them being the aggressors, first and foremost, when you watch that video, Tyree Blige gets his gun when he's hearing commotion, but he stands back and he just watches. When the girl had the gun, he still doesn't approach because in his mind, that wasn't a threat. But when Javante Rivers took that gun, then things got serious. And that's when the chain of events really started. Ladies and gentlemen, Helen Abraham didn't get charged with aggravated assault, putting a gun to the back of William Lewis's head. She didn't get, Javante Rivers wasn't charged with aggravated assault on Quentin Williams. He wasn't charged with, the state didn't even notice that part. When Detective Berry took the stand, she said she didn't see that part of the video when he chased Quentin Williams. And ladies and gentlemen, I'll show you another screenshot so you can see why. And you can see Javante Rivers with his gun to walk. But it doesn't work with their theory. And that's why it wasn't presented to you that way. But it's the facts. And you know, when you ask Tyree Blige on the stand, there's a difference between what he remembers and what he focused in on and what's on the video that he's been watching for 2 years and now he sees a full picture. You know, he can hear commotion, but maybe he didn't see certain areas because he's focused on Javante Rivers. Ladies and gentlemen, those last 2 shots, if you look at the video, there was just active shooting. That was a pop, pop, pop. And that's when you see the muzzle flash on the passenger side with the final pop. There's a difference between facts and feelings. Whether or not you like someone and what the facts of this case have been. Gas station and whether or not gas is being pumped in your car and the Statue of Liberty, that's irrelevant here. The facts is what matter. And you need to be able to drown out those feelings and just apply the facts to the law to seek the truth, because that's all we've asked, is just to seek the truth. Ladies and gentlemen, this case, my client is Tyree Blige. That's who I represent. And I said it was a serious case, and I've also said it's a simple case. And I broke it down ABC 1, 2, 3, because it doesn't get any simpler than that. A, first, applying the law. Intent. Intent is an essential element of any crime and must be proved by the state beyond reasonable doubt. It's as simple as that. There is no presumption against my client. He will not be presumed to have acted with criminal intent, but you may find such intent or absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connecting with the act for which the accused is being prosecuted. Now, I didn't paraphrase the law. I gave you the law straight for what it is. I'm not giving you bullet points because I want you to know the law in full. Ladies and gentlemen, it's important that you see everything because when you don't, it's like a lie by omission. When you hide the facts, when you don't confront the truth, that's what sent Detective Berry on this ride around, because they didn't just be honest with her from the beginning. It wasn't until she got the video that all of a sudden now people want to admit to shooting. If she never got to the video, who knows if they would have ever admitted to shooting. The law, mere association. A jury is not authorized to find a person who was merely associated with other persons involved in the commission of a crime unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. Ladies and gentlemen, there is a lot going on here. The first, William Lewis with his girlfriend, Asia. But in the video, you see, Jacayla stops all that. She gets them all back to Buckhead Law. Solo and Javante don't come running back through until Helen already has that gun. The first is Asia and Will Lewis. Then Solo and Javante get involved. Then they walk away. The second is now Helen and Rhea and one of the keys are punching the window. Okay, that's them getting involved in a situation that wasn't necessary. Asia accidentally hit the car, almost hit the car, but she's also just she just got beat up by her boyfriend. So she's trying to get out of it. And what Helen and them did was too much. And they should have been charged in this case. When they brought a gun to this is when it escalated. That is the aggressor, not Tyree Blige, because he is standing away and just watching. Ladies and gentlemen, mere presence isn't enough either. Being associated with William Lewis, whether you like him or not, is separate from whether or not he's an aggressor. Ladies and gentlemen, he was only there for 30 minutes. He comes after he's been on the road for months. And when he comes, even when he's on the stand, you can tell he's cool, calm. But he's a lone wolf. He is not somebody who's just with his friends. You never see him with his friends in any of the videos. And that gets me also to the point when he's saying he's focusing on Javante. But now having seen the video, now he sees everything else that was going on. Ladies and gentlemen, the burden of proof is on the state. There is no burden on Tyree Blige. He didn't have to take a stand, but he took the stand so he could tell you his truth. No person shall be convicted of any crime unless and until each element of the crime is proven. But in this case, it's not just only they have to prove every element. We've raised an affirmative defense that we're justified. So not only do they have to prove every element, they also have to prove that the actions weren't reasonable. They have to go that extra step. Direct and circumstantial evidence. You would be authorized to convict only if the evidence excludes all reasonable theories of innocence. All reasonable theories must be excluded in order to get a conviction in this case. Ladies and gentlemen, Judge McBurney will tell you that sometimes the defendant's use of force is legally justified, and so it is not a crime. The state has the burden of proving beyond a reasonable doubt that his actions were not justified. All right, I said ABC, so we got to the B. Now we're down to the bottom line. And ladies and gentlemen, the bottom line is that Tyree Blige is not guilty of murder. He's not guilty of felony murder. He's not guilty of aggravated assault, and he's not guilty of possession of firearm during the commission of the felony. The above charges. Ladies and gentlemen, he took responsibility for his actions. He admits he was panicked, he was scared, he's never been in trouble before, never been in an active shooting, it's a first. Now, credibility. We're at the C's. Ladies and gentlemen, when determining credibility of the witnesses, you get to look at their manner of testifying, their opportunity of knowing the facts about which they testify, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. You guys get to determine, well, this person took the stand and everything they said wasn't true, or this person took the stand and they're credible. We can believe what they said is true. That's on you guys to determine. And so our job is to show you everything, but their job should be to show you everything, not just what works for them. With conflicts in testimony, you must determine what testimony you will believe and what testimony you will not believe. Now, I want to go through some of the witnesses. We have been here for 6 days. A lot of those witnesses really didn't say much, but they were purpose for them. Now, Officer John Pierre, that was one of the first people, that's the person who didn't even know the name of the victim in this case. The very first person that testified. Officer Gakanga, That was exhibits 1 through 84. So that's how they got all the crime scene pictures in. Officer Jeffrey. He didn't know much. He didn't have any involvement regarding Tyree Blige. Sharon Latners. Now she was the one that got the 911 CAD report in. That's the radio surveillance radio that I don't even think that was played. They put up this witness, they put this exhibit in, but I don't even think it was played. Ladies and gentlemen, exhibit 129, you'll hear that the radio of one shot in the leg, one shot in the back. The crime scene tech Gomez, that was the redhead lady that now works at the Marshalls. She that doesn't want to work for APD anymore. She is the one that noticed that there's the 5 .380 shell casing and the 4.45. But ladies and gentlemen, here's the issue with the state's theory. The state can't say that my client caused the 45 shot to the victim's back, but he also picked up the shell casings. You can't have both. Either he picked up the shell casings or he didn't. But ultimately, my client took that stand and he told you he had a knock. And a 45 is what shot Solomon Smith in the back. But that's where Detective Bacon came into play, because Detective Bacon is where you'll see this exhibit. And ladies and gentlemen, when Detective Berry took the stand, she said there weren't any defects back here. But also, if you see on the video, a lot of cars left after the shooting. So who really knows what defects were in the cars that actually left? But what we do know is this car was still there, and this car has defects in a projectile. And it would make sense for those 45 shell casings to have been shot in this direction, while these 380 shell casings were shot in this direction. It makes sense. Ladies and gentlemen, this is another part of the exhibit, just so you can identify what 1, 2, 3 were. Detective T, that was the detective that took the stand just to get all the video surveillance in. Now, Javante Rivers and Jakayla Rivers, I didn't write a lot about it because every statement's changed. So I would end up having 10 different slides. So the first statement, at Piedmont Hospital, that's when he was like, it wasn't my fault, and I didn't do it. Okay, that was his first remarks, not help my friend, not anything of that nature. He doesn't want any part of it. Then the second time, they go to his house, his sister's there, they go to his house and they're recording all these interviews and he still doesn't say anything. Instead, he says there's a man with long dreads at the top of the hill, that was the shooter. Then the third interview that's at his house, he still doesn't say anything until 15 minutes in when they take him away and they're like, we've seen the video. We've seen the video, we know what's going on. And that's when he says, yeah, I shot 3 times, or no, at first he says I shot once in the air. Then he says, actually, I shot twice. Then he says, after I shot, I slid the gun under the car and Kiki picks the gun up and Kiki shoots once in the air. But once he took the stand, he didn't even want to admit about Kiki shooting in the air. But we had to refresh his recollection. And we could have done that with Will Lewis too. But Jakayla Rivers and Javante Rivers were always together in all of their interviews. So they always knew what each other said. They never were separated. It wasn't like, let's bring them down to the police precinct. You go into interview room 1, you go into interview room 2. We won't let you guys figure out your story together. But if they were so innocent and they're just these, here's even worse. They're cooperative. They were cooperative, but leading Detective Berry down a rabbit hole. Leading Detective Berry into non-truths. Where, William Lewis, he might not want to take this stand and testify against his friend. But he did, and he still told the truth. So that's important when understanding the facts, because all we want is to seek the truth, and we got to separate facts versus feelings. Immunity. In assessing the credibility of a witness, you may consider any possible motive in testifying if shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. In my opening statement, I told you the person that shot Solomon Smith in the back was not sitting in this room. It's because that was Javante Rivers. Ladies and gentlemen, Javante Rivers is not here being charged. Jacayla Rivers is not here. Kiki is not here. Maya Thompson's not here. There's another Kiana, Cleat. None of them were charged, but they were very much active because in the first tussle, Tyree's not getting involved, and Solo and Javante get involved. In the second tussle, now Will Lewis is pushing the girls off, but he's still not getting involved. Helen grabs the gun now. I mean, Will Lewis is trying to get back in his car when he gets hit in the face by Solomon Smith, but that's when Helen's coming around the corner. That's when Helen's pointing. And then that's when the gun's behind Will Lewis's head. But they were never charged with any of that. William Lewis said he didn't want to testify, but he did. He cooperated with detectives and he was honest. He provided names, he provided numbers. Now he said, I don't recall, but they never gave him the opportunity to refresh his recollection. Now, he testified to something to the effect like, I would give you the transcript, you said you didn't want to read it. He said something to the effect that you were supposed to text it to me, but I never got it. But, you know, whether or not he wanted to read it, he could have been made to listen to it. We all could have. All you had to do was press play. He admitted to fighting the women. He also admitted that Tyree wasn't an aggressive person. And that's important because the state's trying to make it like he's this protector of everyone. But Tyree took this stand and he explained that even if it was a stranger, he would have been protecting them. Tyree made the decision to go down that hill after Javante chased off Quentin. Wow. And then Javante's still in the corner, and watch his body language, because you'll see him walk around like this. And his body, because we can't hear it, but watch his body language, because his body language shows the aggression. Judge Teskey, that was William Lewis's mentor. About it. I mean, he was here to say that he actually wrote down the names instead of Will Lewis, and Will Lewis told him the names, and that's how he provided the names. Tiffany, she was the waitress. Helen Abraham, we already pointed Helen Abraham out. But you know, also, the state wasn't gonna show you that Helen Abraham did a photo lineup. It wasn't until I showed Helen that, oh yeah, you did a photo lineup, right? Oh, you also identified someone who wasn't even involved, just to identify someone. Or the next person who identified someone, and then she goes, well, the police told me just whoever favored him most. You know, Helen also made the good point that Javante took that stand and told y'all, he went up to Helen and Rhea and said, is this your gun? Yes. Is it registered? Yes. Helen confirmed that never happened. Kiera, now this is the third, she was after Javante and Jacayla. She was the one that Helen said she's been dating Javante ever since Solo's death. She's the other one that did the photo lineup. Asia Ashley, she was William Lewis's girlfriend at the time. Trace and Holly, the guy with the dreads, he was present that night. He was in the white car. Dr. Karen Sullivan. Now, she's the one that testified that the cause of death was the gunshot wound in the torso. But what's important is the direction. The direction is back to front, left to right, and up. And that shows that he was already falling. But when I show you the chain of events, when I show you the screenshots later, that's why it's so important about how this happened. Because Dr. Sullivan explained that that leg shot broke his leg, but it didn't kill him, but it made him fall. And that's when he got shot in the back by the 45. It wasn't a 380, it was a 45. And those 45 shell casings out there came from Javante Rivers. Catherine Jordan, she's the one that told us which caliber was which from GBI. So she's the one that said the 380 was found in the leg. That was the projectile fragments. And then the 45 was found in the back. Terrence Blige. Now, Terrence Blige is the one that caught me up in my feelings because I would never expect his father to have to take a stand to identify Tyree when we're already saying it's Tyree, to identify the type of car Tyree drives, which we're saying what type of car he drives. It was just the purpose of putting his father on the stand to testify against him. But he still told the truth. You know, Detective Savannah Berry, this is not poor police work. And you know, lots of cases are about poor police work, but this isn't that. This detective did what she could do with what she had. And what she had was Solomon's friends and family and girlfriend lying, obstructing her investigation to get to the truth. Now, when I showed her the video, she never noticed Helen with the gun to the back of William Lewis's head. That's important in the chain of events. She never noticed Javante Rivers with the gun chasing Quentin Williams. That's important to the chain of events. She testified that there were 2 gunshot wounds to the leg, but we know that there's 1 to the leg, 1 to the back. Now, no further investigation into Rhea Thompson's firearm, just to prove whether or not she had a firearm, or if she had a .45, or if her mother had one. Just to get that information is the purpose of that investigation and that question. She confirms Tyree Blige has no criminal history. She confirms Tyree Blige has the right to own a gun. He's licensed to carry. And she confirms that Tyree Blige has the right to defend others. Investigator Rickman. Now he's the one that when he was like, I'm not the senior investigator, he got me with that one. But, you know, his purpose was to say why we couldn't hear from Rhea Thompson. But what about the Kiana that was shooting out in the passenger side of the car? 88 Grant Root. Now he was the one that brought in those jail calls, but he also didn't recall that he was also the first initial prosecutor in this case. And when he was the first initial prosecutor in this case, he was pursuing charges against Javante Rivers, and he didn't have any part in dismissing Javante Rivers. That happened Monday at this table. Tyree Blige. Ladies and gentlemen, good, bad, or ugly, the truth is the truth. And Tyree Blige took the stand and he told you his truth. Please understand there's a difference between what you remember, what you saw in your own line of vision, and when you had the opportunity to look at a full picture of it. So now when he's saying, well, seeing on the video, maybe he didn't see way down at the end of the parking lot because he's focused in on Javante Rivers. Good character alone, this is law. You have heard evidence of the character of Mr. Blige in an effort to show that he likely acted in keeping with such character. The evidence has been offered in the form of an opinion of another witness. You should consider any such evidence along with all the other evidence in deciding whether or not you have a reasonable doubt about the guilt of Mr. Blige. The evidence is that Mr. Blige is not aggressive. It's as simple as that. He's not aggressive in nature. He was not the first to bring a gun into this situation, and he's observing from afar to determine when the threat is serious enough to get involved. All right, ABC, 1, 2, 3. I'm gonna start with 3. Justification and the use of force in defense of others. 3 elements, ladies and gentlemen. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when 1, he reasonably believes that the use of such force is necessary. 2, to prevent death or serious bodily injury of a third person. 3, to prevent the commission of a forcible felony, which means a felony that involves the use of force or violence against each other. The state has the burden of proving beyond a reasonable doubt that Mr. Blige's actions were not justified. If you decide that Mr. Blige's actions were justified, it would be your duty to acquit Mr. Blige. This is more law. Threats justifying a homicide. A defendant's use of deadly force may be justified even when there has not been physical contact between anyone.
if the menacing action of the alleged victim is sufficient to create a reasonable belief that 1, another's life is in imminent danger, 2, another is in imminent danger of a serious bodily injury, 3, a forcible felony is about to be committed, then the defendant's use of deadly force may be justified. Ladies and gentlemen, this is not just Helen yelling out or anyone yelling out. This is them holding guns to people. This is them holding guns to his friends that he's just watching. But nobody brings out a gun except them first. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing action may justify the use of deadly force. Ladies and gentlemen, this has been a case about chain of events. It's a timeline. And that is where we're asking that you understand Mr. Blige's actions were justified. There have been 2 means of successful impeachment in this case. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Prior statements has been an underlying issue in this case, and that's because everything was recorded. So we know exactly what was said. So when they take the stand and they say something different, that's when they've been confronted. 1, ultimately, this has been like a theory word in this case. Ultimately, these chain of events. At 2:16:06 is the first time a gun is brought into the picture. At 2:16:08, the gun is behind William Lewis's head. At 2:16:19, the gun is being passed off to Rhea Thompson. At 2:16:20, Javante Rivers grabs the gun. At 2:16:25, this is where he's coming for Quentin Williams. That gun is pulled straight, not in the air. This was an aggravated assault by Javante Williams. This is when Helen brought the gun, but when Javante Rivers really brought the heat. 2:16:29. This is WAP. This big guy, ladies and gentlemen, you'll see in the video that that's when first he runs and chases Quentin Williams from here. Then this crowd is mingled, and that's when you see Javante Rivers like this. And then WAP saying something, we don't know what, but that's when he puts the gun in WAP's face. 2:16:41. That is a muzzle shot. That is not in the air. That is somebody running. Ladies and gentlemen, we submit that is the shot that killed Solomon Smith. Ladies and gentlemen, Javante Rivers said he was shooting in the air. At 2:16:43, you see him using the car to steady his shot. This is more law, grave suspicion. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charge or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient. Ladies and gentlemen, you can think he probably did it. You can think he likely did it. You can think maybe he did it. That's still a not guilty verdict. Ladies and gentlemen, it's not just guilt beyond a reasonable doubt, but it's all of the elements charged plus the justification in order to convict. So if you feel like he probably did it, maybe he did it, it's likely he did it, that's not enough for a guilty verdict. Ladies and gentlemen, we are asking that you find Tyree Blige not guilty. We understand that this has been a long week and some change. And we appreciate your attentiveness, we appreciate your notes, and we hope that you come back with a verdict that speaks the truth, because that's all we're asking here. Please understand the chain of events in this case and understand why Tyree Blige is justified. Thank you.
Thank you, Ms. Fagan. Mr. King.
Thank you, Judge. Good afternoon. I've been in an interesting position the entire trial, being the third one up, not wanting to bore you guys. So I'm gonna do the same thing again, because a lot of the stuff you heard from both parties is not in dispute. So I'm gonna do my best to keep this short and do my best not to keep repeating what other folks have been saying. As I stated in the very beginning of this case, I had a title, and that title was called Assumptions Are Not Conclusions. And I wanted you to have that reference when you listen to the evidence, because there was going to be, I knew there would be a lot of facts presented that the state was going to draw some assumptions and represent to you that they were conclusions. And I wanted you to make sure that you kept that in your mind while you're listening to the evidence. One of the assumptions in this case, that the beginning all the way to the end, this is based on a crew versus crew situation. The problem with having a theory when you're a detective or in law enforcement, and you take that theory and you don't rule out all other possible theories, is what you're supposed to do. Sometimes mistakes are made. And that's today is one of those times with this case. So in this case, we have two crews. And the reason why I use crew versus crew is because this is what the state is in their opening. When they're telling you that it was crew on crew, and because it was crew on crew, that they can't have two people here from one crew and then another person from that other crew in their at the table. So to follow through with the crew versus crew theory, they decide to let one person in the crew of the deceased go because it's not in line with their theory. But what we learned is, as things started to unravel, and I believe that Detective Berry learned this as well, is that it was a lot more complicated than crew versus crew. One of the important things, and I want to get to Detective Berry's testimony later, one of the important things about the crew versus crew theory in this situation is what I crossed Detective Berry about. And that is, when I started saying, is it possible that Javante shot his friend outside of you? Okay. At first, she said, well, that's not possible because that's his friend. That's the crew versus crew theory. Is because Javante and Solomon are on one side of the verses. It's not something that she even thought about. But the problem is you have to follow the evidence, see what's there, see what's not there. And when you're looking at what's not there, determine if it's something possible, something else possible. But that didn't dawn on her until she realized, and when she realized during her testimony, it seemed like that's when she realized it, is that Javante said he didn't know where Solomon was. And if you don't know where Solomon is, then I guess it's back into the crew versus crew theory, because you might have shot your friend because you didn't know where he was. Point is, Detective Berry was influenced by that. So was the state. They got it wrong. And that's the danger of using the theory, but not ruling out all other possibilities. And in this, that's what this whole case is about. Have they ruled out all other possibilities? And that is an impossible situation based on the facts that we have. So the state and Ms. Fagan have all talked to you about the law. That's one thing I want you to understand. The judge is going to read, and I don't want to go back over it. I just want you to understand that Mr. Head, he is presumed innocent of everything until the state overcomes certain hurdles. And they have to overcome those hurdles beyond reasonable doubt. Meaning that you can't have any suspicion that it's possible something else happened. You got to really, really believe it. And then you have to, as I try to tell you, that what should have happened, you got to rule out all other theories. And when the evidence supports some sort of justification, it's not our job to prove the justification. It's the state's job, beyond a reasonable doubt, to disprove it. And that's an important distinction here. So just as the judge will read it to you, the state's talked about some of it, Ms. Fagan's talked about some of it. These are the laws of the case. Don't want to go through every one of them because a lot of them are self-explanatory and you'll hear them. Ms. Fagan talked about mere association. So I don't need to talk about it again. The judge is going to read it to you. But it is a very, very important part in this situation. So murder. In this situation, if you want to do the malice murder, which the state has charged my client with, these are the things that they have to prove. Number one, they caused the death. It was unlawful and with malice aforethought. The felony murder is, the state used like a bank robbery type of thing, the parties to a crime, and he gave the parties to a crime, but I want you to understand that that same example can be used for felony murder. So if you use a bank robbery situation, and let's just say you planned the bank robbery, but you didn't go in. But in the bank, a security guard gets killed. Security guards gets killed. So the felony that you're committing is bank robbery. And during that commission, death happens. So even the person who planned it can be responsible for the death. And so that's just another theory in the state of Georgia in which somebody can be held accountable for the death of the person. In this situation, the state is trying to say that if there's an aggravated assault, and in that aggravated assault, the person died, then the person who committed the aggravated assault should be found guilty. In this situation, it's kind of can get complicated because there are two different bullets. And in this situation, we don't know who fired any of the bullets. And that's one of the problems that the state is going to have to overcome. But in a situation like this, you would have to say the person who shot the 45 caused the death of the deceased. That's the facts we have. And because he shot the 45, that's aggravated assault. Because the aggravated assault actually caused the death, then that's felony murder. So it's just another theory. And that's what the state has to prove in this situation. Aggravated assault, it's already been told to you, already been explained. And the justification has already been explained. So I don't really want to go back over this. Parties to a crime. I want to talk to you a little bit about that. The law's right here, but just to give you an example, the party to a crime like the bank period, the issue here, I imagine what the state's going to try to do is say that, well, they have to say, we don't know who shot. But we don't have to because they were working in concert together. The problem with that theory is there's no evidence to support it. The evidence that we have is there are at least 5 shooters that have been discussed during this trial. Okay, and I'll talk about that in a minute. but they still have to show who did the shooting. And the shooting that actually caused the death. They have to show that without a justification. And in this situation, Detective Berry, she specifically said the reason why she charged all three of these people for the murder is because she didn't know who shot. Yes, it is a terrible chain of events that happened, but the state still has to prove something. And what they have to prove is that Xavier Head caused the death, or he worked in concert with somebody else that caused the death. There wasn't any communication between him and anyone else. There wasn't any unwritten body language between Xavier Head and anyone else. There wasn't anything besides the state saying that because they were close to each other on two different sides of the car, him and the co-defendant, that therefore they were working in concert together. Problem is, there's no evidence to support it, number one, but number two, you actually need to show that one of those two, who they would say are in concert with together, actually caused the death. And that's something that cannot be overcome. So just to sum it up a little bit more about the things that led up to the untimely death of Dr. Solomon Smith. So Xavier Head and his friends met up with William Lewis. Then they head to the Buckhead Loft. At the same time, Solomon Smith, Javante Rivers, Jakayla, Kiana, they're all meeting up with Helen and Rhea, and they're going to the Buckhead Loft as well. Both groups go in. I don't think anybody from either group knew each other at the time. So William Lewis argues with Asia Ashley, and then they decide to leave the club. Xavier Head and Quentin, they leave at some time a little bit after that. Both parties really leave the club, and they're kind of, at this point, converging on each other. William Lewis assaults Asia Ashley. Jakayla and her group checks Jakayla's car for damage. William and Asia get in the car to leave. Asia is backing out and almost hits Rhea. Helen starts to beat on Asia's window. William Lewis gets out of the car and hits Helen. Fights break out, and Helen gets a gun and points it at William Lewis, escalating this incident. Helen passes the gun to Rhea. Javante gets the gun from Rhea, and now it's escalated. It's already escalated. It's going to another level. Javante gets the gun from Rhea and starts chasing Quentin, and that's when the bullets fly. Solomon Smith is shot in the leg and in the lower back. Javante gets into the vehicle with the gun, and another shot is fired in the direction of Solomon Smith. Kiana Clark shoots, well, that's in the direction of Solomon Smith. Kiana Clark. Before I talk about the specific witnesses, I want you to understand the hurdles that the state has to overcome and prove each set of facts, overcoming those hurdles beyond a reasonable doubt. That a particular person fired a shot from a gun. Obviously that happened. That a bullet fired from that gun struck Solomon Smith. That particular bullet fired from that particular person's gun caused the death. These are kind of generic. Or that person is either the accused, or the accused helped that person cause the death of Solomon Smith, and the shooting was not justified. So all of those things have to be here in order for you to find him guilty of malice murder or felony murder in this situation, and aggravated assault, if you just take the death out of that equation. So let's get into the witnesses. And obviously I don't want to go through everything, but some of the important things regarding Xavier Head when it comes to these witnesses. William Lewis, yes, he was involved. He didn't say anything. And there's no evidence that he had any conversation with Xavier Head that would be presented that would be held against my client. Mr. Holly had two things that went on. Number one, when he testified, he didn't testify to anything that could be held against my client, Xavier Head. Okay. And number two, you all heard the jail calls. Jail calls is something that most people understand they are recorded. Yes, most people know them. I believe Mr. Holly thought that he was doing my client a favor by doing something with the gun. Okay. Now, the reason why I put this in parentheses, now keep in mind that this is 35 days after the shooting. And at this point, when Mr. Head is arrested, he already knows that there's a warrant out for him. He already knows, and of course, he was there the night the shooting happened. The reason why this is important is because if you take this information, then also with the testimony of Ms. Drain, when I cross-examined Ms. Drain, and she stated that it was her initiation to get rid of the gun because she wanted it out of her house. She never testified that she was told to go somewhere and get the gun. She actually testified that she told Xavier, his parents, to come get this gun because I wanted it out of my house. That was her initiation. There was no evidence presented in jail calls or testimony that says that Xavier Head made any initiation to get rid of a gun. But yes, the state presented evidence that my client was either silent or said no on the jail calls. Why would he do that? Because of course, exactly what happened in this trial. The state was gonna hold it against him. But I'm glad that Ms. Drain testified. And I'll tell you, she's not gonna lie for him, right? Y'all know that because apparently she hates his guts. So you know she's not gonna lie for him. So the easy thing would be, he told me to get rid of the gun. She didn't even say it. She came in here and told you the truth. I talked to his mama, told him to go get the gun because I didn't want that thing in my house. And the reason why I think that it's significant is 35 days after the shooting is under the state's theory, if you're getting rid of a gun, get rid of it after the shooting. Get rid of it the night of, if that's what your intention is. But ladies and gentlemen, the reason why there was no gun initiated for Xavier Head to get rid of is because he's not responsible for the shooting. So Asia Ashley, she didn't see anything involving the crime here. She didn't see anything, and she never spoke to Xavier as well. The significant part of Helen Abraham's testimony is the fact that she, of course, she was telling the truth. Yes, she is the one who introduced the firearm. And just like Ms. Fagan said, that this was a chain of events. And you have to look at who escalated certain things. And then you also have to look at, did the people at this table cause the death of Solomon Smith? And in this situation, Helen Abraham escalated from something that was a fist fight at most to now an aggravated assault. So Helen Abraham actually is the first person that's felony in this situation. Kiana Clark, she fires a shot in the direction of Solomon Smith in that car. The state's gonna say that Solomon Smith had already dove to the ground. The problem is we don't know exactly what Solomon Smith did after he dove to the ground because he was out of view. And obviously, knowing simple physics, if the camera view is coming from this side of the vehicle, you don't know what is on the other side of the vehicle, especially at night. So you cannot rule out the fact that Kiana Clark may have also fired a shot that hit Solomon Smith. And then the other thing about the other person here, Jacayla Rivers, Jacayla saw a guy with a long gun and dreads. And the reason why I want to bring that up is because of what I've been saying all along is 5 separate people have been introduced into this case as potential shooters, but we don't know which one it was. So now there's several issues about Detective Barry. She responds to the shooting. She wasn't able to positively identify my client as the shooter in this homicide. She circumstantially IDs him because of him and Mr. Holly walking out of the vehicle, but you cannot make a positive ID even then. She quote unquote charged everyone because she didn't know who shot the victim. She charged Javante knowing he could have been the actual shooter who fired the fatal shot. Frankly, Detective Barry, and just like Ms. Fagan said, I believe she's trying to do the right thing. She's a hardworking detective, and I appreciate everything she said, including some of the stuff that she had to walk out. But I just believe she got it wrong and she stopped. One of the things that I wanted to also point out, I think it's on here, but I wanted to, it brings it to my attention. It didn't seem like that she knew that Solomon Smith was shot in the back until she was on the stand. And the problem with that is, if you don't know such a crucial fact, and that is where on the body was the person shot, then can you believe that she ruled out all potential theories in order to reach the conclusions that she reached? Ladies and gentlemen, I believe that answer is an obvious one. She thought that Solomon Smith was shot twice in the leg. And that's important because this is a whodunit, and you have multiple people that have been introduced as having guns and firing them, but there are only two people here, and we don't know, according to Detective Barry, who shot. And on the stand, Detective Barry admitted that she could not rule out Javante Rivers as the shooter. So this canceled out the whole crew on crew theory, because now it's a potential that one crew shot his own because he was shooting in a direction in which he contradicts his own sister, because he's saying that the bullet came from the direction he was shooting, instead of shooting where his sister said the bullet was coming from the place in which the car was driving. So now let's get to what happened with Javante Rivers. At first, there was a guy with long dreads shooting in the opposite direction of the parking lot. He was second. He shot only once. It was a warning shot. He shot twice. He got the gun from the ground. He got the gun from Helen Abraham. All lies. Never admitted to getting the gun from Rhea Thompson. Asked if it was registered, which even the state admitted sounds pretty ridiculous. It wasn't corroborated by Helen or Rhea. He shot the gun in the air. And I don't think anybody believes he shot the gun in the air, but could not, after taking an oath and looking at you guys straight in the eyes, couldn't even admit to what we can all see as the truth. Never could admit it. He never mentioned that he chased Quentin Williams with the gun, because I don't think anybody confronted him. Because, and that's an important thing, is that if the state puts him up, they must be putting him up for a reason. And that reason is for him to tell you guys the truth. So I would hope that he would give you that at least, especially because he was doing what I quote him as saying, trying to get justice for my brother. So forget all the other stuff you lied about. Walk into this courtroom, tell you guys the truth, so we can further justice for my brother. He couldn't even do that. So if the state's presenting him as a major witness, What's the purpose? Is because he has to put forth the crew versus crew there. Even if it doesn't support, it's not supported by the video. And there's a reason why Javante Rivers never was willing to tell you the truth, even though he was looking at you guys in the face and felt like it to try to tell you that he was trying to get justice. And that reason is because he fired shots in the direction of his friend. And I believe that he caused his friend's death. But he thinks that it might have happened because he doesn't know. And that's the problem, is none of us know. But that guilty conscience showed up at the hospital when he made that quote, when he talked about it wasn't my fault or something like that. That's the guilty conscience, because he thinks it might have done it. If you didn't think you might have done it, then don't set these lies. And especially when you know you're not being charged, come and tell the truth, at least to the jury. That's not what happened, ladies and gentlemen. He couldn't even tell the truth after all of this time. So, ladies and gentlemen, there's a few more slides. Helen Abraham puts the gun to Williams' head. Javante Rivers puts the gun to Quentin Williams' head. Javante Rivers shoots multiple shots in the direction of Solomon Smith. Javante Rivers may have shot Solomon Smith off camera. The .45 projectile killed Solomon Smith, and we do not know who fired it. The .380 struck Solomon Smith in the leg, and we don't know who fired that. The .380 projectile does not match anyone's gun. In fact, there were no guns that were presented. Detective Berry says that she saw Xavier and Head Williams walk to the car, but that's also circumstantial. No eyewitnesses from the scene ID Xavier Head as the shooter. No eyewitnesses from the scene ID Xavier Head as the driver of the vehicle. And there were 5 shooters introduced into this case. No one shot their firearm until Helen Abraham put the gun to Will Lewis's head. No one shot their firearm until Javante Rivers chased Quentin Williams with the gun. And the bullet that killed Solomon Smith was a .45 caliber, and there's been no testimony that anybody specifically had a .45. As I spoke to you a little bit a while ago about the hurdles that the state had to overcome, this is actually almost the same slide, because every single thing that the state has to overcome, they have not been able to based on the facts. So these are the questions that we still have. Who shot Solomon Smith? Who killed Solomon Smith? Why couldn't Javante tell the truth? How many times did the Javante Rivers fire when he was out of view? And where is Javante Rivers? And I say where, and why isn't he charged? If the theory is, we don't know, but you participated. Because I think that's what the state's theory is going to have to be. Because nobody knows who fired that .45. And to Detective Berry's credit, she felt at least that he should be charged because she couldn't figure out who fired the shot. So these are some of the state's questions, but I want to make sure that we keep in mind that the state is not here to ask questions because it's their burden. But these are the questions that they want you to use as your reason to convict Xavier Head. Is why didn't they call the police? That's a good question, but it's not required, and the state has to prove the burden of proof to prove that my client committed a crime. Why Are we just hearing this defense now? That my client has a right to remain silent at all times. And the judge is going to instruct you on the law and explain to you that you can't hold anything against my client for being silent. So if he has never given the police an interview, and he's never testified in his trial, you can't hold that against him, or else you would be violating the law. And the state seems like they want to hold it against him because this is the first time they're hearing it. Why did they conceal evidence? My client didn't conceal anything in this case. And if not Xavier, then who? The problem is this is not school. This is, you can't use process of elimination in this situation. Ladies and gentlemen, they have to say what happened and who did it. And because they can't say what happened and who did it, there's only one verdict in this situation. This is similar to what Ms. Fagan gave. And I want you to keep in mind that as you're deliberating, the only thing that you can do to convict anybody at the tables over there is have no doubt, no reasonable doubt. But based on the state's theory and the evidence presented, they have no evidence that my client committed any of these crimes. And because of that, you can't even say he probably did it. You can't say he might have done it because the state has the burden. But in this situation, even if you think maybe he wasn't involved or maybe he did do it, you have to rule out all possible doubts and all possible theories and rule out justification. It cannot be done in this situation. And lastly, when I started in my opening, I just want to be honest. Of course, sometimes we don't know how the evidence is going to play out. And I don't want you guys to think that I was trying to kind of hide the ball in this situation. So yes, there's been plenty of evidence to show that Xavier Head was in that car. And there's been evidence to show that Xavier Head was on scene. I don't shy away from it. But the problem is the state has to prove so many more things because the things I just stated are not part of the evidence. The only thing that you have to do, what the state has to do, is they have to prove who did it, and they have to prove that it was without justification. Ladies and gentlemen, based on the evidence, my client, Xavier Head, did not do it. And because of that, I would ask that you find him not guilty every single count of the indictment. Thank y'all so much.
Thank you, Mr. King. Ladies and gentlemen, I'm going to give you a short break before we have our last piece of closing argument coming from one of the two prosecutors. You have been sitting there listening attentively. Some of you are invisible to me. Hopefully you're still in here. You are. We're going to take a quick break. You go back to the jury room. Try to keep it around 10 minutes. I'll have one of the deputies check on you maybe at 2:35. And if you're ready to come back out here, we'll have the state's second part of their closing and we'll go from there. Don't talk about the case yet. We're not done with closings. I still haven't given you the law, but I will see you all in a few minutes. Thank you so much.
All right, juror.
Mr. Abate, anything before we break?
No,
Mr. King? Ms. Fagan? All right, then I'll see you guys back here in about 5 to 6 minutes. Thanks. So what's bold ginger ale? I've never seen bold.
Extra gingery.
Is it more pop to it? You like it? I will get one. No, I understand. I didn't.
Extra, I'm sorry.
You like the bolds?
No, I used to, I gotta get one.
Yeah, exactly. Well, she's not giving you hers. Yeah, I see that. I see that.
So your allergies, seasonal allergies.
Got it. Cool. Well, we'll get it. My kids like ginger ale, so we'll try the bold. Bold.
Right.
That's why.
Is it a turn? It doesn't literally look like it.
It's too big to be just like. It's just like crouched up. You're only like 6'8".
But if something happens on one side, then one.
The chair still live right there? You really couldn't tell. This one, that's just one. It's because. And so little.
You can drink it, take it outside. Did y'all tell them more? Y'all tell them about drinks? Okay. Court will now come to order.
Mr. Abate, are you ready? Would you like a half hour? Hmm. Exactly. And we got one guy, you can't see him right now, but that big guy. Yeah. Okay. He's been a dozer. Poor guy. He works at nights and he's not stopping working. So.
Yes, Judge.
All right. Mr. King, you ready?
I am, thank you.
And Ms. Fagan?
Yes, sir.
Great. Then when you guys are ready, let's bring the jurors in, please.
All rise for the jurors. All jurors are counted.
Thank you, sir. You all can be seated. Ladies and gentlemen, we are in the home stretch. Mr. Abate is going to share with you his final closing remarks. And when he's done, I will move this, someone will move this monitor a little bit so I can see you guys better. And I will give you the law that you must apply to the evidence that you've received. Mr. Abate, when you're ready.
There's one key thing that both defense counsel didn't mention in their closing. And that's that the defendants were shooting. You didn't see one single slide highlighting the defendant's open firing on that crowd, that group of people, ultimately killing Solomon Smith. Not one. Javonta, 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 Javonta. That's all you heard. That's it. At the beginning of this trial, at the beginning of this case, in my opening, I didn't lie to you. My job is to present the facts and the evidence, and for you, ladies and gentlemen, to determine the truth. And to do that, I told you Javonta Smith, or Javonta Rivers, shot. I told you the gun that Javonta Rivers was never recovered. 2 other guns weren't recovered that night. And you heard from Xavier Head where his gun was. His mama got it. They hid it, they concealed it. You heard today from Tyree Blige. Coincidentally, his mama, who's sitting in the courtroom, has his gun hidden in a bag, just laying there. Is that a coincidence? Now, I want to highlight one of the legal principles that the judge is going to go over. And a party to a crime means that participants may be convicted of all charges, although they are not the actual perpetrator. But ladies and gentlemen, we have the 2 shooters. We have the 2 suspects. One is a party to a crime when they directly commit, intentionally help, advise, encourage, hires, counsel, and procures another, or causes someone else to commit a crime, which is exactly what Mr. Blige was doing when Mr. Quentin Williams is walking around, bending down over and over again, picking up shell casings. Mr. Blige may have only picked up 4 like he told you in the stand, but that's because Quentin Williams had picked up the rest. You know who didn't pick up shell casings? You know who wasn't concerned with that? Javonta Rivers. You want to know why? Because he was concerned because his friend had been shot twice by those 2 defendants for absolutely no reason. Absolutely no reason. And you know it was for absolutely no reason because Tyree Blige told you. He told you sitting right there looking you in the eyes that he was just observing, observing, observing. He wasn't observing, he was waiting for Xavier Head. The moment that the shooting would occur was when Xavier Head became parallel or aligned with him and they walked down together. That's what he was waiting for. He wasn't observing anything. He said he observed Helen point a gun at Williams' head, but that wasn't serious enough for him to take action. That's a lie. That makes no sense. Makes absolutely no sense. And you will see in the video, in still shots, Javonta Rivers is nowhere near the direction where these 2 defendants are shooting. He's behind a car. They cannot see him. The person they were aiming at was Solomon Smith, because Solomon Smith stood up to William Lewis. They were William Lewis's armed guards. And William Lewis told you that. He told Detective Barry that. He told Judge Teskey that. He told Detective Sajak that. And he told you that, ladies and gentlemen. And I could have played his statement, but in the interest of your time, I refreshed the detective's recollection with the transcript of the recording that defense counsel referenced. Guess who else could have played it? Defense counsel. But they did it because they knew the transcript was accurate. that the transcript was the exact same thing that the recording the state is hiding. That makes no sense. We picked you, ladies and gentlemen, because you said you could follow the law and you have common sense. Use it when you're filtering the argument. Use it when you're looking at the evidence. Use your life experiences. Use all of that when evaluating the evidence. Now, this is important. Presence, companionship, and conduct. And it can be conduct before and it can be conduct after. Ladies and gentlemen, if maybe my eyes are playing tricks on me, it's playing a trick on me because the two defendants walked down in concert. They walk down side by side. They walk at the same speed, ladies and gentlemen, but Mr. Blige wants you to think he didn't see that Mr. Head had a gun. He wasn't paying attention to that. That makes absolutely no sense. Absolutely no sense. They started firing at the exact same time, but he didn't know he had a gun. And we know Xavier Head got out of that car. We know Xavier had fired that weapon because his co-defendant told him. His fellow shooter told you. Their conduct after. You have Mr. Head talking with his girlfriend, talking with Trey, I confronted him as to whether he had any conversations and he had ever been to Miss Drain's house about this gun. He looked each and one of you in the eyes and said no. He said no. He's on that jail call. You heard him saying he came over to Miss Drain's house because he was going to take the gun to his daddy's house. That's what he said. And you hear Mr. Head not say, what gun are you talking about? He says, hey, dude. That was his sign of shut up. Because Mr. Head does know the call to record it, which is exactly why he tells Asia Drain, and excuse my language, you can't talk code for shit. And Asia Drain says, man, it's getting too difficult to talk code. Because no person can talk code 24/7. That's the point. That's the point. He can try as hard as he wants to hide the truth from you, ladies and gentlemen, but the facts are the facts. The evidence is the evidence, and the video is the video. Can't be changed. Now, the defense. You've heard multiple defenses that the defendants aren't the shooters. Mr. King got up here and said, we don't know Xavier was shooting. We don't know he was one of the shooters. The state hasn't proved that beyond a reasonable doubt. I beg to differ. Or that the defendants are just merely present. Well, Mr. Blige's testimony completely blew that one up in the water. He told you they were both shooting. That's corroborated by Ms. Drain's testimony. It's corroborated by the video. You can make out the stripes down Xavier Head's pants. You can make out Mr. Blige's tracksuit or jumpsuit. You see that in the video. They can't deny it. But they look each and every one of you in the eyes and try to. Now I'm going to go through the timeline. I'm going to do it quick because I know I'll be the third person who's done it. And I know you're tired of hearing all of our voices, but definitely mine because you've heard it for the last week. And it's clear that on July 12th, 2009 at 12:06 a.m., that's when the caravan, the Head is second in line, arrives at the law. Miss Asia actually told you that. They all had drinks at her house. And her, William Lewis, Tress and Holly, he didn't want to admit that to you. But Miss Ashley, he didn't realize Miss Ashley was gonna testify to that. And Mr. Head all drove up. You see Miss Ashley's car parked right here. You see Mr. Head's car right behind her. And then not more than 30 seconds later, you see Justin Holly's car at 12:07:18. And you know that's Mr. Holly's car because he identified it on the screen during his testimony. He described it, the white vehicle with black roof, a Scion. He told you that. Can't deny it. They all come together. 12:27:19. After waiting in the parking lot, you see Mr. Head, Mr. Williams, Mr. Holly, their friend Nick, Mr. Lewis, and in front of him, and you can only see her back, is Miss Asia. They all entered the club together. Then at 1:46:59, you see Tyree Blige arrives at the Buckhead Loft in his black Mercedes, and he parks right here in this open parking spot. And then he walks into the club, down the wood staircase, and up into the club. And you see him enter the Buckhead Loft at 1:49:06. And back again at 2:09:06 with his wallet, because he told you that. And he's wearing a green jacket, a white shirt, some white shoes, and a matching green pants. Then a short time later, just as Mr. Blige told you, 2:12:25, you see Mr. Head and Mr. Holly. They leave together, just the two of them, both in black. And you see them on the video walk down the parking lot to their vehicles where they parked. You see them do that. It wouldn't be my turn. We'll just go. Okay. Followed by Mr. Head jumps out of the car at 2:16. You've got Mr. Rivers getting a gun at 2:16:20. You've got Mr. Head and Mr. Blige shooting at 2:16:35. This is how you know it's them. You see the photograph on the screen, you can see Mr. Head's white stripe as he gets out of the car. You can see the white stripe in that angle, and the angle from the alleyway. And Mr. Blige told you it was him. Then you got Tyree Blige, who, when a car is pulling out, directly shines on his green tracksuit. He thought he was hiding, but you can't hide from all the headlights. And then at 2:16:35, you see Mr. Head and Mr. Blige walking in front of Mr. Holly's vehicle, where his car door is open, and you saw on the video during this trial him get out and just stand there. But he wants you to believe from his testimony he didn't see a thing. He didn't know there was shooting going on. He knew nothing. The defense counsel wants to bring up Javonta Rivers, Kayla Rivers, at times said, I don't recall, I don't recall, I don't recall, and they did. It's for you to determine if they were lying or they really don't recall. But let's not forget, Mr. Holly, we're called nothing. But you know, he's standing right there. He is right in front of the shooting, and he wants to tell you nothing about it. And I don't blame him. Who wants to tell on their friends? Who wants to tell the police and anyone else? They just watched two friends that they grew up with kill a man. No one wants to do that. It's not unreasonable that he doesn't want to do that. But you know he's lying because he's right here. And what's interesting, ladies and gentlemen, when Mr. Holly and Mr. Lewis both testified, both growing up with the defendants, knowing them for at least 5 years, guess what they didn't say? Not once did they say that either one of these defendants was justified. Not once did they say they were acting in self-defense, and not once did they say they were protecting them. Not once. That's important. There's a reason they didn't say that to you. There is a reason. And we all know why, because they weren't. They were only willing to go so far for their friends. They didn't want to recall anything, but they definitely weren't going to make things up. And they both made that clear. Which is why they did not say that their friends were acting in self-defense or protecting them. Because there was nothing to protect them from. Now, what the defendants want you to believe is that them and their friends were not the initial aggressors. That they didn't act together or in concert. That they weren't in sync when the shooting occurred. They want you to believe that they had no other choice but to open fire on this parking lot. That's what you have to believe in order to believe that they were justified. You have to believe that they had no other choice but to open fire on Solomon Smith and the group of people at the Buckhead Loft that night. That's what you have to believe to say that they were justified. The facts and the evidence just don't support that. Tyree Blige's testimony does not support that. It just doesn't. You don't observe and observe and observe and observe, and then finally decide, after the same gun you saw just a few seconds earlier, that it's time to act. It's interesting that it wasn't time to act when Aisha actually got pushed to the ground, punched to the ground by his friend, by a friend that was expecting that they be armed and dangerous, that when he said, get the strap, they got the strap. That's what the evidence shows, ladies and gentlemen. It is clear. Now we've been through this. Mr. Lewis was the initial aggressor. He initiated it all. Solomon and his friends saw Asia go down. Some said he was concerned about her. Others said he was concerned about the car. But after the initial interaction, he was done. As Ms. Fagan pointed out through the cross-examination of several witnesses, Solomon and Jakayla and Javonta were headed up towards the entrance of Buckhead Law. They removed themselves from Mr. Lewis's aggression. But Jakayla told you that he walked back over to the vehicle, that he had to say something. That he initiated again as she was trying to get into the passenger seat. And then it popped off again. But again, she was able to calm Solomon, calm the situation. And after she did that, Javonta tells you he hears get the strap. Miss Helen said the same thing. And as that's going on, Miss Asia Ashley, rightfully so, another victim in this case, is trying to leave. And I don't disagree with counsel. She was flustered, she was hurt. Her boyfriend had just beat her in front of a group of people. All described her hitting the car was very loud. I'm sure she was disoriented. And as she's backing out, you see it on the video, she comes real close to the black Chuck, Miss Helen, Miss Kiana, and Miss Thompson. And Helen starts banging on the window. No one hid that from you. And she told you what she said and why she said it. And I'm not excusing her behavior, but nothing about her behavior banging on that window is criminal. It's rude, it's inappropriate, it's crass, it's all of those things, but it's not criminal. She didn't damage Miss Asia's car, she testified. No damage to her vehicle. She wanted out of there just like everybody else. Mr. Lewis catches sight or view of this and decides he's gonna just walk up, punch Helen in the face. You see Miss Thompson go back and you see Miss Kiana go back. And then Miss Helen gets the gun. And she told you that. But that doesn't excuse these two defendants' behavior, their actions that night. Their calculated, callous, and behavior of concealing evidence from you, ladies and gentlemen. Because ultimately, the evidence is for you. It's for you to make your determination about all the facts, evidence in this case that you are compliant with the law. They are keeping you from doing that, not the state. They are. They want you to believe that they had no other choice. Mr. Blige went through a list of choices he made before he and Mr. Head opened fire on everyone. He went through step by step the choices he made. And on many occasions, his choice was to watch and observe, according to him. But he was waiting for Mr. Head. There's not a single piece of evidence that supports that these defendants had no other choice. They both could have just left. There's choice number one. They done that, Solomon Smith is still here today. They chose not to leave. Not a single shot was fired until they opened fire on Solomon Smith and his friends. Not a single shot. And there is nothing in the evidence to support otherwise. Nothing. Now, I told you in opening that Javonta Rivers lied, and he was charged with lying. And in order for you to be able to assess his credibility and testify before you, the state made the choice to dismiss his false statement charge. I told you that in opening. And I would do it again. Because if I didn't, you, ladies and gentlemen, would not be able to assess his credibility. You wouldn't have heard from him. Just like you weren't able to hear from Quentin Williams. He'll get the indictment. He's on it. But Rivers on the stand didn't say a single thing that made him look good. He admitted to you that he lied. He admitted to you that he shot. He didn't beat around the bush. There are a lot of things he didn't recall. It is for you to assess whether he was lying or just couldn't recall. I have my opinion, but I'm gonna let you come to your own. Because I think I made it clear when Mr. Rivers testified that before getting the gun, that he whispered into either Miss Ellen or Miss Red, "Is the gun registered? Is it yours?" That's ridiculous, like I said to him. That's ridiculous. And I don't know why he said it. But I do know what the video shows. And I do know the video shows that Solomon Smith is down before Javonte Rivers fires a single shot. I do know that Mr. Rivers is shooting in the air every time he pulls that trigger. It's clear from the video. And defense counsel wants to say, because he's resting his hands above the vehicle, that he's not shooting in the air. I ask, what other direction are you shooting in if you have your hands above on the roof of the vehicle shooting up? I can't shoot anywhere else. Now, I could probably raise my hands higher, but my suit is too tight, to be honest. But that's the only direction it goes, is up. And that's clear from the video. Now, this is a screenshot from 2/16/40. And you see the white shoe of Solomon. He is falling and he is going down. Javonte Rivers is nowhere in the screen. Nowhere. The only people in the screen that are shooting are Xavier Henn and Tyree Blige. It is impossible in this moment for Javonte Rivers to have shot. And I say that because when these two people start shooting, when these two defendants start shooting into the crowd, everybody runs. Everybody starts moving. Had Javonte Rivers fired before the two of them, you would have known, because everyone would have scattered. Mr. King, while Detective Barry was on the stand, said, "How do you know Javonte doesn't shoot from over here, where he is?" You know how you know? Nobody moves. As soon as these people start shooting, as soon as these two defendants start shooting, everybody runs, which is what you do when you hear gunfire. They don't do that until they start shooting at Solomon. It's clear. You can't change that fact. I understand it's a bad fact for the defendants, but it cannot be changed. The video cannot be changed. At 2/16/41, you don't see Solomon anymore. He's down. He is down between the two cars. And you see the muzzle of Javonte Rivers and his hand up in the air, shooting, just like he told you. And when he told the detective at the hospital, or when he neglected to tell the detective at the hospital that he fired a gun, I don't know what was going through his head. He may have felt responsible, but the video shows he's not. And during the questioning of Javonte Rivers by counsel, she asked him what happened to the murder charges, and he told you. During the preliminary or probable cause hearing, a judge found no probable cause, the lowest standard there is, that the charges didn't stick. And he told you after he watched the video is when the judge made that determination. That's why Javonte Rivers is in charge of murder. But it's clear today, beyond a reasonable doubt, Javonte Rivers lied that night. The state's never denied that. Make note, we watched two defendants walk down. You see Solomon over here. He's running, shots fired, Javonte's first shot. He fires 2 more times in that direction. You can see his hands over the vehicle. And I submit to you, ladies and gentlemen, that Jakayla and Javonte, this watchman here. What happened a second ago, but there, the flicker, that defense counsel says that Kiana was the shooter. Again, you don't see Mr. Rivers move. If a gun went off in his car, you would have seen him jump, but watch him in a second. I'm gonna play it one more time because it's really important that you watch. And 2 additional shots are fired after this garage. I'm sorry. Now watch Javonte on that front seat. Right there is where the defense counsel says there's a shot, doesn't move. Now watch what he does when Mr. Blige shoots 2 in his direction. They go down. That's what people do when they hear shots. They go down. I submit to you, ladies and gentlemen of the jury, that was a reflection. You see her get out with her phone. She didn't shoot, and they said that the night that they did to cover because Javonte had shot earlier. That's what the evidence shows. It's clear. Everyone on that video can be accounted for, including those 2 defendants. And the only 2 people shooting when Solomon Smith goes down is Xavier Head and Tyree Blige. And when they shoot, there's no threat. The fight is over. Everybody told you that, including Tresson, Holly, and William Lewis. Both of them told you that. William Lewis said that the defendants were nowhere near when the altercation was occurring. William Lewis told you the fight was over. William Lewis was leaving. The person who started the fight was getting in the car. And then a large number of seconds pass before they decide that they're done waiting, as Mr. Blige put it. Now, what's important and can't be overlooked is the great measure that Tyree Blige and Xavier Head go to conceal the evidence, to conceal their identity. Mr. Blige is crouching behind his vehicle, his car, when he fires 2 shots at Javonte Rivers, who's got his gun to him, or his back to him. You've got Jakayla hiding in the car, but yet there's a threat, according to him. You've got Mr. Blige moving his car from the front to the back of the parking lot. You've got him and Quentin Williams picking up shell casings. And then they leave the scene. And there are 4 separate clips. I'm not going to play them all for you. And here comes Mr. Williams. See him bend down there. This is at 2:22:26. You're gonna see him bend down several other times. Now again. There's 4 other clips of him doing the exact same thing, but I'm not gonna waste your time. There's a reason he continues to pick things up in the middle of the crime scene. It's not his phone and it's not his wallet. Here you're at 2:25:55, you have Mr. Blige returning to the spot. At the end of that clip, you felt during Detective Barry's testimony, he's got his jacket around his head because it's hot outside apparently, and he's picking up shell casings. And you see him not only pick up the shell casings, but bend down where the shell casings would be around his vehicle, immediately in front of his vehicle, but you see him walk down towards where Mr. Rivers was, or excuse me, Mr. Williams was, and pick things up down there. Why? If his actions were justified, why? At this time of the shooting, Solomon Smith was unarmed and he was running. The only reason he got shot was because he stood up to William Lewis. Like I said, the fight was over, and Mr. Lewis confirmed that the defendants had not a single part of the physical altercation. This further illustrates that when the defendants are walking up the chute, there's Mr. Rivers behind the orange SUV. Not waving a gun at one of the defendant's friends, as he told you, he is behind the SUV. And you heard from Captain Jordan, who told you that the 5 .380 cartridge cases that were found at the scene were all fired from the same .380 firearm, and that the 4 .45 cartridge casings were found that were found at the scene were also fired from the same .45 caliber semi-automatic pistol. And what Ms. Jordan told you is that after the 2 bullets were pulled out of one out of the back, Mr. Solomon, and then the front left part of Mr. Solomon's shin or leg. That the 380 was from a Davis Industry or Cobra type 380. And that the 45 was what was pulled out of his back. And what the autopsy shows is that trajectory. It aligns with the movement of the victim as he is running for cover. When he is first, when the shots first start, the video is clear. He is facing the shooters, which is how he gets shot in the leg. And then he starts running to dive in between the car, and they are shooting, and it hits him in the left side of the back. Javonte could never do that. Javonte was never behind him. And Javonte never shot before Solomon Smith went down. Now, I won't go through each one of these points. We've been over and over and over again. They didn't know the cameras were watching them as they tampered with the scene. They didn't know that Asia Ashley was going to tell us that they all met at her house prior to going to the club. And that she could identify her car, his car, Tressel's car. And you heard the jail calls. Each one of the calls with Xavier Head is about the gun. I was fixing to get the gun and take it to your dad's. Hey, for that Asia Ashley, your mama got the gun. He tells her to stop talking about the case and to call directly after that. If it's not the gun, what case? That's what Tomlinson says. If it's not the gun, the 380 that was used to shoot Solomon Smith, then what's the big deal if we talk about it on the call? Why does she got to talk in code if it's not the gun? Now, you heard from Terrence Blige and Chiquita Harrison. And by no means do I think that either one of them having to take a stand was a pleasurable experience. And I understand that. And I didn't want to call them, but they're part of the facts of the evidence. And Terrence Blige told you that he identified his son from the media blast. And he told you about the Mercedes. That's how we found out about the Mercedes. Not through anybody else. Not through Tyree Blige. And Ms. Harrison, she had to, the state had to call Ms. Harrison, no matter how uncomfortable it was. Because not one, but two people had identified her as taking the gun. And they're both on that jail call. Tresson Holly and Asia Drain. If we didn't bring her, they would tell you, just like they did. This case is about one person who stood up, two armed shooters, no threat, and Mr. Smith running for his life. That's what the facts and the evidence show. What really happened was the defendants were acting in revenge. They were doing what Mr. Lewis told them to do. Get the strap. And not long after, he said that these two defendants opened fire on Solomon Smith and a crowd of people. All of the concealment that I've talked about is consciousness of guilt. You don't hide things unless you know they're bad, that they show that you're guilty. That's why you hide things. That's why you run things. That's why you talk in code. And that's why you sell your car. Because at that point, you know it's on video. Now, I understand that what happened in the parking lot, you may not like all the circumstances surrounding Solomon Smith's death. But because you don't like it, doesn't mean that these two defendants get a free pass. Mr. Smith's life mattered. He was a human being. He was a brother. He was a fiance. He was a son. And because of those two defendants, they will forever be an empty chair at his birthday, at his mother's birthday, at every Christmas, at every Thanksgiving, at every holiday going forward because of them, because of their choices. And because of them, Mr. Smith's family is forever changed. They will never be whole again. They will forever be missing someone who should be at that table, who should be at every party. But they took that from them. And they tried to hide it. And ladies and gentlemen, when you come back with your verdict, you're not telling them anything they don't already know. It's what you permit, you promote. And what happened in that parking lot, in the Buckhead lot, shouldn't happen. And it should never happen again. And your verdict will tell them that. It will tell the community what happened on that day will not happen again. That what they did was unacceptable and there is consequences. And you cannot open fire on a crowd of people in a public parking lot. They created an environment like war that night. You see on the video, everyone died. They were lucky. All of them. Ladies and gentlemen, I ask that you consider all the facts and the evidence. And after applying the law, the only verdict that speaks the truth is that these two defendants are guilty of every count in the indictment. Guilty of murder, felony murder, aggravated assault, possession of a firearm and the commission of a felony, and as Mr. Blige told you, tampering with evidence. Thank you.
Thank you, Mr. Abate. Ladies and gentlemen, we're not going to take a full-blown break. You should stand up and stretch a little bit if you want. I promise you what I'm going to share with you is much less dynamic than what you heard from Ms. Fagan, Mr. King, and Mr. Abate. No slide, well, there'll be slides, but no videos or charts or anything like that. I would ask Mr. Rao, since you've been idle while these other folks have been doing things, if you could move that monitor out more to the middle. I need to be able to see the jurors, but I want them to be able to see the monitor. That would be very helpful. But I mean, stand up, do something. I'm going to talk to you for about 30 minutes about the law. And if you don't stand up, it's going to be a long 30 minutes. Just sort of wiggle around while Mr. Rao, without breaking any. Oh, is it? It's a cord's not going to reach?
No.
Oh, I didn't realize that. No, they're gonna see the jury charge on that. So yeah, it would be nice if that thing worked. I didn't realize that Thing was so short. Do we have an extension cord? Nope. All right. Can it slide back a little bit? No, we're good. I don't want you to get unplugged and,
No, I'm serious. I'm so sincere when I say this. I'm good.
okay, let's try that. So if you just unplug it really quickly and plug it back in, the power won't go out.
I believe you did.
He looked. You're fast. That should give us a few feet just to slide it to my right and back a little bit. Don't shock yourself. Then if you'll rotate it that way, yeah. And can it keep going? It's okay if that goes down, just, lower it down. I'm gonna go down. I don't understand that. I thought the plug was on that wall. Okay, that's fine. It'll hover. If you just sort of straighten it out. Perfect. Okay, I can just sit right at the edge. Is that screen on? Or you killed it? I'm gonna share my screen in just a sec. Is it coming on?
Yes, sir.
Fantastic. Does it say jury charge on it now? Great. And Mr. Nguyen, you're welcome to stay standing the whole time if you want. All right, ladies and gentlemen, in a moment, I am going to read to you the contents of this document, which is the jury charge. It's the law that you must apply to the case when you begin your deliberations. Couple things about this document, 3 things. First, you'll get this. So you're welcome to take notes, but literally this document, along with the indictment and the verdict form and the evidence that was admitted, that'll be with you back in the jury room so you can consult it. Second, everything I'm reading will also be on that screen. Some folks like to see what they're hearing. Others just want to listen, and you're welcome to just listen. Third, some of the language you're going to hear is going to strike you as a little stilted or formalistic. I do my best to make the legal language accessible to everyone in the room, me in particular, so I understand it. But there are certain concepts that higher courts, i.e. more powerful courts, have said, here's how you have to define X or Y or Z. So you're going to hear something like a phrase, an abandoned and malignant heart. I don't know what that means. It sounds like a heart with a tumor in it. That's not what it means. But that's a phrase that the higher courts have said you have to talk about an abandoned and malignant heart when you're talking about malice murder. So just work with me. But you'll have this document, as I said, and you can follow along. There won't be a bouncing ball, but as I go through the charge here, the pieces will be up on the screen. All right, without further ado, I can get this to work. There we go. All right, ladies and gentlemen, a grand jury has indicted both defendants for murder, felony murder, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony. The grand jury has also indicted defendant Blige for tampering with evidence. The defendants have entered pleas of not guilty to these charges. The indictment, right here, and the pleas of not guilty form the issue that you are to decide. Neither the indictment nor the pleas of not guilty are evidence. The defendants are presumed innocent until proven guilty. This presumption remains with them unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that one or both defendants are guilty of one or more of the crimes charged. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of each crime, and I'll tell you what those elements are in a little bit, beyond a reasonable doubt. There is no burden of proof upon the defendants, and the burden never shifts to them to introduce evidence or prove anything. When a defense is raised by the evidence, the burden is on the state to negate or disprove that defense beyond a reasonable doubt. The state is not, however, required to prove either defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says, a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror, that's each of you, honestly seeking the truth. It does not mean a vague or arbitrary doubt, but is instead a doubt for which a reason can be given, a reason that arises from your consideration of the evidence, a lack of evidence, or conflict in the evidence. If, after giving consideration to all of the evidence in this case, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law and you must acquit. But if that doubt does not exist as to one or both defendants' guilt, then you would be authorized to convict. It is my responsibility to determine the law that applies to this case and to instruct you on that law. That is what I'm doing right now. You are bound by these instructions. It is your responsibility to determine the facts of the case from the evidence that has been presented. Then you must apply the law I'm giving you now to the facts that you find to determine whether the state has met its burden. You must decide this case based only on the evidence presented during trial. The evidence in this case consists of 1, all witness testimony, and 2, the exhibits that have been admitted. Evidence does not include the indictment, the defendant's pleas of not guilty, anything that I've said during the trial, not evidence, anything the lawyers have said during the trial, not evidence, to include their opening and closing remarks. And finally, questions are not evidence. And this is germane for 2 reasons. Whatever a lawyer asked is not evidence. Some of you may have submitted questions that ultimately didn't get posed to a witness. Those questions are not evidence, and you should not draw any inferences or conclusions about the fact that your question wasn't posed to the witness. It just meant that it wasn't a legally proper question, and it's not evidence. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness, someone who says, I was there, the light was red, the car ran the red light, I saw it happen. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. There is no legal difference in the weight you may give to direct or circumstantial evidence. And in considering the evidence in this case, you may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves defendant's guilt beyond a reasonable doubt. You must determine the credibility of the witnesses who testified before you in this case. In deciding this, you may consider all of the evidence in the case, the witness's manner of testifying, their basis for knowing the facts about which they testified, the probability or improbability of their testimony, their interest or lack of interest in the outcome of this case, their possible bias for or against a party, and their personal credibility as you have observed it. The credibility of a witness may be attacked by disproving facts to which the witness testified. You may also consider, where applicable, other evidence offered to attack the credibility of witnesses. This would include evidence of a witness's bias for or against a party. In determining the credibility of a witness whose credibility has been attacked, you may consider any evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here in court to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. In assessing the credibility of a witness, you may consider any possible motive for the witness's testimony, if it's been shown. And in that regard, you are authorized to consider any pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. Generally, the testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided that you find the witness's testimony to be sufficient. Of course, there's an exception. An exception to this rule about corroboration applies when the witness is an accomplice to the crimes charged. The testimony of an accomplice alone is not sufficient to warrant a conviction. The accomplice's testimony must be supported by some other evidence that supports an inference of the guilt of the accused, independent of the testimony of the accomplice. This supporting evidence does not, on its own, need to be sufficient to warrant a conviction, nor does the accomplice's testimony need to be corroborated in every material way. The supporting evidence must be more than that a crime occurred. It must be sufficient to connect the accused with the crime and must do more than merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crimes and tends to show participation in those crimes can be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. Now, whether any witness in this case was an accomplice is for you to determine. Expert witnesses. You have heard from several witnesses who've been designated as experts in this case. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is typically not known by you or me and other average folk. These witnesses are permitted to give their opinions based upon their training and experience. The testimony of an expert, like that of all witnesses, is to be given only the weight and credit you think it is entitled to receive. Criminal defendants who have no burden to prove anything are not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. You have heard evidence concerning both defendants' character for lack of aggression. This evidence has been offered in the form of the opinion of other witnesses. You should consider this evidence along with all the other evidence when deciding whether you have a reasonable doubt about the guilt of either defendant. Good character is not an excuse for crime, but you may consider it as weighing on the issue of whether the defendants are guilty of the charges in this case. The state must prove beyond a reasonable doubt the identity of the perpetrators of the alleged crimes. It is for you to decide whether the testimony of the witnesses and other evidence you've received in this case sufficiently identify either or both of these defendants beyond a reasonable doubt as the perpetrators of the alleged crimes, or that a defendant was a party to them. It is not necessary that the defendant show you that some other person committed the alleged offenses. If you have any reasonable doubt about whether either defendant has been sufficiently identified as a person who committed the alleged crimes or was a party to them, it would be your duty to acquit that defendant. Defendants are charged with crimes against the laws of Georgia. A crime is simply a violation of a law in which there is a joint operation of some action and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Criminal intent is not the intent to violate the law. It means simply the intent to commit the act that is prohibited by the law. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of the prohibited act. The defendants are not presumed to have acted with criminal intent. but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendants are being prosecuted. If a defendant intentionally commits an unlawful act and his act harms someone other than the person intended, it is not a defense that the defendant did not intend to harm the person who was actually injured. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to the crime only if that person, A, directly commits the crime, or B, intentionally helps in the commission of the crime. Any party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it. Evidence that merely places upon a defendant a grave suspicion of the crime charged, or that merely raises a speculation or conjecture of a defendant's guilt, is not sufficient to authorize a conviction. You may not convict a person who was merely present at the scene of a crime at the time of its perpetration, unless the evidence shows beyond a reasonable doubt that the person either directly committed the crime or helped in the perpetration of the crime. You also may not convict a person who was merely associated with other people involved in the commission of a crime, unless the evidence shows beyond a reasonable doubt that that person helped in the perpetration of the crime. Now, criminal trials must be tried in the county in which the crime was committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt as to each crime charged. Though you may consider all of the evidence as a whole, conviction of one defendant does not necessarily require conviction of another. You must determine the guilt of each defendant separately as to each offense. A conspiracy is an agreement between two or more persons to do an unlawful act. The existence of a conspiracy may be established by proof of acts and conduct, as well as by proof of an express agreement. When people associate themselves in an unlawful enterprise, any act done by any party to the conspiracy to further that unlawful enterprise is considered to be the act of all the conspirators. However, each person is responsible for the acts of others only insofar as such acts are naturally or necessarily done to further the conspiracy. Whether or not a conspiracy existed in this case is a matter for you to determine. You may consider presence, companionship, and conduct before and after the commission of the alleged crimes in determining whether such circumstances, if any, give rise to an inference of the existence of a conspiracy. All right, I am now going to talk to you about the substantive offenses that are alleged in the indictment. And the first is murder. For malice murder, the state must prove three things: that a defendant, 1, caused the death of another person, 2, did so unlawfully, and 3, did so with malice aforethought. The killing must have been done with malice to be murder. Malice, as that term is used here, does not mean ill will or hatred. It means the unlawful intent to kill without justification. You may find malice when the circumstances show that a defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation, and the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, that's that criminal intent, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in a defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing, and it moved the defendant to do it, that is enough for the killing to be murder. I forgot to change the slide. Sorry about that. There are all those words. Raise your hand if we're not following along. Proof of motive is not essential to the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes a defendant's state of mind at the time of the homicide. Count 2 in the indictment is felony murder. For felony murder, the state must prove that a defendant did two things. 1, caused the death of another person, and 2, by committing a felony. The state does not have to show that a defendant acted with malice to prove felony murder. Aggravated assault, which I will define in a moment, is a felony. You may find a defendant guilty of felony murder if you believe that he caused the death of another by committing the felony of aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection, however, between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Aggravated assault. A person commits an assault when he attempts to commit a violent injury to another. A person commits the offense of aggravated assault when he assaults another with a deadly weapon. The state must prove as a material element of aggravated assault, as it is alleged in this case, that the assault was committed with a deadly weapon. And I instruct you that a firearm is a deadly weapon as a matter of law. Count 4 charges both defendants with possession of a firearm during the commission of a felony. That is defined as follows. A person commits the offense of possession of a firearm during the commission of a felony when he has on or within arm's reach a firearm during the commission of a felony. Murder, felony murder, and aggravated assault are all felonies, and firearm includes any handgun. Now, Mr. Blige is charged in count 5 with tampering with evidence. A person commits the offense of tampering with evidence when, with the intent to prevent the apprehension of any person or to obstruct the prosecution of any person, he knowingly destroys, alters, conceals, or disguises physical evidence. Sometimes a defendant's use of force is legally justified and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when, 1, he reasonably believes that the use of such force is necessary, and 2, to prevent either death or serious bodily injury to himself or a third person, or the commission of a forcible felony, which means a felony that involves the use of force or violence against another. An aggravated assault is a forcible felony. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide that their actions were justified, it would be your duty to find them not guilty. A defendant is not justified in using force if he, 1, is committing a felony, aggravated assault is a felony, or 2, he is the initial aggressor unless he withdraws from the encounter and clearly communicates to the other person his intent to withdraw, but that other person continues or threatens to continue the use of unlawful force. For a defendant's use of force to be justified, first, the defendant must believe that the use of force was necessary. 2, that belief must be reasonable. That is, a reasonable person would also believe that the use of force was necessary. And finally, the defendant's reasonable belief must be what prompts him to use the force. A defendant's use of deadly force may be justified even when there has not been physical contact between anyone. If the menacing actions of the alleged victim are sufficient to create a reasonable belief that the defendant's or another's life is in imminent danger, that the defendant or another is in imminent danger of serious bodily injury, or that a forcible felony is about to be committed, then the defendant's use of deadly force may be justified. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing action may justify the use of deadly force. Under the principle of what is known as transferred justification, no guilt attaches if a defendant is justified in using deadly force, but accidentally misses and kills an innocent bystander. However, the principle of transferred justification does not apply if the defendant used deadly force carelessly and in reckless disregard of the danger resulting to the bystander. Ladies and gentlemen, in the jury room or wherever we set you up for deliberating, you will have these two verdict forms. You should consider each count against each defendant individually. Each defendant may separately be found guilty of some, all, or none of the charges in this case. If, after considering all of the evidence, together with the charge I'm giving you, you should unanimously find beyond a reasonable doubt that one or both of the defendants did commit here in Fulton County any of the crimes alleged in the indictment, you would be authorized to find that defendant guilty. And in that event, the form of your verdict would be, we, the jury, find defendant Blige or Head guilty. And in the blank on the verdict form for that particular offense, you would write the word guilty. Simply a blank, you're going to write not guilty or guilty. If you do not believe that a defendant is guilty for a particular offense, or if you have any reasonable doubt as to that defendant's guilt, then it would be your duty to acquit him. In which event, the form of your verdict would be, we, the jury, find defendant Blige or Head not guilty, which would be the next slide. And in the blank on that on the verdict form for that particular offense, you would write the words not guilty. Whatever your verdict is for a particular count, it must be unanimous. Your verdict must also be in writing, signed by your foreperson, and dated. Ladies and gentlemen, by no ruling or comment that I have made during the trial have I intended to express any opinion upon the credibility of the witnesses, the strength of the evidence, or the possible guilt of either defendant. Your verdict must be based solely upon your consideration of the evidence according to the laws I'm giving you now. It is your duty to consider the facts objectively, without favor, affection, or sympathy to any party. It is also your duty to report to me if you perceive that a juror is making decisions based on improper considerations of race, gender, religion, or sexual orientation. You all are the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign these two verdict forms to which you all freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence you have received. We're almost done. 2 more charges. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any outside research. That should sound familiar. You have all the evidence in this case. It would be improper to supplement it with any outside information. And to assist you in complying with this directive, the deputies are going to collect from you before you start your deliberations all of your electronic devices, laptops, tablets, phones, etc. We'll hold on to them while you're deliberating. You get them back when you go home today, but while you're deliberating, no e-devices in the jury room. Going forward, should you need to communicate with me for any reason, question, concern, it must be in writing. I will confer with the attorneys once I've received those written questions or concerns and share with you whatever response I am allowed by law to give to you. Ladies and gentlemen, in a moment, you all are going to retire to the jury room, and I would like you very first to decide if you want to deliberate in the jury room or if you would prefer to deliberate in a larger space, and we'll get you a larger space. But that jury room is for you, and if that's where you want to have your deliberations, you can do them there. But we'll get you a bigger space if you want to spread out for social distancing reasons. What I'm going to ask all of you except Ms. Agnew and Mr. Wong to do is to go back in the jury room, have that initial discussion about whether you want to meet back there or somewhere else, and let the deputy know that. Don't start your deliberations until we've got you in the room you want to be in, and you've selected your foreperson, and most importantly, we've gotten you all the evidence, because you need that with you, the indictment, the charge I just gave you, the verdict forms, and the evidence. Then you can start your deliberations. And so with that, I'd ask the 12 of you whose name I didn't give to go back in the jury room. One of the deputies will be with you in a minute. And Ms. Agnew and Mr. Wong, if you would stay put. All right, Ms. Agnew and Mr. Wong, you are our alternate jurors. You are going to stay here in the courthouse today while your colleagues start their deliberations. At the end of the day, we'll touch base about whether you should come back tomorrow or whether you could be here on short notice, 30, 45 minutes. That'll sort of dictate whether you can go about your business tomorrow or come back down here. We're going to get you two in a separate room. You can keep your electronic devices as long as you use them in ways that are entirely unrelated to this case. It's like you're on an extended break, but we need to keep you here because should we need to excuse one of the non-alternate jurors, then one or both of you will be pressed into duty. You saw the same evidence, heard the same arguments as the other 12, and you are equally capable of being part of that group, but just the way the numbers worked, you two are the alternates. So I'm going to ask you if you have stuff in the jury room to go get it. For now, we're working on where you're going to be. So if you just get your stuff and bring it back out here to the jury box, please. Thank you. Mr. Abate, did you have any exceptions to the jury charge? Mr. King?
No, Your Honor.
Ms. Fagan? All right. Here are the verdict forms, Ms. Fagan, you're closest. If you would grab them and give them a look-see and then share them with Mr. King and the prosecutors. Ms. Fagan, any objection to the jury form, the verdict forms? Mr. King?
No, Your Honor.
Mr. Rao? All right, those will be the ones we use. I think the last thing I need the lawyers to do is to see if there are any exhibits that have been admitted that they think shouldn't go back with the jury. So let's tackle that right now. I know we've got two alternates right here, but I'll manage their location in just a second. It may be that you all have already talked about it. You think everything should go back. It may be that there are some things shouldn't. And I will hear from you in a few minutes on that. Okay. So we'll go off the record, and if you would confer about that.
I think that, something to say, if this goes past Wednesday, I cannot.
Understood.
I have to be in court in person.
Understood. You've told us that.
Okay.
Thank you.
Just let me know.
Have they decided what they want to do?
Maybe like stay here.
They're going to stay in there? Okay. Can you see if our alternates can be in that space right there?
Yes.
That would be great.
I'll get in. If you like, I can explore it now.
Yeah, if that room, is there a table in there?
Yes.
Okay, great. So you two are going to be in there. I think there's a restroom in there, so you should be self-contained. I promise we won't forget about you.
This is the evidence that I got from Ms. Rivers' office.
Yep.
And so.
That's it.
This is it.
Right, I don't think there was anything. Good. Okay. All right, so I'm gonna step off for a few minutes. I'll come back and see how we're doing with what goes to the jury. Thanks. We're all set. They're in the miniature. I don't think so. Our jurors want to stay there.
Yes, sir.
But it is not what we think.
I mean, I guess the flash drives would just stay here. I don't have an issue with the actual flash drives going back. But, I guess.
Flash drive.
One 129 is flash drive of the radio traffic. I think 127A is just the flash drive of all the crime scene photos. 172 is the GBI report. And then 84. 84 is thumb drive of the crime scene videos or crime scene photos from the responding officers. So yeah, that's. I mean, it's not like they'll be able to actually even do anything with the flash drives, I guess.
Good job, y'all, man.
Oh, you too, man.
So far, you ain't done.
Yeah. Clean fight. This, I guess. I mean, I don't know if that might be testimonial. I don't know if y'all have it. I mean, I don't think that matters one way or the other. Yeah. Shit in order. 134, 135. Okay, so. Nicole, do you have an issue with this? Okay. No. Okay. Yeah, I don't really have an issue with any of it. You don't. Yeah. All right. I mean, the least I can do, I guess, is put it in order. I don't know what the issue is. Yeah. We can plug it into the CPU. Yeah, man. Technology is all fucked.
Okay. Great.
That's everything.
We don't have to get on the record yet. Let me just, how are we doing?
Judge, I think all parties have conferred. We don't mind everything going back.
Okay, well, let's get that on the record then.
Yes, Judge.
Let Ms. Clay get situated. Ready? Okay, we are back on the record in State versus Blige and Head. I've got the verdict forms, which have been approved by all lawyers, the jury charge, and the signed indictment. Mr. Rao, you have an update for me based on your conference with Ms. Fagan and Mr. King about what exhibits go back with the jury?
Yes, Judge, and conferring upon both counsels for defendants Blige and Head, we've consented to allowing all evidence that has been admitted to go back to the jury.
Okay, Mr. King, you agree with that?
Yes, I do.
All right, Ms. Fagan? Okay, then if I give this to Sarge, he can put it in with, or hand it to the jurors along with that. So we're clear, the jurors are getting some thumb drives. They have no device by which to play things. That's intentional. If they want to play something, they'll need to ask us and we'll get everyone back in court. Anything else, Mr. Rao, before we pause and let the jury start their work?
No, Judge, not from the state.
Mr. King?
No, Judge.
Ms. Fagan? All right. I need, we can go off the record now, a phone number that someone on my staff can call that will get everyone associated with Mr. Blige back in here. What number should that be? Or if you're going to stay here, I don't need a phone number. Okay. But nonetheless, if you're taking a break.
404-909-4340.
4340. All right. And Mr. King?
404-729-4682.
And how best do we reach the state?
I can give myself a number, 678-458-5571.
All right. And Ms. Clay, are you just gonna stay where you are for now? Until whenever. All right. So for everyone's planning purposes, I'm gonna stay out of the jurors' hair until maybe 5:15. Around 5:15, I'll take their pulse about whether they want to stay later tonight. There'll be a cap on that because the shuttle stops running, et cetera. And I want to be supportive of the deputy schedule. And then they need to come back tomorrow, but they can certainly do that. Obviously, if they have some question, concern, or whatnot, before 5:15, we'll address that. But I don't plan on having one of the deputies take their pulse until about 5:15. Anything else from the state before we break?
Does the jury have the case right now as we speak?
They do.
Okay.
If you're doing your little notes, 4:20. All right. Mr. King, anything else?
No, you
All right, Ms. Fagan? So when you've got the right person power, the defendants can go back into lockup, stay there till we've got something for them. Thank you. You all are welcome to stay in the courtroom. Courtroom is open.
Yeah.
Nicole, you want anything? Water or anything? I'm gonna go down to the break. Yeah. Come on, you want to go?
No, I'm good, man. Appreciate you.
Yeah. He advised me. So you can advise him to just, like, how to get in and how to work. Anytime. Yeah.
I got this for you, but I didn't write anything on it, just in case you don't want it. Speaking of. Okay, well, you're the only one, so hide it.
Well, what they did do is, what I did is prepare it for the phone, back here. And then, yeah, roll call chambers, and they got questions, whatever, and change how to put them. It's better. To get- Oh.
I'm doing fine, man. How about you? I do. Yeah. Okay. Yeah, I don't have a problem with that. If you don't hear from me, then you can assume that everything is a go. I do, yeah. I'm pretty sure it does. Okay. All right. Sounds good, man. All right, thanks. All right, bye. Yeah, I'm good. How you doing? Hey. Good. Oh, okay. Uh-huh. Gotcha. Right. Got it. Correct. That's correct. Okay. Well, I mean, the worst they can say is no, but none of your situation doesn't fall in those categories. That's right. I don't know how that works. I mean, I don't necessarily know if it shows up. I think it only shows up if you were evicted.
What do you think I happened?
Like, not evicted, but if you were like old, if you were, maybe, I don't know how it works. I can't advise you. I really do. I don't know. I really have no idea. Well, you keep on asking me about stuff. I don't know. I really don't. I never even heard of it. But I'm not in the game. I'm not in the game. I've owned my house. I've owned my house since 2005. And last time when I had my office, it was, I mean, they didn't run my record. It's just, I mean, they didn't run my record. Work it out. So I don't know. I really don't. I don't know what this is. I mean, I represented people on eviction, but you know, I don't know anything about it. The answer is no.
I'm still in Agricola. It is on trial.
Gotcha. No.
Yes, no.
No. Exactly. All right, you're welcome. Have a good day. Bye-bye.
Yeah, he said you remember, I mean, he said he told you, but I know, I told him, I was like, well, you got so many parties. Sometimes you don't like the whole board, you know, he's out of town. He's out of town. He's work there, so. No, I'm still at work right now. So he's. Where are you at work? I'm down to I work at Falls Superior. Yes, so I'm just sitting over here, this is such a private. Okay. Yeah. Do that, but we're waiting for it. You know, we're waiting on the system. The jurors. So I don't know. I feel it's time. But it's gonna be, I know it's gonna be before you get off. Okay, but why would I not? That's what. Well, I'm sure that if it's in front of the box, it's not that hard. I know how to follow it. I'll just find this on the box. Okay, turn it clockwise, okay, you know, so I'll come back to the key. But I'll let you know first. I mean, I'll. Okay. Yeah, I will text you. I'll call you when I'm around. All right.
Hey, how are you?
All right.
Hey, Miss Tanya. Hi, how are you? I'm good. That's nice. I was like, who is that?
You family doing? Good, good. Hey, how you doing? Good, I'm gonna send you back. No, I was right in the middle of it. I'm still in trial, but now the jury and everything, so. I will, probably see you this weekend or sometime before that. Come out there. I think we reset for November 15th. Since I was in trial and couldn't make it today. So I think that's when she just put us back on. I think that's when. Yeah, and then also, they've already published the potential trial date. The calendar trial is gonna be January 10th, and if we go to trial, and call, it'll be January 3rd. So we just put that on the calendar just in case, but obviously that's a ways from now. We don't know what's gonna play out between now and then. So you can let them know those things, but then also just let them know at the same time. Yeah. I don't know. It just really depends on, you know, if there's anything that I need to get done. I'll make that decision over the next couple of days. Okay. Oh, yeah, we doing all right. Talk to you soon. Peer support.
Yes.
If money come back over Eddie. No, I'm not gonna be able to make it.
Oh. Madam Funny, Madam Willis said she gonna take care of you, man.
You know what? I think she will hire me. I really do.
Yeah, so.
I really do, but I like what I'm doing. I do. And you know, if I'm not in court, I really don't like anybody telling me where.
I know, honey.
And I really don't even like that, but obviously that comes with the territory.
How long did you spend the days off? Come on.
8 years.
Did you?
Yeah.
You was there 8 years?
I was.
Wow. You see that wrong?
22.
I know. How your husband doing? He's back in the field now, right? He's in field operations? Right, field operations, major, somewhere, yeah. It was an academy.
He's a major there, that's what he started out.
I know he was just a little bitty officer. Look at him now. Hey,
Make her what?
zone one.
Oh, really? Awesome.
So this is about 23 years.
How many more years you gonna do? Just keep going. Hey, as long as the money come in, just keep them working. Keep them working. Keep them checks coming in.
That used to be my stomping ground.
What, zone one?
I was a community prosecutor.
That was all game.
It was.
Zone one.
Pretty rough.
It is rough. It is rough.
Get a lot of calls and-
How you make the big bucks?
Is that what it is?
I'm out of that whole, the whole crime stats thing. I don't know anything about you, but I'm curious to see how it is now compared to how it was when I was there. Because when I was there, we still had the project.
Oh,
Not
more
usually-
homes and.
Home, bankhead. And obviously, when you disperse the projects, you got a different set of issues that disperse a little bit. But I'm interested to see, if it's as bad. If it's as bad, and then also the gentrification that's going on down close to Northside Drive.
Look, get her. You know what? You too, put a mask up. Put a mask up. They say, cause like I told the other girl out there on this, you know, I ain't gonna say it, but I told her. So listen, who's gonna, you good, Sarge? Hey, Sarge, you had a conversation with it? Sarge.
You said jurors have a question?
Yes.
Okay, well, if you can just hold, because I need to get the process. You think she's very calm?
But
So if you all can just hold before they come. I just want to talk. Just stay here.
Hey, Mom, stay here, stay here.
Yeah, you guys live in the city? You live in the city, Mr. Carl? You live in Fulton County?
I know, I live in the cab.
Yeah. So, you gotta vote tomorrow, right, for your mayor?
But it will be city.
It's up,
But I
it's up to you.
still.
Bill Edwards, his son works for us. Bill Edwards' son works for us. He's an IT guy. He's on IT.
Oh, he's gonna go to. Okay. He knows.
Hey. How you doing? What was your questions? I am really. No, that's it. Very instructional. It's just, one person. Discussion. Right. Right. Well, you get into stuff that I didn't think they really get into, like, with, you know, Dylan. Like, it's still, it's, so to ask him those questions, I don't. Yeah. I mean, I still do it. It's kind of confusing. No, that's statutory. That is statutory. I mean, yeah, but at the same time, I agree with you. That's the law. That is the law. Zero. I'll do it. Yeah, I'm familiar with it. Okay. Oh, shit. Hey, I'm good. Oh, no. Understood. So what's doing what we're talking about? So he had a case? Okay, what kind of charge was y'all?
So this has something to do with other sets of facts. Okay, understood. So because they don't cross the level, they don't charge, they moving forward with the juvenile case, we have a whole new case. Understood. Okay, do you have a case number? And you're going out of town, right? Okay. Well, yeah, well, I'll contact you. I'll work with you on that. Did they say they were going to? Well, I mean, the question is, are they transferring? Are they just gonna do it for the day? Are they gonna transfer it to state and, what is it? They probably transfer tomorrow. Yeah, that's like a 2-hour trip. Yeah. I thought on an initial solution. Okay, so I'll keep it posted. But I'm glad we found out exactly what's going on. So that's good. Yeah, I think she was. Okay, I'll call you tomorrow. Okay, bye-bye. Hi. I'm fine, how are you? Good, I just wanted to let you know, even though I asked the other space manager this morning your question, I did not get an answer today, so I will let you know tomorrow morning about coming to work, because I'm not sure. And so, well, you can always, I'm not sure. So that's, I'll figure it out tomorrow. I mean, yes, it's open. Yeah, but the question is, so I just want to give an answer to all that. Before calling back, so I'll call you back in the morning, and then also, I'm gonna have a copy of discovery. And so I will figure out All right. Okay, I'll call you. I'll call you.
Only the jury found out.
Not for me. Come on, LT. What? No, I'm good. They've seen me a ton of times. It's boring now. They're getting them?
Yes.
Okay. 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 Thank you. All right. Ms. Clay, you ready?
Yes.
All right, we're gonna go back on the record in State versus Blige and Head. The jury has a question. It says, could we use a TV or other device to review the, a mystery word, footage presented in evidence? It may be the word surveillance, but what they want to do is watch the video. Sergeant's understanding was that they want something back in the jury room to watch it. So I need to get a sense from the lawyers whether we want to try to create that setup where they could watch it back there, or if the preference is to have them watch it with everyone present out here. I'll start with the state. You're open to either approach. Okay, Mr. King?
I am too.
All right, Ms. Fagan?
I'm open to them having a physical TV. The only thing I have an issue with is that the physical exhibit should have about 364 videos.
All of which have been admitted.
Right.
Okay.
And I think it may be difficult for them to find what they're looking for without.
Okay. Well, that's a great point. You're not opposed to them being able to review at their own stop, start. But we may want to give them some guidance to files that don't say head gets out of car or something like that. So that may be a project that could be made available to them tomorrow, because I don't know that we've got the technology right now. They could get a laptop. It would have to be wiped. It couldn't have anything else on it. So I'll talk with our tech team about that. My thought is that we let them go home in a couple minutes, but bring them out here and explain that we will make the videos and a device available for them for their return tomorrow. I don't think we could make it happen today. If there's a video they want to watch today, it would need to be out here. But that wasn't the form of their request. Did any of you get a sense of how much longer they want to go?
Just asked them, just said after, watch
Okay. Then why don't we bring all 12 out? Before we do that, all I'm going to tell them is if there's a specific video they want to watch, it needs to be out here and we'll play it with everyone. If they want the ability to stop and start and sort of snuffle around in the videos, that would be tomorrow morning before we could get them that equipment set up. And then they can decide what they want to do. You all right with that, Ms. Fagan? Mr. King? Yes. And Mr. Abate? Yes, all right, let's bring them out, please. They stay there for this exchange. Thank you. Can I give you, Ms. Clay, this is a courts exhibit, the whole thing together. I've got a rubber band if courts exhibit 1. I don't know where you want to put it. I guess you can put it on the first card, or if you want to put it in an envelope. That rubber band's not great, but all those together are courts 1. So I don't know if you want to have it go in an envelope.
All these together, is this from the whole trial or just from? Okay.
Right. So those are questions that the jurors had during the trial, and I typically make them a collective courts exhibit 1. This will be courts exhibit 2. That's their question they just wrote. And if there's another, so this can have a sticker on it. This will be 2 and then 3, but good. And then call that courts 1. Fantastic. I'm gonna hold on to it. Yeah.
And if you need it tomorrow, I'm available tomorrow.
Okay.
To come back, but I could email Ms. Rivers to see.
She should be here tomorrow. Yeah. And so you guys, however you want to work the handoff, I'm happy. Okay. You guys will sort it out. Thank you. Yeah. Sorry. Yeah. Oh, yeah. Okay. So if I can get that, so I can see it.
Everybody in the courtroom doesn't have a seat.
I got some better for you. I did bring a jury to
Court from order.
Ms. Clay, you ready? All right, ladies and gentlemen, we are back on the record. It is now moot what we would do with videos or no videos because we have verdicts in the case. We're going to bring the jurors in a minute. For those in the gallery, if you have any concern about your ability to stay calm and quiet and professional like you have throughout the trial, and thank you for that, you should step outside. And folks who can stay in court and stay collected during the announcement of the verdict for each of the two defendants. We'll let you know what happened, but it would be inappropriate for there to be any outbursts or sighs or anything like that. The jury will let us know what the jury decided in a few minutes, and we need to be respectful of that decision. Mr. Abate, anything from the state before we bring the jury in? Mr. King? Ms. Fagan? Okay, let's bring the jurors in, please. Thank you for sending that email. Let's see what happens. Can I give this to you now? Thank you, Sergeant. Ladies and gentlemen, it's my understanding that you all have reached a verdict. You're the foreperson?
Yes, Your Honor.
Great. If you could please share the verdict with the sergeant so I can see them. I will return them in a moment. Sorry, everyone should be seated, including. Right. Thank you, sir. All right, sir, if you would stand for a moment. Was the verdict that was reached in the jury room a unanimous verdict?
Yes, Your Honor.
And have you filled out the verdict form, signed it, and dated it?
Yes, Your Honor.
I'm going to ask you now to do what we call publishing the verdict, which simply means read into the record what the verdict of your jury was. Whenever you're ready.
Verdict for Tyree Blige. Count 1, murder. We, the jury, find defendant Blige not guilty. Count 2, felony murder. We, the jury, find defendant Blige not guilty. Count 3, aggravated assault. We, the jury, find defendant Blige guilty. Count 4, possession of firearm during commission of felony. We, the jury, find defendant Blige guilty. Count 5, tampering with evidence. We, the jury, find defendant Blige guilty. Verdict for Xavier Head. Count 1, murder. We, the jury, find defendant Head not guilty. Count 2, felony murder. We, the jury, find defendant Head not guilty. Count 3, aggravated assault. We, the jury, find defendant Head guilty. Count 4, possession of firearm during commission of felony. We, the jury, find defendant Head guilty.
Thank you. If you would please give the verdicts to the sergeant, he's going to hand them to Mr. Abate, and I need the lawyers for each of the defendants to look at them as well, please. You can take a seat now. Mr. Abate, do you have any objections to the form of the verdict? Mr. King, do you have any objections to the form of the verdict?
No, Your Honor.
Ms. Fagan?
No form, but we do request the jury to be told.
Okay. Ladies and gentlemen, I'm going to call each of you by name. When I call your name, if you would stand, I'm going to ask each of the 12 of you who were the non-alternates to answer the same 3 questions. Mr. David? Was the verdict you just heard your verdict in the jury room?
Yes.
And did you freely and voluntarily enter into that verdict?
Yes.
Is it still your verdict?
Yes.
Thank you. Mr. Long, was the verdict that was read here in court your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into that verdict?
Yes.
Does it remain your verdict?
Yes.
Thank you. Mr. Gray, was the verdict read here, your verdict in the jury room?
Yes.
Is that something to which you freely and voluntarily agreed?
Yes.
Is it still your verdict?
Yes.
Thank you. Ms. Jackson, was the verdict read here in court your verdict in the jury room? And did you freely and voluntarily enter into that? Does it remain your verdict? Thank you. Ms. Jory, was the verdict read here in court your verdict in the jury room? And did you freely and voluntarily join that? Is it still your verdict? Mr. Torbert, was the verdict read here your verdict in the jury room? And is that something you freely and voluntarily entered into? Does it remain your verdict? Thank you, sir. Ms. Roberts, was the verdict read here in court your verdict in the jury room? Did you freely and voluntarily enter into it? Is it still your verdict? Thank you. Mr. Sellers, was the verdict that you read here in court your verdict in the jury room?
Yes.
Is that something you freely and voluntarily entered into?
Yes.
And is it still your verdict?
Yes.
Thank you. Mr. Lord, was the verdict you heard here in court your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into that verdict?
Yes.
Does it remain your verdict? Thank you. Mr. Yanni, was the verdict read here in court your verdict in the jury room?
Yes.
And did you freely and voluntarily enter into that?
Yes.
Is it still your verdict?
Yes.
Thank you. Ms. Bowling, was the verdict read here in court your verdict in the jury room? Did you freely and voluntarily enter into that verdict?
Yes.
Does it remain your verdict?
Yes.
Thank you. And last but not least, Mr. Nguyen, was the verdict read here in court your verdict in the jury room?
Yes, sir.
Did you freely and voluntarily enter into that?
Yes, sir.
Does it remain your verdict?
Yes, sir.
Thank you, sir. Mr. Abate, any reason why I cannot release the jury? Mr. King?
No, Your Honor.
Ms. Fagan? Okay, ladies and gentlemen, on behalf of the lawyers, the parties to this case, I want to thank all 14 of you for your service. As you no doubt understand now, this is a very important matter to the Smith family, to Mr. Blige and his family, to Mr. Head and his family. And we needed 14 open-minded, impartial members of our community to work through what the evidence showed in this case, and that's what you did. So thank you for your service. I'm going to ask you all to go to the jury room / that hallway. We're going to return your devices. I'm going to come back and say a few more words, maybe answer a couple questions you've got, then you'll be free to go. So we won't keep you here much longer. We are generating those letters. We will. If people need a letter saying, no, I've really been in court this past week, there's one that has my name and number on it. So if you've got an employer or a significant other saying where you've been, that'll vouch for it, or they can call me and I'll vouch for it. But we should find out who needs one. Okay. When you go back there, if you just make a list of which of you needs one, so we don't make folks wait, rather than do all 14, we'll do them just for the folks who need them, and we'll return your stuff. But if you go with the Sarge, he'll get you situated back there, and I'll see you in just a minute. Thank you.
Thank you.
Okay. I mean, it's a certain thing if we did it. I just worry it would take too long. We have a certain window. We'll see. All right, you all can be seated. We will not be doing sentencing today. If people need a specific amount of time to be ready for the sentencing hearing, you should let Ms. Nelson know. Otherwise, we'll put it on one of our next available calendars. I just want to give the state a chance, if there are victim impact statements they want to provide, and give both Mr. Head and Mr. Blige a chance to have the folks that they want to have here, if they want to have anyone here beyond the many people who are already here. But given the hour and what everyone's been through, now is not the time that we will be handling the sentencing. So we'll cover that and appellate rights and all those other things when we next convene. But I do want to thank the lawyers for all the work they put into this. I think it was very well tried by both sides. You'll all develop your own opinions about the jury's verdict, but I get the sense that they heard both sides pretty clearly given where they came down. So I appreciate everyone's work. Mr. Abate, you'll be happy to know none of your cases is on the November 8th trial calendar. Mr. King, you got one guy, but you told me he's pleading out anyway. So we'll see. We would treat you well.
I still need more time.
You always need more time.
I do need more time.
Okay, well, we'll deal with that later. Ms. Fagan, this is the only case I have with you, so we'll have to wait for another case before we do business again. Mr. Abate, anything more at this time from the state? Okay, Mr. King and Ms. Fagan. All right, thank you, everyone. And Ms. Clay, we missed by about 15 minutes the email that Ms. Nelson's just actually sent the exact language. And so it said 5:30, but it's 5:45. So if you need me to revise the overtime to 5:45, sure. Yeah, I'll do that. So what I'm going to do is chat with them, and anyone who wants to interact with you, I'll funnel this way. Otherwise, we'll let them go their way.
Yes, sir. You need me? Well, it'll be okay. You want to get to it? That's fine.
Yeah, that's what I was